May it please the lordship, 1 to 6. May it please your lordship, with respect to item number 14, your lordship, we would like to file our additional affidavit in reply, your lordship. We have filed their counter affidavit. That is right.
You are for the respondents or the
Petitioner. For the petitioner.
and counsel for the petitioner pays for and is granted 4 weeks time to file an additional affidavit.
Affidavit in reply, your lordship.
Affidavit in reply. All right. List up 4 weeks.
Deep your petition.
May I please your lordship? Your lordship, I would beg to mention item number 11 and 12.
These are fresh matters. Why do you want an adjournment?
Because your lordship, the senior counsel, Mr. Jyotirmoy Roy, appearing for respondent NRL, is currently indisposed. He is
All right. It is stated that when senior counsel, Mr. Roy, representing the respondent, is unwell. A request is made to adjourn the matters. List after 2 weeks. The other side has no objection. 2 weeks.
May I please, your lordship?
Yes.
I beg to mention item number 7, your lordship. I have
7.
7, your lordship. Here, what has happened, your lordship, both the councils representing the appellant are out of the town, your lordship. Now, the file has been handed over to me in the morning, your lordship. So I need some accommodation, your lordship.
Counsel, Mr. So-and-so,
On
represent
10th, 11th or 12th.
appearing for the appellants. Submit that he has been briefed in the matter recently herein before and needs some time to prepare the case. List after 2 weeks.
Lordship. Deeply obliged.
All right.
May I please, your lordship, with the consent of the other side, beg to mention item number 18 for adjournment, your lordship. We'll file our affidavit in reply within this week, your lordship.
Counsel for the petitioner prays for and is granted 4 weeks time to file affidavit in reply. List after 4 weeks.
Obliged, your lord.
16.
Mm.
May it pleases your lordship, with due consent from the other side, I beg to mention item number 16.
16.
Lordship, the counsel appearing in this case is on bereavement, your lordship.
It is said that the counsel appearing for the appellant is in bereavement and a prayer is made to adjourn the case. The other side has no objection. List up 2 weeks. Scale, you are appearing? 2 weeks. Okay.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item number 19, my lord. My lord may grant quick time to bring on record the recent development in this matter. I have received the instruction yesterday, my lord.
Counsel for, you are for the appellant?
I am the transport department, my lord.
I am for the appellant.
Representing the department, submits that she needs some time to bring on record certain facts which have, by way of subsequent development,
My lord.
list after 2 weeks as stated.
I am deeply obliged, my lord.
Respondent number 1, my name is not being shown in the
Name of this so and so shall hence for the reflected in the call list.
public.
May I please, your lordship, in item number 4, lordship, yesterday we have filed one affidavit, lordship.
Or
May I
let the orders cases be called out. Let the orders cases be called out. That's it.
Wait, your lordship. My lord, yesterday your lordship had permitted a mention memo, my lord, for listing. But due to some certain defects, my lord, that could be listed.
So there must be some defects. You have to cure the defects. Then only
Cure today, my lord, madam may taken up 2 more, my lord. Emergency is there.
check if the defects are subject to curing of defects tomorrow.
My lord.
All right. Yes.
May I please, your lordship? That's why I beg to mention for listing lordship, PIL lordship. Filing serial number 434323. It was filed on 12/4/23 lordship.
What is the matter about?
Matter about lordship regarding the large scale acquisition of land under Bharatmala project lordship.
Mm.
And
So acquisition, how a PIL lies?
lordship in a particular area lordship,
Yes.
Kachar district, a large number of people affected due to unnecessary acquisition lordship.
Oh.
There is a allotted
that-
land lordship.
And you get it listed. There's hardly any scope. Get it listed on in the regular list whenever it comes up. Yes. Okay.
Lordship, item number 22,
Mhm.
this is appeal filed by the department. Lordship, analogous appeal that is also pending, that may be listed along with.
The rest is that tag the file of analogous appeal number so and so. With this appeal and list both the matters together. When?
After 10 days. Lordship.
After 10 days.
Much.
Number 1 for orders.
Mm.
Please, lordship.
Yes.
My lord, today we have received information, my lord, that
That's the service.
already done, my lord, but they denied that today we have received the information from the client, my lord, and we will be receiving that.
So you have to file the affidavit,
Yes,
sir. Counsel for the appellant. Raise for and is granted. 7 days time to file affidavit in proof of the service, in support of the service.
obliged.
List up 10 days. Up the service upon the unserved respondents.
Factor number 2,
Yes. No affidavit file. Who was to file the affidavit?
Yes, my lord, there is.
State.
There is. the order.
Sakya,
Yes, Lordship, Lordship will kindly give me some more time because they have to amend the petition because there is a further amendment. They have challenged the ordinance, but subsequently there is a further amendment on 23rd September 2020.
so why do you want them to give them that opportunity? Argue. It is their, but their headache.
No, prima facie, Lordship, to be honest, there is some unconstitutional on our part.
Okay, very well.
So,
So you want to amend or what?
I will amend, my lord.
yes. Let
The
them
other
amend.
side is telling you.
No.
You are not even aware of that. The Leonard, Advocate General Sakya points out that the petition was filed seeking to challenge the
26/5,
notification dated
no, one is
or
the-
rules. What is the challenge?
My lord, so this is amendment, my lord. Lordship will kindly see page
Seeking to
62.
challenge certain provisions of the
Assam Municipal
Assam
Act.
Municipal Act 1956. But in the intervening period, further amendments have been Act 2020 kar dena. Further amendments have been made in the act and hence, for proper adjudication, the petitioners would be required to file an application for amending the writ petition. Counsel for the petitioner pays for is further submits that the occasion to file an affidavit would only arise if such amendment application is moved. Counsel for the petitioner pays for and is granted 2 weeks time to complete his instructions and to file amended application if so desired.
Otherwise, main cause of action has gone, Lordship, because we have already conducted
then we can-
election in.
We can dispose of the writ petition, give them liberty to file a fresh one.
Yes,
What do you say?
because all
Why
the elections
amendment?
were held.
My lord, I will amend, my lord, because I have challenged this amendment.
So we'll give you the liberty.
Lord.
It's one and the same thing.
Lordship.
All right. You take his statement of Mr. Sakya, that the provisions have been amended in the intervening period. Faced with this situation, that last line that the writ would have to be amended, you delete that. Faced with this situation, then counsel, Mr. Sakya further states that elections as a consequence of the Amendment Act 2020 have already taken place.
Taken place.
And thereafter, there have been further amendments in the act. Faced with this situation, and counsel for the petitioner craves liberty to withdraw the instant writ petition seeking leave that the petitioner may be permitted to file a fresh PIL in context to the amended provisions.
Lordship, my only submission is that after the amendment, the elections held, not
After the amendment, and after the amendment, submit that further amendments have been introduced, and after the amendments, elections have already been held.
highly obliged, Lordship.
Most of it.
Factor number 3,
I'll correct it. Okay. Yes.
Lordship, this matter relates to payment of compensation, Lordship. The sanction has been received yesterday, Lordship. The calculations are to be made, Lordship, within 10 or 14 days. It can be credited, Lordship.
All right, Mr. RKD Chaudhary, Deputy SGI submits that the sanction for paying the compensation to the petitioner has already been issued.
Yes, Lordship.
Now calculations to quantify the amount of compensation is being made. He assures that the payment shall be made within next 15 days.
Lordship.
List on. Give a date after 15 days. 16th May.
Lordship.
Item number 4.
Lordship, we have filed an affidavit yesterday, Lordship, but that has not come into the record of. Lordship.
What have you done? Anything has happened?
Lordship, yes, the issue has been resolved, Lordship. Now or not, Lordship, we started issuing pay slips through email to every officer's Lordship.
My lord, the information that I have gathered, my lord, I could not get because I got the affidavit late. Whatever I could gather, pay slips have been issued and they have been received. But those pay slips, my lord, maximum of them, my lord, are erroneous. Either the name is wrong or the designation, because they have done it, my lord, just to show before my lord. I'll bring those on record, my lord.
Can you appreciate that we have worked forward?
AG sir, Mr. AG, in the very context which is going on, we have passed an order. Probably you must have received the copy. You were not here. We have directed the state to create a database of official email IDs of all your officials. So whenever the notices are to be served, this is a part of that
Today
e-processing.
at 5:30, we have a meeting in this board where all the standing councils, including myself and the chief secretary will sit with the department, head, will finalize that, Lordship. We are
Probably
going
you
to-
you have received that order.
I
Mr.
have not
Nair is
received the
helping
order,
us.
but I have received the invitation to that.
Mr. Nair, Mr. Nair, please pass
I'll
on the
get it.
copy.
But this is in our agenda today, Lordship.
Okay, very well. Mr. Nair is helping us
But that
in,
one, Lordship, that regarding amendment of the High Court rules.
in that very order, we have made a reference.
Already we are,
Email IDs should be collected.
and my representative also attending the meetings,
Okay,
Lordship.
okay, very well. Probably that was long overdue.
Yes, Lordship. Long overdue, we have to take up the backlogs also now.
So this is also one of those steps regarding their payment aspect.
Definitely, Lordship.
There's all pay slips going through by post,
Yes.
being delayed. That's not required.
And in fact, yesterday, my Lord Justice Pathak told me in the court that two of the high courts, Rajasthan and Gujarat, honorable judges are without papers. Everything is on
Yes. There are two,
digital basis.
the judgments, the entire court functions
Is
in a paperless function. We called one of those, both the judges were here on first,
Yes, Lord.
Justice P.S. Bhatti
Lordship.
and Dr. Nupur Bhatti, both
Yes.
were there. So they are paperless.
Hopefully with Lordship interference, Lordship,
Let's
will
see,
also
let's see,
at least make up some of the backlogs.
We'll do that. So,
Highly obliged, Lordship.
yes. Now what do you say? You'll be.
So far as the erroneous Lordship, we do admit, we'll issue the fresh Lordship. That's rectified one Lordship.
Mhm. And what about this e-processing?
That we have started already.
So you're filing anything on record
Lordship, paragraph 5, Lordship.
of what?
Our affidavit filed yesterday, Lordship.
Yes, yesterday affidavit.
Last line, Lordship, at page 53. Lordship.
Rupam, have you got the affidavit?
Not someone supposed.
Let's see their copy. So Mr. Nair, can we close it now?
My lord will not, my lord.
No?
No, my lord will keep it pending for some time.
Okay.
Lordship, at page 53, the last line, Lordship. From now onwards, digitally signed pay slips will be issued to the officer and sent
Yes.
to be forwarded in the respective email IDs of the judicial officer.
Yes,
The respective treasury officers of the, my lord, let them start because that erroneous thing which.
No,
they
no, of
correctly-
course, we
let them
will just test their system.
System. And
Then
they are-
we'll-
My lord, in the next paragraph, they have said that they are bringing on, they are putting on record, putting up a software. Which
Yes,
will be integrated with the, my lord, system of the state.
State government.
So, my lord, they have even had trainings for that. So, my lord, let these things concretize and then, my lord, will.
fine enough. An affidavit has been filed by Land Council, Standing Council, Mr. Talukdar, indicating therein that Office of the Auditor General has started issuing digitized pay slips to the
Officers.
officers.
They're starting coding.
The initiatives taken in this regard have been highlighted in
Para 5 and 6.
the affidavit. Copy of the affidavit be provided to Mr. Nair, who prays for and is granted 2 weeks' time to complete his instructions.
Lordship.
List up 2 weeks. Maybe you can also use this affidavit in that process engineering part,
Lordship.
some of these steps.
Lordship.
Yes.
Much appreciated.
Item
List
number
up.
5.
My lord, last occasion, my lord, the personal appearance of the respondent one who is providing the fine, my lord, was sought for.
Mm. No, Mr. AG, this is the result. Service was effected, no one comes. That is why the officer has been called in the court. So if the e-processing is there, why didn't you come why didn't you instruct anyone regarding appearance in this case? That is why we had to call him. What is your good name?
My Chandan Sharma, Commissioner, Secretary PW Roach.
Okay, so why didn't you appear in this court? Why didn't you instruct your counsel to appear? Did you get the notice?
Yes, sir. I've got.
Did you get the notice?
Yes, I've gotten.
Not for today, the earlier notices.
No, I recently joined, sir, in 3rd March, sir.
3rd March is 2 months back.
Yes.
Did you get the notice of this writ appeal?
In this case, also the call was with the standing.
Okay.
Yes, Lordship. It was his fault. He missed that.
No, question here is that, all right, we serve the copy to the standing council, we have that procedure. But the issue is that when the officer, the notices, thus the service is made, the officer gets the notice. Is he supposed to coordinate with the government advocate or not?
I think they have coordinated, communicated also.
Lordship, in fact, copies were served to the standing council, Lordship. In this case, I received the copy, Lordship.
He was in
That
another
is
court.
directly by the
Yes.
petitioner's counsel. What question we are putting is that the notices are also sent to the department,
Yes.
or not?
Through standing council, Lord.
Right?
Yeah.
Through standing council only.
Yes, Lord.
There is no procedure for direct service on the department or what?
In writ petitions, no, Lordship.
No. All
Department
right.
where standing councils are there.
Okay,
Notices are served through the standing council.
okay.
Lordship, in this case, Lordship will kindly see the order passed by the largest single judge, Lordship. I am only coming to the operated portion at page 20.
Just hold on. Yes, page 21.
Yes, Lordship.
Read.
Lordship, in view of the above submission, the learned counsel for the parties in this writ petition is disposed of at the admission stage itself,
Mm.
with a direction to the respondent number 2 and 3 to examine the claim of the petitioner within a period of 45 days from the date of receipt of a certified copy of this order.
Yes.
And then, if the claim is admitted, the respondent authorities would process the claim of the petitioner in accordance with law. And in the light of the direction contained in Tamsir Supra,
Hmm.
the petitioner shall submit a certified copy of so and so. Lordship, Tamsir is a judgment passed by our High Court, Lordship. It's a full bench judgment.
Yes.
There, Lordship, the financial crunch situation was admitted, Lordship, and accordingly, a direction was passed that if the liability is admitted by the highest officer in the department, then their names will be entered in a list, Lordship, in chronological order,
Mm.
and payments shall be made whenever fund is available, Lordship. Lordship, that was the passed by the learned single judge, Lordship, and he is aggrieved against that.
No, I'm not
He
agree.
is not agreed. He wants an execution.
Yes, my
This is
lord.
basically an execution application.
They are
in this
seeking
case,
a
Lordship,
supplementary fund, my lord. They are making a supplementary fund since 2015, my lord. Till now.
But why an appeal lies? What is your prayer in the appeal? To set aside that order?
No, no,
Read
my
your
lord.
prayer.
Not to set aside, my lord.
Then
They
for
can-
execution,
Yes.
or is it a contempt? Can you file a contempt then?
Kindly see
Why an appeal?
page 102, my lord, on last occasion, the council advocate, my lord.
Oh, sir, please read the prayer in your appeal. Are we sitting as an execution court for the single bench order?
My lord, what happened, my lord, the case.
Can
was
you,
dis-
can you see the
Yes.
relief clause, please?
The entire case was disposed of on the prayer of the standing council NC Hills.
Understood.
Yes, my lord.
So supposing it was a wrong disposal
Yes.
or there was an erroneous statement, you have to file a review. Why an appeal? Do you want us to interfere in the order?
My lord, thing is that, my lord, after completion of the work, my lord, within 45 days, direction.
Sir,
was
a
given.
very simple question.
My lord.
1 + 1 is equal to 2. Do you want us to reverse the order?
My lord, till now. my lord,
What we'll do is, all right, admit the order is stayed. Okay, you'll be satisfied. Why
my lord,
this
the
appeal, sir?
Consequence is, my lord, the fund that is they are saying has been returned back to the state.
Then it is
because-
a matter of
because-
review,
Because they say, my lord, because the fund is to be provided. by the-
either a review or a fresh writ petition against a fresh cause of action. Why an appeal?
My lord, what happened on last occasion, my lord, the NC Hill advocate, they sought time to bring the record of making.
All right, we gave them erroneously, we gave them that leeway. Now we are asking you about the maintainability of your appeal? Why do you give a wrong advice to your client?
No, no, my lord, what happened, my lord, the issue regarding, my lord.
Sir,
the-
please tell us what is the prayer in the appeal? To reverse the order of single bench?
Yes, yes, my lord.
You are not satisfied with the order?
Yes, my lord.
What is wrong in the order? Tell
Wrong
us.
is that, my lord, the Tamser Ali, my lord, judgment which they have cited by the council for the NCL
Hmm.
is its proper place, but that is not the submission from my side. If it is the.
All
submission
right,
of the-
if it was not a submission from your side, then you should have filed a review
Because, my
saying
lord,
that I don't rely upon Tamsher Ali. Why you have put Tamsher Ali in my teeth?
because if.
You
the
should have
Tamser-
gone in review.
If the Tamser Ali judgment is relied on, my lord, the fund that is with the state government, my lord, that they will never be paid, my lord. That is the undertaking given by the council, my lord. Kindly see, my lord, paragraph 5 of the judgment. Now, your lordship will see the page 20,
Yes.
paragraph 5, my lord.
Hmm.
May I read from paragraph 4, my lord, page 20. Referring to the above bills made in affidavit of opposition filed by the respondent number 3, Mr. Das, learned standing council.
All right,
demands
what has
of-
happened in 45 days? The direction was there
Nothing was.
to
been-
examine your claim.
Yes.
Then
that is-
nothing has happened, then it is a case of contempt, sir. That's what we are telling you. Why is it an appeal then? You are not unhappy with this direction, or are you unhappy with this direction?
Yes, my lord.
All right, then we admit your appeal and stay the judgment. That's good. You'll be satisfied. All right, appeal is admitted. There is no application for stay. Feel happy. The personal exemption, presence of the council, the officer is exempted. You want to cause damage to your own client.
No, the thing is that they will never pay, my lord, unless.
Then
this-
what will happen by the admission of the appeal?
Because there is no time frame to pay, my lord. As
Sir,
per the
what
terms
will
and-
happen to the admission, the appeal being admitted, what will happen?
My lord, lordship will place it after 2 weeks for.
Why?
I will satisfy your lordship.
We are hearing you tell us. We'll hold that no, you are not entitled to payment. Then what will happen? You are not happy with the directions given in the single bench judgment, na?
My lord, single just judgment with utmost respect, my lord. That is on the submission of the council.
So you file a review, sir. You say that no, this was not my submission, that you cover my case by Tamsher Ali.
Yes.
So you wrongly applied Tamsher Ali. File a review.
On the other hand, their contrary submission is that fund is no more with us. They say that Tamser is applicable. This is the thing, my lord. Now your lordship, only one page, your lordship say last page 102, my lord, last page of my appeal, my lord. That was the submission of the NC that they are seeking the funds by making supplementary.
We are asking you, we are not sitting as an executing court, Mr.
No.
Counsel. List for admission tomorrow. All right, argue on admission. The personal presence of the, since counsel, Mr. Suvanshu has put in appearance, personal presence of the officer is dispensed with. All right, argue on admission.
Tomorrow.
Yes, tomorrow.
Obligation.
And we may contemplate imposing cost for a frivolous appeal. We are telling you right now. This is frivolous on the face of record.
My lord, I will obtain.
Have a consultation with your client.
Yes.
Yes.
Item number 6 for orders on interim application.
May it please your lordship, my lord.
Yes.
This application, my lords, has been deferred, my lords, on 2 or 3 occasions. This is IA 3705, my lord. If I can just give the background, my lord. The issue here is about, not in the erstwhile when they were having distance education programs, my lords, of conduct of examinations. If I may say so, my lord, this is a second round of litigation. There was an earlier round of litigation which culminated in the judgment of the division bench of the Sikkim High Court, where they said that territorial jurisdiction, you cannot have study centers outside the state of Sikkim. Those study centers were consequently shut down, my lord. After that, my lord, they came up with fresh notifications and eventually a regulation saying that you cannot even hold examinations outside the state of Sikkim. That was challenged, my lord. We did not succeed, and that is the subject matter of appeal in the writ appeal. That is the main challenge, my lords, against the order of the learned single judge subsequent to transfer by the Honorable Supreme Court before this Honorable Court, my lord.
Right.
Now, in the meanwhile, my lord, this one particular individual, my lord, who is visually impaired, he approached, my lords, the Commissioner of Disabilities under, my lords, the Rights of Persons with Disabilities Act 2016. That has culminated, my lord, in an order of 28th October 2022, which your lordship will find at page 30 of my IA.
Okay.
And if I can just read 3 or 4 paragraphs from that order, my lord. at page 31, I'm sorry.
Yes.
Page 31, para 5.3.
Mm.
During online hearing, respondent informed this court that it is bound by the judgment of Honorable Sikkim High Court delivered in writ petition so and so dated 3/1/2020, whereby the Honorable High Court upheld the validity of Regulation 13 of UGC Open and Distance Learning Regulations 2017. Respondent further informed that effect of the judgment is that respondent is bound to conduct examinations within the state of Sikkim only. Respondent also submitted the judgment of Honorable Sikkim High Court has been challenged by writ appeal so and so, and next date of hearing is so and so. The fact that respondent had challenged the judgment of Honorable Sikkim High Court establishes that respondent intends to conduct examination at location outside Sikkim as well. This court is also inclined to take the similar view. One of the purposes of pursuing education programs through distance learning mode is to avoid challenges of overcoming geographical restrictions while appearing in examinations. Because of this reason, educational courses through distance learning are mostly pursued by professionals for purpose of career progression. These reasons become even more relevant in case of the Divyangjan, who are restricted to overcome geographical challenges because of their disability and lack of Divyangjan-friendly accessible infrastructure in the country. This position is same for Divyangjan with different nature of disabilities. For instance, Divyangjan with visual impairment as well as Divyangjan with locomotor disability in lower limbs will find it difficult to travel long distance to appear in examination. However, this court is constrained to pass recommendations on the merits of this complaint because this court cannot interfere when similar issue is pending before Honorable High Court in appeal. So it deferred my lords correctly. Therefore, without touching upon the merits of the present complaint, this court recommends that the respondent can take a sympathetic approach and may file an application before the Honorable Sikkim High Court in the pending appeal, requesting the Honorable Court to consider this case as well as cases of other Divyang candidates as a special case, and may seek relief from the Honorable High Court to allow the respondent to conduct examination of Divyang candidates at different locations outside the state of Sikkim online examination as well, so that Divyang candidates can avoid the problems of traveling long distance to appear in the examinations. Respondent is directed to submit the compliance of this order within 3 months from the date of this order. In case respondent fails to submit compliance within 3 months from the date of this order, it shall be presumed that respondent has not complied with the order, and the issue will be reported to Parliament in accordance with Section 68 of the Act, and the case is disposed of. Now, Lord, I am before your Lordship asking for an exemption for one individual. Totally,
Yes,
my lords, as of today, on my rolls there are 4, but the other 3 are not, my lords, made any request. I am before this honorable court with a request for this one individual. He is based
You want a direction for online examinations for this? individual?
Online for this individual, or if the UGC has some reservation, I will hold it in Pune. But the request of the candidate is that he should be exempted from having to travel to Sikkim.
Travel to Sikkim.
And write the exam physically.
Where is the candidate located? At Pune? All
in
right.
Pune, my lord. The address is
Yes,
at page
what do you
30.
say? Let's hear the other side. Yes.
Yeah, may please your lordship, my lord. The instructions or the direction contained in the paragraph 5.6 and 5.7 are always subject to the regulations that are issued by the University Grants Commission as far as the distance education is concerned.
Yes.
Well, this is a settled proposition of law, my lord. The Supreme Court has come upon the UGC on very heavily on different cases because of some lapses in granting permission to the distance education institutions, my lord. It is since 2001, my lord. It is not time and again University Grants Commission and the IGNO earlier have issued notifications and directions that no university can have off-campus study centers outside the territorial jurisdiction. Therefore, in
But
case
who granted permission to the Sikkim Manipal University to conduct the off-campus centers, to establish the off-campus centers?
My lord, the universities, not only Sikkim Manipal, there are 100 universities.
So who
in
granted
India.
permission?
No, nobody granted permission.
They did it on their own.
They did their own.
That's not correct.
That is why that restrictions had to be made because of my heart goes with that particular fellow who is physically disabled. But if we relax this condition for one person, then we have to open the floodgate, my lord. This cannot be.
He is a different category of a person.
My
He
lord,
has
if
got certain
this
privileges
particular person,
under-
if lordship passes an order, my lord, to have an arrangement in Pune University or some other university near to his.
Why not an online examination?
That can be done if lordship passes a direction because
Yes.
we ourselves cannot do it.
Yes.
Because our regulation does not provide. But he has to go to an
Have
university.
you,
not-
did the institution apply to the UGC?
My lords, for purpose of this examination, my lord?
Yes, yes.
No, they did not.
No, my lord. No, my lord. Because their stand is very clear, my lord, they will not permit. That has been their consistent stand.
All right. What is your reply to the application? What is your reply to the application?
My lord, of late, my lord, this has been a transport case from the Sikkim High Court, my lord.
We have already given 2 dates in this case, sir.
No. I have received the instructions, my lord.
So
I have received the instruction on this point that we cannot grant a special permission to a person particular.
why not in writing? You give it in writing, then we'll deal with it. Why you are shying away from that?
No, I'm not saying, I'll do it.
File your instructions in writing.
My lord,
2 days time only.
my lord, 2 days, I have to take it the signature from the Delhi, my lord.
E-signing, digital signature, matter of 15 minutes.
Not today.
You're living in archaic ages.
Permanently paying, my lord, after 6th of May, my lord.
No, big
No,
no,
no, this is-
absolutely. You are dealing with a different kind of person, Mr. Counsel.
I understand.
Have to
my
be sensitive. You've taken 2 dates, almost 2 months.
lord. My lord,
Get it digitally signed. It is not rocket science nowadays.
Go through many processes, my lord, in HO, my lord. Lordship knows it.
Then we will note that you have failed to file a reply
No.
despite 2
Lordship will not
opportunities
do
being
that.
given.
I'll try my best.
Opportunity to file
I'll
reply
try
is
my best.
closed.
I'll try my best, but difficulty is but from second.
Convey it to your officials. Otherwise we'll require their personal presence here. Your secretary.
My lord, can it be done on 28, my lord?
Yes, 28th. All right.
Very
And
good.
Counsel Mr. So-and-so, appearing for the UGC for all the
Yes,
respondents.
yes. No, I put the UGC. my lord.
UGC, raise for and is granted. Last opportunity to file reply, the affidavit, counter affidavit in this interlocutory application list on 28th April.
I'm grateful, my lord.
I'll file a very brief affidavit because.
Whatever you
I
want.
doesn't have time, my lord, that is why.
Grateful.
The very idea of sending the affidavit and getting it signed from the authority, that goes to show in what kind of age you are living. This candidate is asking for permission to appear in an online examination.
No, my lord, I sent it through mail. I am doing it, but they need to go through a long process.
That is
There are many
retivism.
sections, the sections here, redo it, then
Those are.
queries.
Your lordships
department-
first took up this application on 30th of January, my lord. We are
Commission
now at
has
the end of
to
April.
change its ways.
I understand, my lord.
Those times are past long back.
Well,
We are thinking,
And
we are
I'll
thinking of
instruct them
going,
to see this video, my lord.
we are thinking of going paperless. And you are talking of getting signatures routed through
My hands are tied.
n number of clerks. Sorry, we are not accepting this submission. Okay.
All right.
Grateful.
Item number 8 for fresh admission with stay.
Let me. Well, I'm in respect of an interim order, my lord. Here, my lord, the respondent challenge the inter-office memo, which is at page 57, my lord.
57.
57. Relaxation in time period for deposition of license fee from other entities. With hide no paper so Jones for clarification regard to directors for submission of quarterly license fee for the licenses of SBD and long-term tenders as per corporate office letter number so and so. The matter has examination clarified that the above relaxation for submission license fee of quarterly basis was permitted only for 1 year from the date of resumption of the cooked food post COVID-19.
Hmm.
My lord, this it was my lord modified. My lord, that original letter is at page 69, my lord.
69.
69.
Yes.
This was done, my lord, because the long-term context of 5 years, my lord, they suffered during COVID period. So for them, my lord, some relaxation was granted. The selection time period for deposition license fee mobile this refers so and so line has requested to allow deposit license fee on quarterly basis for a period of 1 year for management of online catering units so and so. The matter has been examined, has been decided that a competent authority all SBD and long-term tender licensing. My lord, this is the important.
Mm.
This is only for them. Shall be permitted to deposit license fee on quarterly basis for period of 1 year only.
Mm.
My lord, this is 1 year left. My lord, they were allowed to deposit.
Has not lapsed.
Now, my lord,
1 year has not lapsed as yet.
My lord,
It'll be completed in November 23.
no, that has been, my lord, that has been modified, my lord. This was modified by the 57.
57. What is the modification?
Modification, my lord, from the date or resumption of cooked food. Cooked food.
Okay. Resumption of, so
So that has
from
already.
you and you curtail the date by a
Yes.
subsequent letter.
My lord. Yes.
Okay.
Now, my lord, what happened? Here, my lord, I have opposed the prayer, my lord, until that two grounds. First, my lord.
What is the
this a-
direction given by
this is a-
single bench?
Yes, my lord. Yeah. The direction you will also find, my lord, at page. But it just at 84, my lord, but the property portion is, my lord, at page 86.
You're against an interim order.
Interim order. My lord, here, my lord, it says, having considered submission of land council of parties, decisions contained in so-and-so letter, address so-and-so, applies the court shall deposit a license fee on yearly basis. Vis-a-vis deposit of license fee on quarterly basis should go to, not go for any prejudice to in between times of deposit. Decision contained in so-and-so was taken in view of the emergence and continuance of the COVID pandemic and situation prevailing post-COVID-19 pandemic, as there was lesser economic activity during the period. And the decision was taken to give some respect licenses for the period of 1 year on and from 2011. No material is placed before the record to the effect that benefit extended by Southern Railway by later so-and-so to maintain uniformity and have level playing field have been withdrawn in the meantime. In such view of the matter, it provided that IRCTC authority shall not insist that deposit license fee on yearly basis so as far the petitioners are concerned till the returnable date and shall receive license fee on
So
quarterly.
the learned single just says that there is no recalling of the order dated 2nd November.
No, no, my lord, recalling said, my lord, but that recalling has not been stayed, my lord.
One more thing,
But
one more
now,
thing.
my lord, what happened?
Just, Ms. Saiwala,
Yes,
who passed the order dated 2nd November 2022?
the same person,
No,
my lord,
read.
yes.
That order is passed by GM and
Yes,
this
yes.
subsequent one is passed by AGM.
AGM.
So
Uh,
are the
well,
officers
that
of
is-
same rank?
That is with the, my lord, with the approval of the competent authority, both. Both are with the approval of the competent authority.
Okay.
And now, my lord, they don't have any SBD or long-term context, my lord.
They don't have any long-term
No,
contract.
no, that file a affidavit, my
All
lord,
right.
annexing.
Then
some
let's see that.
Yes, your losses may come to page 62 onwards, my lord.
62. Was this the argument advanced before single bench?
My lord,
That these persons are not covered even by 2nd November?
my lord.
Was this argument advanced before learned single
Yes,
bench?
yes, my
That
lord.
the petitioners are not even covered by this 2nd November
Correct, my lord,
22?
correct.
Where
And
is that?
Page 76, my lord. Page
76.
Page 76 onward, my lord, they have next some context, my lord. These are on the basis of some fresh tender, my lord.
Where is your affidavit in which you say that the petitioners
No,
are not?
We are not, my lord, filed the affidavit because motion was at stage, my lord, it hasn't passed.
All right.
And we submitted that they have annexed the copies of the some contracts which are.
Where is the pleading in your appeal that they are not covered by
My lord,
these two kind of tenders?
my lord,
Read, please.
yes. My lord, actually, we have submitted the same before the single judge also, page 13, my lord. Your lordship,
1-3. Just
the response.
so
B,
SBD, what is SBD? Full form of SBD?
standard bid document, my lord,
Standard big document.
and the long-term contract. my lord. Submitted the entire approach to the RCT Holy Habitat so and so, which,
Page 13,
no, page 14, my lord.
14. Read.
C. The
Hmm.
REIT appellant submitted that later policy decision taken with the approval of the computer to RCA is further submitted that later the so and so in respect of FPD and long-term licenses for a period of 1 year. It does
What
not
are,
pertain to-
what are the petitioners?
Petitioners are.
What is the nature of trend?
Some fresh tenders issued for only for 6 months.
6 months.
And they were directed by in the tender condition was there that 6 months period they have to pay deposit license fee. Well, your losses may see the new tenders, well, page 76, they have annexed subsequently by filing affidavit.
In which they succeeded. Temporary license.
Yes, these are temporary license, madam. And you'll also see that tender was issued, madam, open on 2/11, one is. Next one is 9/11. These are subsequent, madam. And these are, madam, if you'll also see, they are from Lucknow and Bombay, madam. These are virtually. Now, because they pay GST some in Guwahati also, this register office is here. Well, it is not a register office here.
Yes.
Well, virtually jurisdiction point is also taken by me, my lord.
Yes.
If you'll also see.
Okay. Yes, what do you say, sir?
May I please, your lordship, my lord?
This 2nd November relaxation was
My lord,
to SBD and long-term
my
licensees.
lord, what they have done,
Yes,
SBD is standard bid document.
all right.
So they have issued the online tender notice covering huge number of trains for which people have applied, which are long-term
The question here is, sir, that your contracts even started after the 2nd November letter. You are not an existing contractor before that letter.
Because some of them are existing, they continue to give extension.
But 6 months, that this
Because
long term,
what
this,
they have-
this
what-
relaxation is
No.
only given to,
No, let me, put the background. Your lordships are fully aware, the COVID effect has taken place on railways for 20 months, the railways were closed. Therefore, there was they could not, they continued to have this stuff because they were prohibited
sir,
from.
that would be relevant for the people who are
No,
having
I'm-
tenders
I'm
when the COVID struck.
No, I am only giving the background. Thereafter, when it was resumed, that was resumed, if your lordship sees, 19/11/21. That is the date. And that is when the cooked food was introduced. Now, the impugn order 3/2/23 also says about cooked food, but we are concerned with.
Food?
this-
Question here is long-term
No, what.
tender licenses.
I-
It
I
is
just-
very well qualifies the kind of licenses
no,
would be
may I
covered.
Just place this, below.
Yes, please.
On the association, then after it was resumed, the association thereafter, filed a representation before the railway board. And on 2/11/22, that is much after the introduction of that cooked food, they say that, all right, you pay on quarterly basis installment. They say it's a mode of how you pay your license fee.
Distribution
It
is
can
there.
be in advance or it can be on quarterly basis. So the benefit, and that too only for 1 year. The benefit was given because the situation was such that it called for that and they were satisfied that has to be given. So in fact, the first case which came, that was done and they came on appeal, I am told. Some order was passed. If your lordships now go to the page 83, 83 is the impugn order. It is only an order, at page 86. He has only issued notice and list the case on 2/5/23 along with, he has given the numbers. This case started with, this first case was 7138 of 22. I am told,
Ms. Saiwala, we give you liberty to file 2263. File it 2263.
No, but the other case is also, one is before you lost this, the next case. Next case is also before you lost this.
What we are saying is,
Yes.
you file an application for vacation of ex parte attendance stay. What prevents you from doing it? Have it adjudicated?
They have
On the face
themselves.
of it, my lord, what I am submitting, my lord.
Yes.
Because they are suffering because these are.
Sir, you are in appeal against an ex parte interim order.
Not
right.
party, my lord.
This is
I was heard.
You were heard,
Yes.
but your reply was not there.
Reply.
No.
So you were heard on the very same day.
Same.
Same day. Your appearance is not there. Deputy SJ
No, my
appeared.
appearance is there, my lord.
It is
Page
there.
84.
There.
My
All right.
appearance is there.
So we will give you liberty. File 2263. It will be considered on merits.
Yes.
But
that's
only
what
thing,
your
my lord,
lordship-
is-
Just hold on, sir, please.
I'm sorry.
My lord, only my question is this, my lord, that this is absolutely, my lord, they are unknown to that, my lord, because they don't have
Understood,
any.
sir, because your pleadings were not there. That's why we are giving you liberty. File your affidavit and then argue on vacation of interim stay.
My lord, because what I am submitting.
These facts which you are trying to point out,
Yes.
they were not brought to the attention of learned single judge.
I have brought out, my lord, their losses will see, just.
There is that argument.
Yes.
You could not have, because you were caught by surprise.
Yes.
You should have sought time for filing reply.
No, reply has not been filed. But the
Aha,
only thing,
that's
my
what
lord,
we are saying, that
when-
you should have sought time, saying that, or wait, sir, we'll file affidavit, then only here on stay. You could have done that. So the remedy is file 2263. We'll observe that it will be considered on merits and you will not be stopped from raising all arguments simply because your attendance was there.
Yeah. Yes.
We'll record their concession on this
my lord,
aspect.
your losses may just hear the next case first, my lord, in that case. Next case also, my lord, because this is not. Because next case, your losses next. Right?
Yes.
In fact, we have brought the case, all these cases fixed on 2/5. And that's why this matter.
Next case is against a final order.
Yes.
Yes, sir, please. We can't hear two counsels at the same time.
No, I am.
You can take your seat, please.
Okay.
Your lordship,
all
be retro.
No, we didn't, sir.
Against the interim order passed in this case, my lord, earlier we approached this honorable court. And if you also see page 295, this honorable court directed my lord to hear all the matters on my lord 12/11/12/22.
Just hold on.
295, my lord.
295.
Yes. Challenge by so and so, so and so. Interim order earlier continued. The matter was lastly listed for a single judge on 5/12/22, and the matter order we had the cognate petition. As the matter is at large, the land is single judge, the appeal is not entertained. Let the read petition along with cognate matters be listed before the land single judge on 12/12.
This is regarding this particular appeal you are talking
Yes.
about. But this is against an interim order. We are giving you a liberty.
This is also, my lord, against interim order. This was also against interim. I shall place, my lord, because some relevancy is there, my lord. Because this is the tender which has been annexed here, my lord. In this matter, you can also see the tender, my lord, condition which has been challenged in this petition, is, my lord, tender is issued, my lord, at page 64, but at the main clause is, my lord, page 70. Page 70, which has been challenged here. Page 70, note.
What does this appeal have to do with the earlier one? First you finish off that. We'll hear this independently.
Because this, it has some relevance because this is the tender on the basis of which they annex those.
We understand,
Yes.
we understand,
Yes.
but then the argument that this 2/11/22 would not apply to the petitioners regarding payment of license fee in quarterly installments because they are not holding long-term tenders,
Correct, madam.
long-term vents. You have to point it out to the single bench, get an adjudication, file a 2263.
No, that was pointed out, my lord, that was not.
Read the argument. Read the argument. Where is that argument? Noted. You didn't file your counter. Till then, how the single bench is supposed to adjudicate upon that?
On the basis of the those notifications, my lord, I have argued, my lord. On the basis of the notification, I have argued. Happy that SBT a long-term tender.
That, where is that argument noted in the single bench order, please? If it is not noted already, you file a review then.
My lord, yes, your lordship, my lord, para 3 of that, my lord, page 84.
Read.
The petitioner referred to letter that I have also placed this, my lord, which contains the decision of the competent authority in respondent ISCT to establish that all SBD and long-term tender licenses are hereby permitted to deposit license fee on quarterly basis for 1 year. This has been considered, my lord.
Where? Para number?
Para 3,
Para 3.
my lord.
Yes.
Yes.
So, all right.
Yes.
But then the learned single judge has not been able to discern the difference that these persons who approached the court, they were not holding a license of this nature.
That's correct.
These were never argued.
Well, another aspect your lordship may see, the last sentence by which the interim order was passed, page 86.
Yes.
In such view of the matter, it provided the respondent RCT authority shall not insist deposit license fee on yearly basis. Well, here there is no question of yearly basis because this tender was only for 6 months.
Till the returnable date. So this stay is not unlimited. You can always argue for vacating that interim stay. Raise all these arguments. We'll make an observation that the stay application, the interim application has not been decided. This stay is limited to the next date. Make an argument. They'll consider. Dispose of.
Your lordship may fix it on 2/5, my lord. Already fixed, my lord. On that the matter,
Alright,
the
this-
matter can be hard, my
The
lord.
court appeal is directed against an ad interim order dated 24/3/2023 passed by learned single bench, whereby, the prayer for interim relief, an ad interim order, is order dated 24/3/2023 passed by learned single bench in WPC number 1171/23, whereby, the learned single bench, restrained the appellant from its directed the appellant not to insist on deposit of license fee on yearly basis insofar as the respondent's writ petitioners are concerned till the returnable date, and to receive the license fee on quarterly basis if such license fee on quarterly basis falls due in the meantime. the said order is challenged by the appellant on the ground that the writ petitioners were not holding the SBD and long-term licenses covered by the letter dated 2/11/22, and thus, they were not entitled to have their cases considered under the said communication, which was further modified on letter dated 3rd February 2023. Post up. We have considered the submissions of Ms. Sahiwala. We have gone through the impugned order. Suffice it to say that though the interim order records the presence of all learned counsel for the respondents, but still, it has been limited to the next returnable date. Needless to say that the affidavits on behalf of the respondents were not filed by the time when the interim order came to be passed. Thus, we give liberty to the appellant herein to file its affidavit in opposition before the learned single bench and then argue the matter for vacation of the interim stay order on the next date of listing. It is further clarified that the respondent, the appellant herein shall be entitled to raise all permissible arguments, objections against the grant of interim relief to the petitioners based on the averments made in the affidavit in opposition. Observations made in the order dated so and so 24/3/2023 shall not prejudice the case of the appellant.
Well, on second, it was fixed.
On second, this court is informed that the matter is listed before the single bench on 2nd May. The matter regarding continuance of interim relief, vacation of an interim stay order shall be, we request the learned single bench to consider the prayer of the appellant for discontinuing the interim stay order, vacating the same on the next date of hearing, listing. That is 2/5/2023. With the above observations, the instant intra-court rate appeal is disposed of.
On the next case, my lord, you have not been free, my lord.
Yes, we are having the file.
My lord.
We are having the file.
Now, here, my lord, what they have challenged, page 70, my lord. That is the tender, my lord, it starts at page 67, 63. And the main contention, my lord, their challenge is, my lord. Note, my lord, if you will see. Got it? License fee schedule. The above quoted license fee for 6 months is to be deposited at a successful bidder within 5 working days from the date of issue of LOA or 5 working days before the date of commencement of the operation whichever is later. Issue of acceptance of is to be submitted within 5 working days from the license fee for next 6 months extension, if any applicable, it will be deposited 1 month before the completion of the term of the 6 months. My lord, this is a tender condition, my lord, and they participated in tender and they got, my lord, the tender. And thereafter they challenge it on the basis of the letter dated 2/11/22, my lord.
Again, you argue it finally.
My lord,
That interim, sir, just hold on.
Yes.
When was the interim order passed?
the interim order was passed to the approach this honorable court, and this honorable court fixed the matters for hearing on 12/12/22, my lord. That is why 295 I have said, my lord.
So we'll keep this appeal pending with an observation that in case the SB, the matter before SB is not decided, we'll consider your appeal on merits. Okay?
My lord.
Very well. This court is informed. This is an appeal against an interim, an order dated.
Lord, may I point out only one thing? my lord?
Yes,
This relates to 7138, where your lordship passed the earlier order, because they came on appeal and your lordship remanded. And pursuant to that, the court ultimately has fixed the matter on 2nd of May
right.
to hear the matter. Therefore, they can argue and we can argue and finish the whole matter. Because that is.
The
what-
earlier appeal is also in 7138.
Yes, that is what
My
I'm
lord,
saying.
and this court fixed up, my lord, case for.
Just
hearing-
hold on, give that file.
Uh,
So why,
My lord, order that at 295, my lord.
Your
Please.
lordship's order is that you not.
no, this rate appeal number 131 doesn't arise of.
No, that. Well, earlier against this order, I have.
We
approached
know, yeah, against the initial interim order you came, the court refused to entertain.
And directed to,
Why a fresh appeal lies now?
directed to hear the matter, but.
All right, so now we'll give you an anecdote. You know, there was a preventive detention matter in the Delhi High Court. Okay, we'll not name the judge. The matter went on for 11 months. It was not decided. The period of the order was, the life of the detention order was for 1 year. So the detainee filed a SLP in the Supreme Court. Supreme Court passed an order. We request the learned judge of Delhi High Court to decide the writ petition within 1 month. All right. The order was placed. The learned single judge said, at that time it was heard by a single judge, that we are not bound by the order of the Supreme Court. Again, the matter went to the Supreme Court, and Supreme Court said, yes, the learned single judge was right. So this is not a supervisory jurisdiction. This is an intra-court writ appeal. What is illegality in the order?
No, my submission is this, my lord, because they submitted their tender. They got the tender. And after receipt of the tender, they challenged this.
Sahewala, matter is placed sub judice before single bench. Argue on merits, make a request. We'll again observe. We request learned single judge to try and hear the matter on the next date. That's all. Dispose of.
Matter may be kept pending, my lord.
No, why? You argue the matter there. You got it fixed on the 2nd of May and you
All
are
right.
going to appeal now.
Argue. Dispose of. This is the instant intra-court writ appeal has been filed by the appellant IRCTC, being aggrieved by the fact, being aggrieved of the non-decision of the writ petition number so and so 7138/2022. Pending before learned single bench. Mr. Sahewala submits that in an earlier round of litigation, the division bench observed that the matter can be decided on merits in an earlier round of litigation against an interim order, within bracket WA number 375/22, decided on 6/12/22, this court observed that the appeal is not liable to be entertained, fit to be entertained, and the matter is required to be heard by the single bench. We make it clear that the petitioner shall not, the writ petitioner shall not be entitled to seek any adjournment in the matter pending before single bench. We have seen from the proceedings filed on record that on one date, the case was adjourned because the petitioner was not represented. We make it clear that the writ petition shall not be, that the petitioner's non-representation shall not be a valid ground for adjourning the writ petition. List after 2 weeks.
No, on second, my lord, it is fixed.
We are listing this appeal after 2 weeks. Let's see what happens on 2nd May.
Yes, as your lordship pleases. Only thing.
The petitioner cannot be allowed to take advantage of an interim order by dragging on the litigation in this manner. All right.
May I just point out one thing? To be fair to the learned single judge who heard the matter for quite a few days, we argued this matter. Unfortunately.
Sir, it is better, all right, you argue on merits. Will
On merit.
The single bench is constrained for time. Will transfer the writ petition to division bench.
Let me complete.
Yes.
On merits, we are good. Unfortunately, during the currency of that proceeding, my lord, his mother passed away.
We are not casting any aspersion on single bench, sir. We are saying on 9th March, you are not aware, you are not available.
Saying that we are not.
You are not available on 9th March, that is what the order says.
Maybe, my lord, that may be right.
That maybe that is recorded in the order, sir.
But then matter was heard quite a few days. And during that course.
We are talking of 9th March, sir. We are talking of 9th March.
9th March, I was not here, but maybe your lordship is right. It is recorded, therefore there is no question.
So that's what we have observed.
That's right.
Let the matter come up before single bench.
No No, we are not taking any advantage. We argued the matter. Therefore, we can't help it, my lord, if it is released.
List of 2 weeks.
We're ready to argue the matter. We have filed all our replies.
All right.
Item number 10.
May I please, Lord?
Yes.
Lordship, my rate petition is dismissed and cost of 25,000 is imposed on me as the learned single judge held me guilty of suppressing the material fact of the case.
Yes.
In fact, I have disclosed all the material facts and I have annexed all the relevant documents,
Mm.
but I have been found guilty of misleading the court on account that it is a second petition. Lordship, brief fact of the case that
Mm.
in the year of 2016 and 17,
Mm.
I was engaged to supply some construction materials under MG Nrega scheme. And bill was duly signed and it was uploaded in the online. But due to some public complaint, bill was deleted. Thereafter, I had approached this honorable court by way of filing a writ petition, which was registered as a writ petition number 2283 of 2018. And during the pendency of the writ petition, the inquiry was conducted by the deputy commissioner and report was forwarded to the director or commissioner of PNRD for necessary action. But this report was not placed before the learned single judge while adjudicating the writ
Mm.
petition number 2285.
Yes.
Because at that time, I was not aware, I could not collect the report. I have learned that there was such report and that was orally submitted. And which is also mentioned in the page number 35
Yes.
of the order of earlier round of litigation, that entire detailed report was not placed. When the matter was disposed by passing final order, only that, after that, I obtained the inquiry report. And
Mm.
I made a representation to the concerned authority to take necessary action as per the report.
Yes.
And when they did not take action, then I approached this honorable court again by filing another writ petition, which was registered as a writ petition number 5721/22. So this is my fault, Lordship. This on that ground, the learned single judge held me guilty of misleading the court. So my understanding is that the cause of action is different because in earlier round of litigation,
Where is your earlier writ petition? Where is the petition? What is the prayer? What are the amendments?
in the writ petition, Lordship, this first writ petition is 2285. It is not placed in the record.
That's what we have to see. If the amendments made in the two petitions are similar or not. That's what is to be seen.
And this,
Yeah, the learned single judge was very liberal with you, we can say. In a similar case, we have imposed cost of 5 lakhs. You are standing that risk now.
Lordship,
Ask, put a question to yourself. We'll give you the order right now if you want.
Lordship, this, my understanding is that, Lordship,
Yes,
in earlier round, I approached this honorable court with a prayer for direction to release the bill.
yes,
And second writ petition that I have approached this honorable court, that only that I had.
let us see the pleadings of your second writ petition. Where is your writ petition? At page number?
This prayer part is there, Lordship.
Where is the writ petition? You have not annexed the writ petition.
And I have annexed.
Where is it? Read.
It is in the page number, copy of it, page number 12 to 42.
Yes. Let's see the prayer.
The second writ petition.
We know, we know.
The prayer portion is on page number 21, Lordship.
Read prayer number 3.
Testify in the nature of writ in the nature of mandamus or any other appropriate writ shall not be issued directing the respondent number 2 and 3 to disperse the bill amount to the vendors whose names they had proposed to approve instead of the petitioner still the disposal of their representation. So Lordship, this prayer, I did not pray that bill supposed to be dispersed to me, that
They should not be disposed to others. Why?
because some other parties were there.
Is it a PIL?
No, Lord.
Was it a PIL then? How could you have approached the court asking that bills of XYZ should not be dispersed? What is your locus?
Because the Lordship will, the picture will be more tangible, Lordship, if you read the inquiry report itself on the basis of.
Why should we go into the inquiry report, sir? What is the date of the inquiry report?
Pardon, Lordship,
What is the date of the inquiry report?
page 27. 9th June 2020.
20. And your first writ petition was decided on
First petition was decided on
9/6/20.
9/6/22. Why didn't you bring the inquiry report on record earlier?
I could not get it because I filed an RTI application also at that time. It was not
When did you file the RTA application?
on 2 occasions, Lordship. I
Date,
cannot-
please.
Date is, I cannot remember. On earlier occasion, when I went for the appeal, only then I received the,
When was your RTA application filed, sir? Let us know the date. That is very relevant for examining your conduct. We presume that the application must have been filed before the first writ came to be dismissed, right? So if you are in knowledge, where is your pleading in the writ petition that I have filed an application for RTI? They have not provided the copy to me. Have you got the copy of the earlier writ, Mr. Counsel? Get the file right now. Get the file of the earlier writ petition. And then you will, probably your client will be made to suffer more. Writ petition number 2285/18. That is the rate?
My lord.
Lordship.
Yes,
My lord, page 35, it's, will come to page 35.
yes.
The appeal, my lord. Paragraph 9 of the first judgment of the. May I read, my lord?
Just hold on. Para 9, yes.
Para 9. May I read, my lord?
Never engaged. Ah,
Yes, my lord. Page 35, para 9.
yes.
In the counter affidavit filed by the respondent number 3, it has been categorically stated that the petitioners were never engaged by the respondent number 5 to perform the supply works for rural constructions under Borkola Development Block. The petition number 2 had, however, undertaken some supply works in the year 2015-16, and all the payments with regards to his bills had been cleared, and there was no outstanding bills for any supply works. It has been averred that the petitioners had submitted bills with 4 signature of a member of the concerned Anchalik Panchayat, so and so, who is incidentally the mother of the petition number 1. The said member had submitted that a letter dated so and so, wherein it is mentioned that the DDAN project manager DRDA Kacha submitted some bills which were certified by the forging her signature. She was the mother of the petitioner, my lord, one member, my lord. Based on such complaint, DDAN BDO so and so block had filed a FIR before the officer in charge Silchar police station on so and so against the petition number 1. Herein it is been stated that the said FIR was lodged after making the inquiry by visiting the sites of work and making queries with the village monitoring committees. The said FIR has been registered as so and so for the offences under 468, 471, 420, my lord. And as the dispute was there, my lord, factual disputes were there, my lord. First writ petition was dismissed, my lord, because the factual disputes were there, my lord. And subsequently, second writ petition has been filed, my lord, suppressing that the earlier writ petition was dismissed as because the dispute on facts were there, my lord.
Not-
They can approach the civil court, my lord, if they have any claim, my
Lordship,
lord.
That
How a writ petition, the
submission,
mandamus is
Lordship,
maintainable, my lord.
Lordship, that
There is a
submission that
question.
I suppress the material fact, Lordship will find that I have annexed the earlier.
Annex the
order
cop-
also. It
Annex
may be
a
a
copy of the
procedural-
judgment.
It may, Lordship. it may
You have
be-
annexed the copy of the earlier judgment.
Yes, Lordship.
Yes, all right. Irrespective thereof, why a second writ petition is to be maintained?
At
On the
Lordship,
same facts, why a second writ petition is to be entertained?
Lordship, it may be the procedural lacuna from my side. It may be the,
So all right, then your client suffer for that. We'll increase the cost to 50,000 now.
Lordship.
Are you ready for that?
Lordship, I was the conducting.
This is frivolous on
counsel.
the face of record, Mr. Counsel. Your prayer by itself is mischievous. Stop the payment to other two people. Why? Who are you? You didn't get any order. Those people supplied the goods. They were the vendors who were picked up after the tendering process. You didn't file any tender. What kind of writ jurisdiction are you trying to invoke? All right, dismiss with 50,000 cost.
Lordship, cost may be same. I'll pay the cost. My last prayer is, Lordship,
Yes.
I'll pay the 25,000. It may not be increased. Lordship.
So then you want a withdrawal
I want to withdraw.
after arguing the matter for some time. Then counsel for the appellant craves liberty to withdraw the writ appeal. Hence the same is dismissed as withdrawn.
I have another prayer, Lordship. If you allow me, then I may submit.
Yes,
I may be allowed to file a review petition.
that's your choice. You do it, whatever you want to do. Why should we give you liberty? Left to us, we would have justified our order with full fervor. Don't worry, for increasing the cost. It's too liberal an approach by a single bench in our mind. Such litigants deserve to be dealt with a stronger hands. Next case.
Highly obliging.
Item number 13 for fresh admission without stay.
In this case, Lordship, the state has filed the appeal. And on the last occasion, Lordship was pleased to direct.
Call for the record.
Records are before this honorable court today.
Okay.
We have all the applications of 347, which were never forwarded for the selection purpose. And director is also present, Lordship.
Let's go through this. This appeal is delayed by 4 years. You condone the delay.
Delay has been condoned, Lordship.
Right, okay.
Delay has been.
So what is the
condoned.
matter about?
The
Can we-
matter is, Lordship, it is regarding recruitment of 4 posts of LDA in a particular district.
4.
4 posts in 2 districts, in Kachar 2 posts. And the advertisement was issued sometime in 2014.
Mhm.
These 2 repeats are never applied in pursuance to the advertisement. They submitted the application 2 years prior in 2012.
Mhm.
The director processed it at that point in 2014. There were only 4 applications found.
Hmm.
2 appeared in the written test. They have cleared. Results were not declared. They came before the honorable court. The honorable court directed that complete the selection process.
All right.
And it was found, not complete the selection process, pass a speaking order on the representations.
Mm.
A speaking order was passed whereby it has been said that during the course of inquiry and verification, it was found that only 4 applications were considered. 2 appeared in the written examination. 347 applications were never forwarded for recruitment.
Never
purpose.
forwarded.
Never forwarded.
That is why we called for the record.
Yes,
Yes.
the records are in a trunk in this honorable court now.
All right, okay.
And therefore, they were not considered.
Hmm.
So we have cancelled the recruitment process. That is the case.
Okay. So these are the people, those 4 people
Those
Who-
4 people who did not appear also in the this written test.
who did not appear.
Did not appear. 2 appeared, but they did not submitted their application in pursuance to the advertisement of 2014.
Their applications were pending from before.
2012. Directly.
All
they
right,
submitted-
assuming that is, so what action have you taken against your local officers?
That
who
officer,
failed to-
yes, that was the question to them also. He retired in 2016 itself,
Okay,
in August 2016. This new director found it out in 2019, all these anomalies. And there's an inquiry also.
Mhm.
Those 2 applications which they submitted in 2012 are with the vigilance still now.
Mhm.
Prima facie, there is no indefeasible enforceable right in favor of them, Lordship,
Mm.
although being selected according to them. But
Mhm.
we have not selected them.
No final order was passed.
No
of
final order was
selecting. What was
They
the
cleared the
process?
written test.
Viva was not held.
Viva also held.
Okay, but the result was not declared.
Results were not declared.
So your recruitment advertisement must be having some stipulation that this can be, there is no finality to this process.
Yes, that
Where is
Lordship will kindly come to page 68. That is the
There
order.
must be some stipulation.
Yes, Lordship, may I just place it, Lordship? This
Yes.
order, which will make it very clear.
68.
Page 68, Annexure 9.
Yes.
Whereas the Honorable High Court in its order dated 21/9/2017 held that following in WPC so-and-so, Amit Kumar Dev and others, and state the Director of Social Welfare is directed to consider and dispose of the representation of the petitioners dated 22/3/2016 and 31/10/2016 by way of a speaking order within a period of 6 weeks from the date of receipt of the certified copy of this order. Speaking order passed by the director shall be communicated to the petitioners. Peruse the petition dated so-and-so. The main contention of the representation is regarding prayer for declaration of final results of LDA cum typist, which was held on 18/1/2016 to 21/2016 on the basis of advertisement of 24/2/2014. In compliance of the Honorable High Court's order dated 21/9/2017, the materials on record have been consulted, and it seems that the Director of Social Welfare Assam had published an advertisement dated 24th February 2014 for various categories of posts, including 4 posts of LDA cum typist, which were lying vacant in the district of Kachar and Jorhat. It may be mentioned here that the said advertisement, the candidates belonging to this district shall only apply. The employment exchange registration number of the concerned districts from where the candidates belong should be mentioned invariably in the application form. And for the post of LDA cum typist, temporary post of regular basis, and LDA cum typist, temporary post on contractual basis, application must reach the office of the concerned district social welfare officer from where the candidates belong on or before 31/3/2014 by 5 p.m. Whereas Dilwar Hussain Loskar and Amit Kumar Dev applied for the post from Kachar in pursuance of the advertisement dated 24 February 2014, the roll number of so-and-so irrespectively. Whereas the written examination against the advertisement mentioned was held from 13 December 2015 to, and Viva Pusi was held on 18/1/2016 to 21/2016. Whereas as per record, it is seen that Dilwar Hussain and Amit Kumar cleared the written test held on 13 December and appeared in the
Just a moment. You are saying that these candidates did not apply in pursuance of
Yes,
this
okay,
advertisement.
that I will come little bit later in the
Because
affidavit. We
That
made,
that written this order doesn't say so.
yes, that is not said, but in the affidavit, we have a specific,
All right.
I have verified also this
All right.
point.
Let's see.
Whereas
And
on-
one more thing. You say that the result is not being declared,
Yes,
but the para 11 of the judgment says that the 2 posts of Jorat have been filled up.
Jorhat filled up, Kachar not.
How?
They are with Kachar. There is a difference.
How those 2 posts, when the results were not declared, how
We-
2 posts were filled up?
Separate.
Read page 6 of the order.
This order is in respect of Kachar district also.
There were 4 posts as per you.
Yes,
This-
Lordship.
The speaking order says about,
Let me
talks
complete
about.
this order, then I'll clarify, Lord.
All right, okay.
Whereas on verification of records, it is seen that the result of post of LDA cum typist was not declared along with the result of other posts.
Mm,
This is the line.
mm,
As per available record, 2 posts of LDA cum typist were earmarked for Kachar district only.
mm.
The candidates of Kachar district could apply with employment exchange registration only from Kachar district should apply for the post as per the advertisement of for 24th February 2014. As per the said advertisement, the applicant had to submit their application to the district social welfare officer, Kachar. The district social welfare officer, Kachar, was asked to send those applications to the Directorate of Social Welfare, Assam in due course for selection process. But later on, after written examination and Viva Pusi tests were completed, the then Director of Social Welfare informed verbally the director that few applications were left in his office and requested to take necessary actions on the matter. Therefore, it was decided not to declare the results of 4 posts cum LDA kept pending in the matter.
4
Since-
posts.
4 posts. Since then, no action has been taken to declare the results by the authority. Hence, the results of the 4 posts of LDA cum typist regular was not declared along with the results of other posts which were declared on 17 February 2017. The order of the Honorable High Court dated so-and-so is hereby
That is why the question, how
Lord.
2 posts of Jorat were filled up then?
That let me clarify, because I am concerned only with this Kachar.
You're not concerned with Kachar. You are concerned with 4 posts which have been indicated.
The Jorhat posts also have not been filled up till date.
Read page 6 of the order, para 11, impure order.
Just before that, page 100 for a moment, Lordship.
एक बार पढ़ तो लीजिए. Para 11, read please.
J. Pegu, the learned state council submitted as per instructions received by him. The other 2 posts of Jorhat have already been filled up. He, however, does not have the details as to how the posts have been filled up. So this is Jorhat, this was the submission, but now the director is saying that those posts are still lying vacant.
Chale, all right. What do you want to point out?
Yes, now
100.
page 100,
Yes.
paragraph 4. This was the affidavit filed by the
In the
Social
writ-
Welfare Department.
in the writ petition.
Then director. The
Okay.
answering deponent respondent submits that as per the report dated 4/14/2019, submitted by the district social welfare officer Kachar, total 347 number of applications for the post of LDA cum typist had been received by this office in the month of March 2014. According to the said report, the applications of the petitioners for the selection process was received by the Office of District Social Welfare Officer Kachar in 2012. And no such applications of the petitioners applying in 2014 was available in the official record.
Let us see the application. You have the original record.
The 347 we have, but 2
about-
applications he submitted in 2012 are seized by the vigilance. No? Vigilance, because there was inquiry in respect of various other recruitment process of social welfare. It's a very tainted department at that point of time. It was. Yeah, no,
When we are coming across litigation in this state pertaining to
2-3
selection in
departments.
government agencies, everything is tainted.
Yes,
Everything is tainted.
tainted, more in education department,
Yes,
followed by
you are right.
social welfare, to some extent health
Most
department,
of the litigation coming through from education department.
mostly.
Regularization, right, left and center.
Absolutely.
Nobody bothers
And
about
there was some
judgments.
fault with the honorable court also. Honorable court believed the petitioners to a large extent till 2010. There were contradictions in the honorable court's order also.
That's right, that's right.
So this is, in this case, the
This is your affidavit. Have they countered it? Have they filed any counter against this?
I think that I could not file in my record, maybe.
Then again, 102, read 102.
This is a letter. Yes, this is a letter where the petitioner Amit Kumar Dev did not submit any application. in
There are
the-
2 petitioners.
2 petitioners.
So whether both did not submit application in 14 or only one, because even your order at 100 refers to the petitioner. Whether it is regarding both or one.
In district social welfare, again, Lordship, I have to. There was no 2 applications of these 2 petitioners in the district office.
Your
The
your
as should have been there.
affidavit also says the
Ah.
petitioner.
The petitioner.
The which petitioner? Amit Kumar Dev is clear, then again specified in the document at page 102. Only Amit Kumar.
Yes, Lordship, these are some grammatical mistakes, Lordship.
No, not grammatical mistake. The petitioner, Mr. Amit Dev, did not submit any application. It's very qualified statement in 102.
Yes, that is what.
So the other petitioner, what is your stand, other petitioner?
No, what about the other one?
You please complete your instructions, come back tomorrow. AG sir, get properly briefed, come back tomorrow.
No, if Lordship like, puts a, this is the only question or any further question?
No, any further question we can't say right now. We have to
Because
hear the
today
other
is that
side.
Lordship may admit it in my humble submission. Because
And,
prima facie, they do not have any enforceable right.
Let's see your advertisement first. That's why we are telling you to read the advertisement.
Advertisement at page 46,
46.
24th February 2014.
Have there been any further recruitments in the meantime? in which they may have applied. You don't know,
These,
because the issue which arises is these people become overage,
The director is saying there is no further recruitment.
no further recruitment.
These posts are lying vacant. Page 47, serial number 3,
Yes.
two districts. Prima facie, Lordship, even this advertisement is unconstitutional. It is in violation of Article 16(2).
No reservation provided.
No.
Well,
They are confined, the applicant should be confined to 2 districts
two
only.
districts only.
This is prima facie unconstitutional,
Yes,
but
yes,
I'm
yes.
not on that today.
We need not go into that. But normally, why we are asking you is that normally in Rajasthan, the recruitment notifications contain a stipulation that mere appearance in examination will not give rise to any right. The appointments will always be
Yes,
conditional.
yes, that is
That
absolutely
is
correct,
not
Lordship.
there in this.
The law is well settled in that field, Lordship.
Yes.
Even if they are selected, if their name appears in the selectives also.
That's
if
that's
you have a
no
good
guarantee
ground-
of appointment. Yes.
If you have a good ground to cancel the thing, it should not be arbitrary.
Yes.
Here we have found that 347 applications who have actually applied in
Sir, what do you
pursuant to
say,
the
sir?
advertisement.
We will admit the appeal. We'll hear it at length. This averment that the application itself was filed in 2012
My
was
lord,
not.
the letter your lordship has said that just now my learned friend has placed before your lordship and the query upon this bench is that they have applied in 2014.
12.
2014 was the letter.
12. No, sir. Their letter speaks of only one Amit Kumar. Maybe there might be some error. But what is the crystallized right in favor of the petitioner to be selected simply
Well,
because they cleared the
There is-
examination?
From 1991, the Sangat Das case of constitution bench, there is no right to selection.
Then
But the direction was there to declare my results. Now, my lord, in affidavit filed by my lord, I placed before your lordship, the affidavit. they
is
have
there any
filed-
order cancelling the selection process?
This is the only order, Lordship.
Where is that
That is the
order?
order.
Page
Page 69, the last 4. It is not to declare the results.
that is virtually a cancellation.
Cancellation implied.
Yes, right.
My lord, in a affidavit filed by them before the contempt, they have said they destroyed the answer scripts. They have said, but their stand was never taken during that contempt. There is a affidavit filed by the director, my lord, saying that they have destroyed the answer script.
Answer scripts have been destroyed, but they have decided not to declare the result. That means the process is scrapped. That is what the consequence is. That they have a right to do. If they find any arbitrariness in the selection process, can anyone stop them from scrapping it? It is not a case that they have offered appointment to anyone else.
My lord, to what extent, my lord, arbitrariness, they themselves commit some fraud, is not on our part.
That's
We have
right.
applied for the examination.
Right. You are waiting
that
in
will be-
anticipation.
that
There-
will be
Mr.
justice and
Counsel,
justice only,
there are
my lord.
thousands of aspirants who are waiting in
My
anticipation.
lord, was it there was
The
a call
courts-
that I have done anything corruption or?
No, no.
But
The-
whether
the-
they have taken
just-
action against the respondent,
Just hold on.
nothing, my lord. They will not do anything to them. The corrupt department is corrupt and by saying that, my lord, a person who, I am also an aspirant, I am also need for a job, my
That's
lord.
right. That's
I have
right.
applied for that now after 4 years by paying a cost of 5,000, the delay is condemned. And in a quantum application which is pending for 4 years, they took time one after another,
Mm.
saying that the answer scripts were destroyed. And by, I do not say something, by an affidavit, they come and say something from Govardhan's case to everywhere. My lord, then affidavit cannot change what they are in the impugned order. So justice has to be something somewhere
That's
done. my lord.
right. Assuming for the moment we ignore their contrary stand. Okay.
My lord.
But can you dispute the fact that the employer, the government has the right to cancel any recruitment process if it finds any flaw in the
They have right to cancel the selection
process?
Selection process also there.
Yes. So
but
that is what they have done.
My lord, I have a right to know even in RT, I have to know my right to go for my written test examination.
Yes, all right.
Let
So
them declare my result.
assuming you passed,
My
but
lord, that,
does
that-
does
at
that
least there
give
will be
you?
some justice done on
does-
my part,
does that
that
give
I
you-
have passed the examination. My lord,
All right,
selection
Mr. AG, you show them the result and then take a decision
My
that
lord,
we are
they
scrapping
have
it,
my result.
scrapping the process
They
for
have
XYZ
they have
reasons.
destroyed the question paper. This is the affidavit.
Lordship, those records were destroyed because we engaged a third party. They kept the record for 5 years, thereafter they destroyed it. This is what they have told us. Only 2 answer script.
But while the litigation, when was the litigation filed?
It started in
17,
2018.
18. So what is your stand? When did you destroy the result?
This is, it is a second round of litigation. The first round of litigation in terms of that order of, it is 2016,
16.
7031.
When did you destroy the result? When were the
That's,
results?
third party agency, we have to verify on which date they have destroyed. I'll give that instruction.
Give the date, day after tomorrow.
Lordship.
If you have destroyed it during pendency of the litigation,
They are not parties here, Lordship. And that is not,
the recruitment agency is the state government or the district, whatever the district officers,
Lord.
the education department. So we are not
This is
bothered
social
about
welfare department, Lord.
whose welfare they are doing, we don't know. Day after tomorrow.
But somebody has designed it. How to seclude these 347 applications.
That's right.
And to post only 2 persons.
Do you have those applications with you?
Yeah, it is in the trunk, we have brought it.
You,
Lordship.
there are 2 applications. You have
That,
stated
Lordship, that will verify.
to verify because you have given out a date, 2012.
Yes.
To get it from. If the
In,
record is
in a
destroyed.
report, and I asked the director, Lordship, he said that all these records were seized by the.
To get a copy, Advocate General can very well.
Yeah, we can get it.
Do it.
Those.
Let us see the applications. If that is so, then well, the things become very transparent then,
Absolutely, Lordship.
right?
Highly obliged.
We'll have it on 3rd of May. 3rd May.
Personal appearance.
The personal, we didn't require his personal appearance. We only called for the record.
Lordship. Highly obliged.
All right. A personal appearance of the officer is dispensed with. Call.
Item number 27 of supplementary list for fresh admission.
Yes.
But my knowledge friend for the bank is also appearing.
Mm.
But this is a very simple matter, Manoj. An essay of filed by us is pending in the DRT. And Manoj, during the pendency of the essay, a notice has been issued by the bank for vacating the property.
Mhm.
Manoj, challenging, praying for an interim order regarding that note, we have filed 2 interim applications. with
Before the DRT.
And the DRT is not present up to Manoj, 30th of April.
All right. What do you say? Till 30th April, don't take any action.
Will not take.
All right. On this statement, we'll close
No, the next date fixed before the DRT is 4th of May.
till 4th of May. All right. This writ petition has been preferred by the petitioner. Petitioner seeking a direction of status quo in respect of the secured assets mortgaged by the petitioner with the respondent bank on the ground that the DRT Guwahati is not holding a sitting till 4th May, which is the next date fixed in the essay
I'm sorry,
number
Manoj, the DRT is on leave till 29th of April, but the
Uh,
next date fixed is 4th of
is
May.
not holding a sitting for the present.
Present.
And the next date fixed in the essay number 108/2022 filed by the petitioner is 4th May 2022. 23. Learned Counsel, Ms. So and so, what's your good name, sir?
Yes, Datta.
As the appearing for the respondent number 2, respondents, comma, makes a statement that till 4th of May 2023, comma, the bank shall not take any coercive steps against the petitioners. And on that day, comma, the prayer for interim relief would be considered as per law by the DRT. In view of the statement so made, comma, the instant made by learned counsel for the respondents, comma, the instant writ petition is disposed of.
Deeply.
Okay.
Item number 28.
May it please your lordship. My lord, this is moved as a motion item, my lord. The petitioner before your lordship is serving as an assistant professor in the Department of Radiotherapy, that is radio oncology in the State Cancer Institute of Guwahati Medical Hospital. My lord, she passed out of her,
Just hold on. Why does it come to the division bench?
because my lord, rule has been challenged. That's why it has been placed before the division bench, my lord, by the learned single judge.
Where is the order?
my lord,
All right.
so my lord, she is working already in GMC Oncology Department as an assistant professor.
Mm.
There is another institute called Dr. B. Borua Cancer Institute, which is around 4 kilometers away from GMC, my lord. From there, she passed out her MBBS, MD. And there was a bond that you should work there for 1 year, that all those things have been done. Now an advertisement has been issued by the B. Borua Cancer Institute that inviting professors for oncology in those in certain department.
Mm.
And there were 3 unreserved posts, and the petitioner was also selected for the 3rd post. And in terms of the advertisement, since I am working in a government department, a no objection certificate has to be furnished by the petitioner.
Mm.
Now, when she applied for the no objection certificate, it has been rejected by citing a provision of a rule which has been framed under Article 309. Earlier also, there were several occasions when doctors want to go from GMC to AIMS or a better institute. There are judgments of different high courts also, because this is not the first time that the doctors are facing. All the courts have consistently held that issuance of no objection certificate, if can't be.
What is the rule which comes
Yes,
in your
that,
way?
that your lordship will find at page 50.
15.
50.
All right.
This has been cited as the
Bond period,
no bond period I have already executed.
then 50.
50,
Yes.
that clause 11.
Clause
The
11.
acceptance of the no objection certificate, the acceptance.
Mm.
The acceptance of the no objection certificate for applying to any post, be it directly under central government or any state government or any other organization authority established by the central or state government or any other organization, shall be considered only if patient care or academic services at such institute, college where a member of service is so serving and are not affected and shall be dependent upon the need of the larger public interest. Yeah, the acceptance, your lordship will interpret how the acceptance has to be, whether it is the B. Borua Institute or whether it is the GMC Institute. This rule has been cited in the impugn order. Your lordship will kindly see the impugn order at page 45.
Yes.
I am to inform that
So why the rule is bad? They have not given any of the reasons which are required in the rules.
Yes.
So the order may be bad, but the
Yes.
rule,
Yes.
why does it require the adjudication by a
Malad,
division bench?
Earlier also, Malad, when we challenged this rule, Malad, the query was always
Mr.
put
Kumar.
by the court. This is only an abandoned question, Malad. Yesterday, I even said that for the time being, I mean, my challenge to the rule may not be taken into consideration. But he said that once I have said you cannot withdraw it, it
you
has to
can't,
go
yeah.
before the division
Yeah, what do you
bench.
say?
So,
Your order doesn't have any of the stipulations of the rule. The rule says that in larger public interest.
Yes, my
Where
lord.
is it written in the order?
In this matter, my lord, Advocate General will appear. So after some time it may be taken. Otherwise, my lord, the rule, as per the rule, my lord, because it says that if the patient care is affected and
Then
so-
your order has to say so that we don't have this kind of specialist in the hospital.
Yes, my lord, that rule has been quoted, my lord, because that rule itself. speaks
Quoting,
about-
quoting a rule is sufficient. Is it enough? Or the authority is supposed to apply its mind
Yes,
in terms of the language of the rule?
my lord, if your lordship peruses the deliberations in the department, my lord, then your lordship will find that, my lord.
Where are the deliberations? Let's see. Have you filed something on record?
Yes, my lord. No, I have just today obtained.
What is your last date of joining?
Malad, I have to join by today itself, and they have said that not later than page 43. Appointment letter, Malad. Clause 5.
So this institute is
It's all under
private-
government, but it's all government only from 4 kilometers. And B. Borua specialized in cancer, and this is the
one
only
and the same thing. This is all a government institution. This is
Because we do not have, if your lordship peruses, because regarding the case of the petitioner, deliberations were there, my lord.
Hmm.
So there is a communication dated 10/2/2023. 23, my lord. There, my lord, the director of medical education has written a letter to the secretary, my lord. In the next page, your lordship will find the vacancy position. The petitioner is working in SCI GMC Guwahati, State Cancer Institute. There, my lord,
the professor post is vacant, associate professor post is vacant, assistant professor 3 and register 2. So due to shortage and scarcity of doctors, and in another letter that I have produced, my lord.
Miss,
So there is a there was a meeting, my lord, earlier, my lord, there was a meeting, there was a minute that in particular 4 departments, my lord, that has been mentioned, FSM, forensic science medicine, anesthesiology, dermatology and radiology.
that was an order passed a year back. What has happened thereafter?
Thereafter, my lord, this is a recent position, my lord. The letter dated 10/2/2023 on the application of the.
In the meeting, it was decided that faculty members, doctors of the following departments will not be granted NOC at this moment.
Yes, my lord.
That moment was a year back.
That was there, but present position, the letter from the DME, my lord, Director of Medical Education to the Secretary, my lord, 10/2/2023.
Yes.
And this letter is regarding subject matter, regarding of NOC in respect of Dr. Gitashree Bora, the present petitioner, my lord. So invoking the said rule, my lord, the NOC has been rejected.
Just hold on. Sorry.
Your lordship, I have given that present the position of the doctors at page 13, paragraph 14.
Page?
Page 13, paragraph 14. Paragraph 14, my lord.
Yes.
Page 13.
Page 13. Yes.
Paragraph 14, that the petitioner begs to submit, there are already 3 assistant professors. I am also one of the assistant professors. 2 registrar, a senior professor, a sub-registrar, and 6 number of postgraduate students in the State Cancer Institute, Guwahati Medical College, Guwahati, in the post of radiotherapy and radio-oncology. Hence, in the likely event of the petitioner joining her service at B. Boga Cancer Institute, Guwahati, as assistant professor in radiation oncology department, patient care and academic service would not be adversely.
This is GMCH or SCI GMY?
GMCS, my lord, it's Bhanagar.
Number 1.
No, my lord, number 2.
Number 2. So,
STI, GMC.
yes.
It's in
So
the same
assistant professor 3 filled up. Where are the vacancies? All 3 posts are filled up. If one goes,
Including the petitioner, my lord.
so then
4.
My lord, because other,
Oh.
my lord, a professor, associate professor, all are vacant. Only.
yes.
Yes, my lord.
So you take steps for filling those posts. The petitioner is not going to step into those posts.
We have taken steps, my lord.
Yes.
Doctors are not available, my lord.
Yeah, right.
So therefore, my lord,
She's- Mr. Counsel,
this particular.
she will otherwise also go into another government facility. She's not going into a private facility.
My lord, this rule we have amended, we have enacted this rule for this purpose only, my lord.
That would have been all right if there was not a single or there was only one assistant professor in the
My lord,
college.
it is a big hospital only with 1 or 2.
All right, increase the cadre strength.
My lord.
If you are talking of
even
that.
Even if we increase, my lord.
Yes.
The persons are not available, my lord.
So you have to give them incentives. You have to change their pay scales. Then only you will be able to have good talent. That is the only way out.
But by invoking this particular rule, this
Right.
rule is there, my lord. And
But that means that no one will ever get an NOC.
No,
That is what
because these particular 4 departments, my lord, and there is there.
all right, you file your affidavit. We'll consider.
Yes, my lord. And your lordship may peruse
You
this-
file these documents on record.
Yes, my lord.
and
we will
counsel
file,
Mr.
but,
So-and-so.
Since today it has come, so I have obtained this, but I will file it.
My lord, assistant professor, total 4, including me.
Assistant professor.
Yes, I am assistant professor. Even if I go, 3 assistant professor will be there.
You say that 4, they
4.
say that 3.
No, 3 is, my lord, 3 excluding me.
No.
One registrar in the meantime has been promoted as a assistant professor.
Oh, my lord, this is the latest position, 11 to 2000.
I want
10 to 23.
Yes.
Is not latest.
Not latest.
10 to.
One registrar has been
After the
promoted as
application of
assistant
the
professor.
petitioner, because subject matter is there.
Mr. Kumar,
Yes, my lord.
you also filed an affidavit that one more registrar has been promoted.
But promotion will be done, my lord. 3 assistant professors are already there, excluding me. And one more assistant professor is likely, one more registrar is likely. to be
Bring these
promoted
facts,
assistant.
bring these facts on record through an affidavit.
My lord, your lordship will only protect that post because there are other.
Then you
candidates
don't
who
fill in that, then
Wait list.
she has been selected.
We are not the authority over there, my lord. There is a.
Is that that
Yes.
institution a party?
Yes, ma'am.
Let's see. Then we'll issue notice to that institution.
Yes, ma'am.
No, they, probably we are being represented by the
Respondent number 5.
central government council.
Why? Why central government?
No,
Because Dr. B. Borua Cancer Institute, my lord, that is under the Ministry of Nuclear Research and Atomic Energy, my lord.
Or issue notice. Mr. Mr. Advocate General will be appearing.
Yes, my lord.
You just made a statement. Be sure about it.
I am sure that that is under
Mr. Student, so what's your good name? You take your decision
Yes, my lord.
in that. Your good name, please.
DP Bora.
Appears on behalf of the response numbers 1 to 4. Thus, notice be issued to the respondent number 5 only. Steps for service be taken within 3 days. Rule is made returnable on 9th May till next date, comma. The post of assistant professor E
Yes, ma'am.
in the respondent number 5, which has been, or for which the petitioner has been selected,
yes, madam.
shall not be filled up on account of non-joining of the petitioner on this set post.
You can take dusty service also on the.
Dusty service is permitted.
Deeply.
Rule is made returnable on 9th. The other respondents to file their affidavit in a position in the meantime.
My lord, extra copies. may be
Yes, yes.
served.
During the
Extra
course of-
copies of the writ petition be provided to the respondents council forthwith. Advocate General's attendance is marked.
Yes, my lord.
All right. 9th May.
Deeply obliged.
Obliged, my lord.
Yes. Item number?
In item 13,
Yes.
can I pray for 8 of May, my lord?
8th May. All right.
Lord, Lord.
You inform the other side also.
Yes, I have informed. I have taken contact.
Item number 15 of daily list.
Right. Yes.
May I please, your lordship?
Hmm.
In this case, respondent number 1 is supposed to file the reply. As per the last order,
direction to the Union of India.
15/3.
Where is Mr. Chaudhary? We'll pass it over. Call Mr. R.K.D. Chaudhary.
Item number 17.
All right, give him 7 days. And Mr. Chaudhary prays for and is granted further opportunity of 2 weeks to file the counter affidavit.
My lord, item number 17, we have.
We have
filed
given him 2
affidavit
weeks
today.
time.
My lord, we have filed affidavit today, my lord. So let it be listed after 2 weeks or in that.
In which case?
Item number 17.
17 will take up just now. 2 weeks, list up 2 weeks. That item number 15, 2 weeks. Kar dijiye. Yes. 17
I have filed the affidavit today, my lord.
today.
It is not on the record, my lord.
All
I have
right.
served a copy to the. other side.
Affidavit on behalf of respondents numbers
Respondent
4 to 8.
4 to 8, my lord.
4 to 8 has been filed today. The same be taken on record. Counsel for the petitioner prays for time to complete his instructions. List after 2 weeks
My lord, for admission.
for admission.
Always.
Item number 20.
Yes.
So this appeal, my lord, against the judgment passed by a single judge, my lord, the petitioner was terminated, my lord, while he was appointed as a constable, my lord, in CISF. Then, my lord, after completion of the probation period, sorry, my lord, training, my lord, he was put in the probation, my lord. Probation period was for 2 years. During the probation period, he, my lord, developed a disease, my lord, heart disease, my lord, and thereafter undergone open heart surgery.
And consequently, my lord, he came into the lower medical category, shape 2, my lord. And thereafter, my lord, on the basis of that medical certificate, my lord, medical board was considered, medical board issued that certificate, and his service was terminated, my lord, as per rule 25 and 26.
On ground of medical, being
One-
medically unfit.
Yes, my lord.
Okay.
Then thereafter, my lord, appeal was filed, appeal was also dismissed. Then he approached this honorable court single judge. Single judge has, my lord, accepted the, my lord, lordship will find paragraph 7 onwards from page 182. My lord.
Mm.
May I read, my lord? In the instant case, it is taken note of that the materials on record also provides that when the petitioner was recruited as constable DD in the CIS, there was a medical examination conducted upon him. And in the medical report, he was in a good and acceptable medical state. It happened that in course of his service during the probation period, the petitioner suffered from certain heart ailments. And as because of the heart ailments suffered by the petitioner, his medical conditions too degraded, which may not have sustained him.
What has happened after the directions given in para 11? Have they taken any steps?
My lord, steps not taken, my lord. No steps that they have taken.
Because
Now,
the direction is dissociation from the service would have to be as per the law applicable to the man acquiring a lower medical category.
my lord,
So what has happened as per the directions given in para 12?
my lord, they have not taken any steps. Lordship will also see paragraph 13, my lord.
Yes.
Paragraph
Lordship,
Yes.
kindly matter will pass over for the time being. Senior counsel is, it will take 5 minutes, Lordship.
Pass.
Can it be in Samara Day, my lord?
All right. Miss so and so, you are appearing for on behalf of
K. Gogoi, Lordship.
K. Gogoi. On behalf of CISF.
Yes, sir.
Okay. Standing counsel, Mr. K. Gogoi. Who would be appearing for the respondent number 1? Union of India, Deputy SGI.
My lord.
You are,
K. Gogoi. is
Mr. Gogoi
representing-
appears for whom?
K. Gogoi is representing all, my lord.
All. Ms. MS so and so associate to Mr. K. Gogoi. Representing all the respondents, comma. Please for time, list after 10 days. All right.
The number 21.
May please allow.
Yes.
My lord, what had happened in this case, a particular road construction contract was given to the appellant, my lord. Now, on the ground that, my lord, there was delay in, my lord, the execution of the project. That too in the September 21, my lord, in the, my lord, COVID, my contract was cancelled.
Okay.
That is one part.
Mm.
The second part is, my lord, now they purportedly a retender was issued at the risk and cost of the appellant. And purportedly it was, my lord, like work was given to respondent number 6.
Mm.
Now subsequently it's so transpired, my lord, even from the departmental inquiry, that, my lord, this the then incumbent who, my lord, terminated the contract, he was not even competent because it is the chief engineer who can terminate the contract.
Mhm.
And secondly, my lord, on 28th of February 2020, my lord, he went on retirement. Just 2 days before, my lord, he did all this mischief. Then executive. Subsequently, my lord, the departmental inquiry revealed that, my lord, there was no tender, nothing was done.
Alright.
And my lord, the bill worth about 3 crore was prepared in 2 days' work.
Without any tender.
Without any tender. My lord, there is a report by the.
What was your writ about? What was your writ about?
It was, my lord, challenging the termination of the contract.
Okay.
And purportedly, when we filed the writ petition, my lord, this fact was not known to us that the work has already been handed over to somebody. Then by filing additional.
Handed over
affidavit-
under the said order of the executive engineer.
Yes.
Okay.
Yes. My lord, just one, my lord, I did not trouble your lordship with much. There is an inquiry report. If your lordship will kindly come to page number 361, my lord.
Mm.
The report starts at 361.
Right. So now what is your prayer regarding damages or what?
Yes, not only damages, my lord. No,
Then-
my lord, I can go to the for damages only when there is a positive finding in my
Finding.
favor.
All
My
right.
lord, when I approach the learned single judge, my lord, even learned single judge, my lord, dealt with the matter in a manner, in my humble submission, ought to have been dealt with more, my lord, rigorously, my lord. It was not
Okay,
done.
well, what do you point out? What do you want to
Yes,
point out
yes,
from the
yes, yes,
inquiry report?
yes.
Right.
367. My lord will kindly come to page number 366, my lord.
Mhm. Yes.
On top, as per the office record, Sri Samed Ali, the then executive engineer, Patharkandi and Rathabari, sent a press notice inviting tender white letter dated to the Director Information and Public Relation Dispur Guwahati, requesting for publication in the widely circulated daily in English in Assamese on or before 4/2/21 or 1 day. As per the office record, where it is seen that the same was received by the Director of Information and Public Relation Dispur. As per office record, it is seen that NIT was published in the newspaper Batori Kakot on dated 3/2/21. My lord, the work is in, my lord, Borat Valley, and the newspaper
Publication is-
advertisement is in vernacular in Brahmaputra Valley. But as per the affidavit submitted to the Honorable Court on 3/10/21 by Mansur Ahmed, contractor who filed RTI, SPIO so-and-so, replied by dated so-and-so, that they have neither received nor published press notice inviting tenders dated so-and-so. As such, publication of
Publication is
NIT
doubtful.
in newspaper is doubtful. In fact, my lord, the relevant newspaper which they said published or holding that copy does not contain the advertisement.
There's no advertisement.
No advertisement, my lord.
That paper is there on record.
Yes, my lord.
All right, Mr. Nath will agree to that submission.
No, my
No.
my instruction is not that, Lord. Well, in fact, my instruction, I have received the instruction, Lord. I need 10 days time, Lord, or 1 week time, Lord, to file the affidavit on behalf of 1 and 4.
Affidavit must be there before single. bench.
Yes.
It is there because in while filing the retable, Lord, some more allegations have been, they have brought in to the note,
Okay.
in the matter, Lord. By filing an additional affidavit also, some allegations have been brought. Lord, new grounds have been taken.
Only one
Kindly-
fact,
kindly give us
which
time,
was
my
not
lord. I
before.
Let them
I
state
have
something
the-
additional facts they want to.
I have the
Mr.
record.
Nath submits that
Yeah.
he has received instructions, fresh instructions to file an additional affidavit in this appeal because certain averments over and above what were made in the writ petition have been set out in the memo of appeal.
Yes.
A praise for it is granted, 2 weeks time to do the needful. List on 12th May.
My lord, there is one more, my lord. They will not release the bill, my lord, because the bills are pending. That lordship will protect.
A list on 17th May. Till then, the bills towards the work in question shall not be released.
Yes, deeply.
Number 23.
Yes.
Yeah, please, also, my lord, three affidavit, my lord, regarding response number 3, 5, and 6 has been served, my lord, today.
Applications.
Affidavit
Well, we
of-
have filed a affidavit of opposition on behalf of respondent 3, 5, and 6.
Okay.
Today. I have served the
Today.
copy on the other side, yes. So let it be on
Affidavit-
record, lordship may kindly-
Ms. Council, Mr.
B. Gogoi, madam.
B. Gogoi has filed affidavit in opposition on behalf of the response numbers 3, 5, and 6.
No.
On the last date, you appeared for 1 to 6.
1 to 12, my lord.
No, affidavit on behalf of 3, 5, and.
Only,
Otherwise,
all right.
Official respondents have appeared.
Copy thereof has been provided to the petitioners council. The affidavit be brought on record. List up 4 weeks.
My lord, the affidavit so far, my lord, pharmacy council concern, my lord, this is also my lord essential because my lord, the drafts of.
Who is
the
representing
affidavit,
the-
my lord,
I am appearing, my lord, they have submitted that, my lord, so far as the present case is concerned, my lord, they are no way connected. So, my lord, that
my
affidavit.
lord,
is not
the- so far, the-
My instruction, I will place the survey copy to him.
my lord, so
I have
far,
taken
so far, my lord, the allegation is this, my lord, the.
They don't want to respond. We'll accept whatever you have said.
Yes,
Written instruction.
yes, I have placed. My lord, the Pharmacy Council of Assam is only concerned with the enrollment of passed out pharmacies. Here is the case, my lord, they have instituted against the institution who are imparting the education, these degrees and all. They are no way connected.
But the, my lord, pharmacy council act and the rules also concern, my lord, there. So
That to be defined by whom, my lord?
We'll consider, take your averments in the writ petition as uncontroverted by the pharmacy
So
council.
they have to, my lord, written the, my lord, these things in record that they are not, my lord, my lord, any submission will be from the. from the council.
We'll record his statement that there is no
Yes,
proposal.
that may be recorded,
Yes,
my lord, then.
all right.
Well,
Mr. Gogoi further submits that on instructions from the respondent number 1,
Respondent two.
respondent number 2, that he has received instruction from the respondent number 2 that there is no requirement to file any affidavit on its behalf in this writ petition. The copy of the written instruction is dated 16/2/2021 is placed on record.
My lord, this is so far the, my lord, pharmacy council of Assam, my lord.
Some,
But the act is
He's-
concerned, it will pharmacy council. of
he's
India.
talking about Pharmacy Council of India. Then
It is the union.
who is representing?
Union.
Notice is served.
That notice was not issued, my lord.
Issue notice to the other respondents.
All right.
Respondents numbers.
1,
7 to.
All right. Notice has still not been issued to the respondents numbers 1,
12, my lord.
1, 2, and 12.
No, 1 to 12, my lord.
You are appearing for,
My lord, 2, 3, 4, 5, 6, I am appearing.
since Mr. Gogoi appears only on behalf of the respondents of 2, 3, 4, 2 to 6,
Yes.
let notice be issued to the other respondents. Steps be taken within 7 days. Rule is made returnable in 6 weeks.
All right.
वो मत लिखिएगा.
Master blessing. All right.
The number 24.
Oh, sorry.
In earlier occasions, my lord, your lordship asked the government to file affidavit regarding the. So on the, as against that, we have also filed our counter. Now the question, what is the government case? Because when your lordship said that from irrigation department, records should be produced. Accordingly, they have produced record. And these two documents, from those two documents, one thing is very clear, that the latest document regarding her status as a government servant, so far that aspect is concerned, that she belongs to the general category.
Okay. Yes.
If that be so, my lord, there is no question of giving any benefit of that.
Okay.
Secondly, my lord, my learned friend also raised that question. Since your lordship also once hinted regarding that locus standi, I think the matter is resolved by the decision of the Supreme Court.
Okay.
First, my lord, the Bombay High Court said, unfortunately, they referred to a Supreme Court decision, but didn't give any reference, only Supreme. So, my lord, the lordship will see that. No, Bombay.
Yes, please.
Lord, this is a decision from a Bombay High Court division bench. your lordship may kindly come to para 6, page 4 of the photo session.
Mm.
It is so far, your lordship got it. In so far as the issue of locus is concerned, the apex court has held that the issue regarding the locus cannot be restricted in the matter regarding the status of caste and tribe. It has been held that if a candidate claims a status of particular reserved category, though he or she is not entitled to that, a citizen would be entitled to knock the door of the court and seek redressal. In this view of the matter, we find no substance in the preliminary objection and reject the same. Now, my lord, here two things are there. One is that this decision referred to one apex court decision. But we have tried our best, my lord, to find out this, but we failed.
Okay.
And here, not only a particular person, a citizen has the right. That is the what Bombay High Court held. Now, my lord, another. I'm grateful to my learned junior. That judgment we could not find out, but there is another judgment of the Supreme Court, 2008, 9 SCC, page 54.
Yes.
Your lordship may kindly come, paragraph 45, page 74. May I read it, my lord?
Yes.
We must now deal with the question of locus standi. A special leave petition ordinarily would not have been entertained in the instance of the appellant. Validity of appointment or otherwise on the basis of a caste certificate granted by a committee is ordinarily a matter between the employer and employee. This court, however, when a question is raised and can take cognizance of the matter of such grave importance, so motu. It may not treat a special leave petition as a public interest, but as a public law litigation. It is in proceedings of that nature permissible for the court to make detailed inquiry with regard to the broader aspects of the matter, though it was initiated at the instance of a person having a private interest. A deeper scrutiny can be made so as to enable the court to find out as to whether a party to a lease is guilty of commission of fraud on the Constitution. If such inquiry subserves the greater public interest and has a far-reaching effect on the society, in our opinion, this court will not serve as its responsibilities for doing so. I think matter is laid rest so far that concerning. Now, my lord, my learned friend, before the single judge also relied on that Patil's case.
Madhuri Patil.
Madhuri Patil. If we, my lord, go with all the principles evolved there, then it may not be at all what my learned friend wants to say. Now, if your lordship kindly takes that case, that is a first case, my lord, even the government also relied on that. Single judge also relied on that. And then while relying on that, single judge did not explain anything. He quoted the report of the authority concerned and subject to correction, my lord, I don't find any finding or any reason given by the learned single judge in the judgment. Only thing, my lord, he says that government record is like this and the inquiry committee has held like that. That was quoted, and these are the things, my lord. Not only private persons are involved. So far court is concerned, court will have to see the entire broader aspect of the matter, whether there is any scope for fraud, or the judgment should be give certain direction so that in this type of matter, always, my lord, this will be disputed by either party. So Supreme Court also in many of the cases they took it very seriously. In fact, in one of the cases that it is a fraud on the constitution. Or our case here it is that so long you were living comfortably. When this matter comes in, then only you decided to take certificate. And mother did not take any certificate. Moreover, if your lordship see the entire thing even on their own admission, the lady in question, she has, now of course she is married, till she was not married, she took the surname of father. And their own evidences, they used to stay with them. That is number one. Number two, my lord, if at all her father's marriage was disputed or did not give the real recognition, that is by their family, that means father's family, namely grandfather of the petitioner. So here is the question of coming, they have said they were deprived of this thing, and we are making a statement. If your lordship looks into their averment, finding nowhere they have adduced any evidence. In all the cases, Supreme Court says that they must adduce facts. There must be some evidence. Now somebody, some Gambura and all these people come, they give a certificate. On that basis alone will not do. And then, so far that inquiry is concerned, how broad-based it was, at least confining to her mother's village or father's village and surrounding places. Because the public interest is involved here. So that is why your lordship will kindly consider.
Yes.
And so far the other candidates of OBC. Now, so her question is this, that since she has been deprived of all the advantages and she was not being recognized, then she took mother's, and she was there. But all along we have seen, she stayed at Guwahati with father, she stayed at Jorat with father.
Yes.
All official communications in the father's address. As much as, my lord, when it was all over, when she took permission, admission in the law college, there she showed as a general candidate. Because in that case also, my lord, some seats are these professional colleges. These questions arises and they get certain benefit of the reserve category. Now, if you're kindly government. Now, your lordship would kindly see. Your lordship may kindly take the government affidavit, the last affidavit, filed probably on 10th March.
Yes. Yes.
Millard, the lordship can kindly come to page 184. Should be good.
Yes.
The next, sir, one, my lord. No? Service book, my lord. No mention of OBC.
Yes.
Then, my lord, when the matter was sent for a regularization, first time she claimed to be OBC, it starts from 216,
Mm,
page number,
yes.
with reference, your lordship got it.
Yes, yes.
With reference to the above, I have the honor to submit herewith the list of master roll workers as per performer supplied from the Chief Engineer Irrigation Department and onward admission to Chief Engineer as desired. This is for favorable. Next year, page 2017. Now your lordship would kindly come, page to 218, continuation.
Yes.
120.
Serial number 120.
Yes.
For the first time, she was, there's some correction, my lord. Past
It is the diploma in English typing, English national typing,
diploma in
diploma in English and
English and in
Assamese typing.
Assamese typing, general.
ठीक है, तो OBC, then OBC.
Then, my lord, last one was OBC.
Yes.
It will not put any document.
She did not submit any document.
All right.
It really clear.
Okay.
It really clear that that is why promotion of the search, she was trained to be a
Then, my lord, your lordship would kindly.
Where is her
come.
name in the list?
Yes,
Where is her name in the list?
120,
120,
serial number 1.
page 218.
Yes. All right. What is the date of this document, sir?
This was
8/6/2005.
8/6/2000. So herein,
forwarding letter,
herein it is OBC.
OBC.
Okay.
Now, your lordship will come, that
Yes.
since she could not show any document, perhaps. I am only,
This was the letter, forwarding letter.
now your lordship may kindly come page 219.
Yes.
The letter is to the chief engineer by the executive engineer, Jorhat Division.
Oh,
With reference to the above subject, I have the honor to submit here with the proposal for filing of the vacant post of senior assistant by way of promotion. Mrs. Nirupama Borua, senior, then in favor of your approval. In this connection, senior list of assistant vacancy position and senior assistant sanction strength, 100 points roster and character incumbent are enclosed herewith for favor of your kind disposal. Then, my lord, it was next page 200.
Number 2.
Serial number 2,
yes.
Purnima Datta, so and so, general,
Right.
last clause.
Okay. Hmm.
So, my lord, this document was submitted before the court after we have gone into certain extent. Your lordship also asked for certain queries. We also said, my learned friend also said.
Right.
Now, perhaps for the court, it was easier to rely on the government document. And it
Yes.
is, your lordship would kindly see this letter was 16
This was
Yes.
in the 116. She never asked for change in this matter if she was OBC. And it was quite late. By that time, she had documents.
19 would like.
Sorry, she had no documents till that time. Only in 19, she brought out some document. Before going to that, my lord, I would like to show one thing. Why this is taking place? She has to explain.
Yes.
She must come and say that this is my evidence. These are the documents. I
Yes.
don't say, my lord,
Yes.
that whatever documents she plays, it may be a part of the evidence. Those certificates and the way they have brought the certificate, that also creates a doubt how they got it. Now,
Okay.
in this matter, at least last document as per your lordship query, whether it is easier for the court to come to the conclusion as OBC or
Right.
general.
Okay.
And the
Yes.
last document is general,
Yes.
and that too fixing the seniority.
Right.
At least after that, before coming to the court, she should have applied to the government that there is a mistake.
All right. Yes.
My learned friend has relied in Ramesh Bhai's decision. Actually, my lord, on that date, I didn't go through this decision. Now I have gone through it. Your lordship may kindly come. The Ramesh Bhai decision 212 3 SCC 400.
Yes.
Now your lordship there may kindly come to page 53.
Yeah, no. Yes.
53, 54.
Yes.
Now, my lord, a question is posed. If a question is posed, on the basis of which evidence you are asking to be declared as SC.
Yes.
Something must be there as evidence, and it has to be it must depend on a document which is sufficiently pure. Because your lordship is deciding something which is disputed.
Yes.
Then your lordship may kindly come page 424. I'll rely on 3 paragraphs. 424, paragraph 53, Ramesh Bhai decision. Arvinda Kumar Saha versus State of Assam, a division bench of the Guwahati High Court had a case before it in which a person whose father belonged to the upper caste and mother of a scheduled caste claimed the scheduled caste facts also same. And case originates from here. The court found and held that though the father of the writ petitioner was admittedly a forward caste man, he was brought up as a member of the scheduled caste. This was evident from the fact that the writ petitioner had not only been the office holder of Anusuchit Jati, appellant as belonging to the scheduled caste, Karmasari Parishad, but scheduled caste community treated the appellant as belonging to the scheduled caste. And even the non-scheduled caste people treated him as a scheduled caste in as much as in his college career and in his service career, he was treated as a person belonging to. This is very important. Throughout my career, she is sufficiently young, madam. It is not the fag end of her career. Throughout my career, can you show on record that I was treated or deprived of the certain thing, or that society treated her as scheduled caste? Because if we read Melodi's decision, then we find both sides that you give evidence, say where you were brought up, where you stayed, there you face some difficulty or some opportunities given by deals like reservation and all that, you were deprived of that. Where is that fact? Mere saying will not do. And that too in 19, whereas the evidence not a single state there except the statement they are deprived. How? You stayed with your mother. I mean, you stayed with your father, both at Guwahati and Jorhat. Nothing is there that she faced this problem. Now, by mere showing a certificate will not do. And who gave that certificate? That has to be seen. And no record they referred. Otherwise, my lord, if it is a certificate for some administrative matter, it may not be that serious, but she wants on the basis of those certificates that to issue in early.
Right.
He wants to be declared as OBC and so that she can avail. If so, admission is an equally important in law college. In law college, in admission, she showed as a general clerk. In fact, all throughout her career, she showed as a general clerk.
Yes.
His brother also. Her brother, so how, all on a sudden, out of two children, one comes as a scheduled caste and one comes as OBC.
Mm.
Moreover, my lord, she never said that she suffered from any financial difficulty while she was studying. She never complained anything against the father. Two cases may be there. Lord, one is that having the forward class man, having married a scheduled caste man, after some time, the person started misbehaving. Children suffer for it. That is one class of thing. Another class where I stay, all the time I am being harassed, saying about this. Which one is there? But so far, father is concerned, nil.
All right.
Not a single son.
Yes.
So far, society is concerned, only those certificates. Certificates given by whom? Then, my lord, your lordship would kindly see Ramesh Bhai's case in paragraph 54. 53 to 54. In view of the analysis of the earlier decision and the discussion made above, the legal position that seems to emerge is that an intercaste marriage or a marriage between tribal and non-tribal, the determination of a caste of the offspring is essentially a question of fact to be decided on the basis of facts adduced in such case. The document may be also fact recorded. So what is those prominent documents on which we can rely and thereby persuade the court to declare it? Then, my lord, the determination of caste of a person born of an intercaste marriage or a marriage between tribal and a non-tribal cannot be determined in complete disregard of attending facts of the case. What are the attending facts? First, on there we have the here it is established. Now, that evidence they must adduce evidence. Then we'll have paragraph 55. In an intercaste marriage or a marriage between a tribal and non-tribal, there may be presumption that the child has the caste of the father. The presumption may be stronger in the case wherein the intercaste marriage or a marriage between a tribal and non-tribal, the husbands belong to a forward class. But by no means the presumption is conclusive or irrefutable, and it is open to the child of such marriage to lead evidence or to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being the son of a forward caste father, he did not have any advantageous start in life, but on the contrary, suffered the deprivation, indignity, humility, and handicap like any other member of the community to which his or her father belonged. Admittedly that he was always treated as a member of the community to which her mother belonged, not only to that community, but by the people outside the community as well. So as I said, the question of both. her caste to which she wants to belong. Both sides, probably if I have understood correctly, Miller,
Yes.
wherever she suffered, and that has to be proved to the hilt by adducing evidence.
So that you have said 7 times, no need to repeat, please. You've said so 7 times, you have noted that. No need to repeat.
And your lordship will find
Yes.
this decision, when she obtained certificate, this decision was not there. It was 2012 and she got it 2006.
Yes. Very well.
Another class comes there when mother becomes a single,
Mm.
either divorcee.
That is not a situation here. She is not a divorcee.
She not,
So why traverse on that situation? All right. Yes.
but she has to claim it, no, when she has claimed it.
That you have said, sir, we'll consider your argument. Yes.
এইটো সেইকাৰণে so even then, Miller, though it is not case there, but even there is a notification for single mother, divorcee and all that. Your lordship
We are
may
not
kindly
dealing
note
with that situation. Yes.
Notification dated, Miller, issued by the central government, dated.
We are not dealing with that situation, sir. We are not faced with that situation. How does that
No, no, Miller,
notification?
just for understanding, I am showing it.
We'll try to understand the best, to the best of our capability. Don't worry.
I'm only
Yes,
bringing it to your lordship, because I'm not relying anything on that.
very well. Yes.
That is annexer A1, the decision, I mean
Yes.
the notification. Then, Miller, having said this, Miller,
Yes.
if he has to be in the category of OBC, Miller, then the question comes, there is a notification, what is the, whether she is belonging to the creamy layer or non-creamy.
Is there a concept of creamy layer or non-creamy layer here?
Yes,
Is there a concept?
yes, Miller.
All
I'm
right.
saying that.
Mm, yes.
If you say, Miller, the Indra Sahani's case,
Yes.
there are 2 cases, Miller. If we go to the second one,
Yes.
2001,
So certificate will be treated as it is. If the certificate says it is creamy layer, if the certificate doesn't reflect that she is the candidate of NCL, then she'll be treated to be of
no,
creamy
Miller,
layer.
that's not been gone into by the employer.
All right. Let's see the reservation provided. Where is the reservation?
Reservation provided in 95.
Page 95. Where is the recruitment notification? What is the reservation provided? Is it for NCL only?
No, no,
Then
no, Miller, that question will arise only after holding her to belong to the ABC. Then only the question of creamy lawyer will come,
so
otherwise not. And creamy lawyer not on the basis of the caste.
obviously that
lawyer
is on basis of income of each year.
income. Then
Yes.
what was her income?
Yes, her or her mother's income.
Both
Parents,
parents' income, there is
parents'
a
income.
notification, your lordship.
So
will see.
why should we enter into that, sir, for the present? We are not required to enter into that.
No, no,
That is not the controversy in this court.
Suppose, my lord, the OBC, if it is shown, neither she belongs to the creamy lawyer nor. she belongs
Why
to-
are we supposed to enter into that controversy, sir?
Because your lordship, if your lordship holds that she was treated as a scheduled caste and thereby transferred to the category of OBC. In that
Yes.
case, it has to be decided by the government first, whether she belongs to the creamy layer.
She will be required to procure a certificate if she wants to be treated as an NCL.
Those
It is her.
those certificates are not.
So,
yeah.
all right, then she will, if the certificate doesn't say so, she doesn't get any advantage. Why are you worried then?
No, no.
Why are you worried
She
then?
has been claiming there. And she has.
What is the certificate? Let us see then. All right.
Before that, Miller, I would like to show that notification about the income.
Sir, please show the certificate first. We understand what is NCL and what is creamy layer, we understand that. Let us see your certificate.
At 57.
57,
57.
87 or 57?
57. 57.
Yes, all right, that aspect will come when she claims to be a member of NCL. Why we should cross a threshold we have not even reached?
She claims that she has to show that she.
But there is no
beyond-
such issue before this court, sir. For the present, the issue is whether this OBC certificate is valid or not.
No, my lord.
NCL, she will claim whenever she wants. Then you will have
No,
to
no, once he goes to the OBC, government itself has to do it.
do what?
To do-
Automatically she becomes
whether
NCL.
She belongs to creamy layer or not. Then
Is it
only
is it an automatic consequence of she being declared to be an OBC?
Yes, yes.
Oh,
No,
that's too much.
no, don't-
She has to apply. It's not an automatic
She has
consequence.
already applied for OBC. She has gone to the OBC.
Sir, for the NCL, there will have to be a fresh process.
No, she cannot claim reservation. Thank you.
You don't expect this kind of argument, sorry.
She cannot claim reservation.
All right, sir. We will. Please tell us from the SB order whether NCL or non or creamy layer issue was there before.
Your lordship,
Yes, be.
If not satisfied with the.
Sir, that issue is not there before this court. Why waste the time of the court on that?
No, it is not a question of wasting time.
It is obviously. Where is the ground in your appeal that the issue of NCL and creamy layer is involved in this case? Read from your memo.
Even then, Miller.
Read from your memo, please.
Even then, Miller, I can raise that point because it's a constitutional.
No, sir, we will not allow you to do that because that is purely a question of fact.
No, Miller, that is different. Your lordship.
That is purely a question of fact, whether she is an NCL candidate or creamy layer candidate.
7.11.
Your lordship may
Round down 7.11.
read appeal,
Page 19.
Yes, read please.
page 19,
Yes,
7.11. For that,
yes,
even as otherwise, as per office memorandum dated so and so, it is provided that members of the other backward classes
yes.
who fall in creamy layer shall not be entitled to the benefits of the reservation. In the instant case, both the parents of petitioner are working under the state government as class one.
Sir,
and-
did she claim any relief in the writ petition that to declare me to be NCL candidate, NCL category? She did not claim.
Milord,
So
till-
why are we supposed to adjudicate on
No,
that?
no, till that time, my lord, whether she be treated as my lord, the scheduled caste or OBC, that why do you come to the court?
That is their problem. They want to be treated as OBC. That's their problem.
The moment you have to be
Sir,
declared as
we
OBC.
can't decide an issue in
My lord,
anticipation,
Your
please.
lordship is not getting me. What I am saying, I am raising these 2 points. Suppose your lordship,
We don't propose to adjudicate on that, sir. That was not the issue before single
at
bench.
least your lordship can reject it.
Why? That was not the issue, sir.
No, no, my lord, because this court is not the final. So that I am not guilty of not raising that issue. I have taken as in a pleading.
Okay, very
as
well,
as that.
very well. Understood. Okay.
And this notification your lordship will see regarding her. Where a lawyer cannot expect that all his contention will be accepted, but I have to raise it.
Yes,
That is what. Your lordship kindly say, page 237,
yes.
annexure A2. Office memorandum dated 13 September 2017. The undersigned is directed to invite attention to this department's office memorandum, which inter alia provided that sons and daughters of persons having gross annual income of rupees 1 lakh or above for a period of 3 consecutive years would fall within the creamy layer and would not be entitled to get the benefit of the reservation available to the other backward classes. The aforesaid limit of income for determining the creamy layer status was subsequently raised from 2.5 lakh to 4.5 lakh and rupees 6 lakh by this department were so and so, dated so and so, respectively. It has now been decided to raise the income limit of rupees 6 lakh to rupees 8 lakh per annum for determining the creamy layer amongst the other backward classes. Accordingly, the expression rupees 6 lakh under category 6 in the schedule, this department aforesaid one dated 8 September 1993 would be substituted by rupees 8 lakhs.
No, paid in the repetition. Yeah. Yes, all right.
What I am submitting, that
Yeah, we have taken note of your submission that she is not a candidate of OBC NCL, and so she is not entitled to reservation under this notification, which
Yes.
issue was never there before the single bench,
my lord.
which was not an issue before single bench. She
yes,
never made such
yes,
prayer.
that's true.
So why are we required to adjudicate upon that, sir?
Your lordship may not refer, that's a different thing.
Yes,
My
all right.
department-
Yes, you are entitled to raise any kind of argument under the earth, under the sun. If it is relevant, irrelevant, but you are entitled to make
No,
such.
then your lordship will say that in the judgment.
All right, very well.
My duty is to argue.
Okay,
Your lordship's court's duty is to give it the judgment.
yes, yes,
I cannot
understood, sir,
express all
understood.
my points, but
Continue, sir, please. Continue, please, kindly continue, yes.
It is a constitutional point.
Sir, please continue. We are taking note of your
Yes,
arguments.
that will be enough.
All right.
Then, my lord, let me put the Indra Sahani. List এখন বারে বারে বানাবো আপনার। As your lordship knows that the first Indra Sahani case was a big bench about the. I'm not
Yes.
going to bother your lordship with that. Now your lordship would kindly see.
Yes.
Two hundred one SCC, one.
We will continue at 2, sir. Mr. Burgoyne, we'll take up your matter after this is over. Yes. At 2.
Subsequent development, lordship. With the apprehension that the NHIDCL may go on a appeal by filing the SLP before the Honorable Supreme Court,
Mhm.
we filed. What do you call it? Sorry. We filed a caveat before the Honorable Supreme Court on the 6th, lordship, the 6th of April.
Mhm.
So, lordship, interestingly, the NHIDCL has tried to move the SLP yesterday before the Honorable Supreme Court.
Okay.
Lordship, no stay has been granted. Matter was not taken up yesterday. It is to be taken
We'll
up. on
wait for a
first.
few days.
Yes,
Let them
lordship.
try their luck.
Lordship,
Even otherwise, lordship, if my lords may kindly allow me,
Yes, yes.
may I place the SLP copies for your lordship's perusal?
No, we'll not like to comment anything on that. It is their right. Other day, we told them, we are requested them rather to test this order before Supreme Court.
Yes, lordship.
That was the observation.
yeah, Lordship, to be very, I understand what is going on because yesterday I received the communication
Mhm.
from the authority. Copy the-
No, they are absolutely justified. That is a right provided to the citizens. That is a right provided to the authority to approach the Supreme Court. Why
Yeah.
shouldn't they do it?
Now, their apprehension is that by this order,
No, there are lawyers in Delhi. Their services are required. The NHIDCL has got many funds to spare. So that is a part of litigation fund. Let them spend it. Yes.
Your lordship, if my lords may kindly appreciate this fact. Now the steps, subsequent orders leading to order dated 31/3/2023. Lordship, everything is in detail. How it started is by the order dated 14 December 2022, lordship. It was not even the suggestion of this honorable court, but on the suggestion of the learned amicus curiae, my learned senior counsel. On this suggestion, all the parties agreed. There was a consent order passed by this honorable court.
Mr. Counsel,
Yes, Lord.
that letter says it is coming up on first.
Yes, Lordship.
Let us pose this matter 2 days later. Let us see what the fate of the order is
Lordship.
in the SLP. Then we'll consider. Huh?
I anticipate your lordship. I anticipate what is coming. But what I make it out, my lord, I having a talk with the GM.
Mm.
What I can get a feeling, my lord, that's just off the record I'm saying. There is a view in Delhi, your lordship, though Delhi is not that far, but it is far.
Mm.
What I feel that there is an apprehension that by this order,
Mm.
by taking of this order, there may be certain circumstances in certain other parts of the country.
Precedents.
Precedent.
How this can form a precedent?
Ah.
Kohima Dimapur highway cannot exist anywhere else in the country. There cannot be a similar situation which is being faced in this highway. Right? Okay. In another matter, you are arguing after this.
Yes.
Again, a similar situation, but again, the same area. You know,
Yes, my lord, that is
calling for subscriptions from the contractors building highways, calling obstructions.
my lord.
These are things typical to this
Part.
landscape.
Yes,
This can't be cited as a precedent anywhere else.
my lord.
And we have made things very clear in the order. Let the order be tested. Doesn't matter. We'll just give them a few days breathing space.
Lordship,
And whatever time limit we have given in this order, we'll extend accordingly.
if not, your lordships, I wanted to read just one short paragraph from order dated 14/12.
Yeah, please, your lordship.
Yes.
Yeah, please,
Yes.
Lord.
Yes,
Lordship,
please.
we can continue with package 1 and 2. Because lordship,
Package 1 and 2, nobody is stopped. Package 1 and 2 have to continue.
but no, my lord. The point is, my lord,
Package
last,
1 and 2 contractor is not here, my lord.
that is the issue. Last three
Yeah, but
repeated,
package 1 and 2 also is held up or what?
No, it's not held up.
Then?
They are supposed to execute the work and give a certificate. They are supposed to complete the work by 15th of January 2023. Till
Why,
now-
if they have not done it, then it is for the NHIDCL to take the action.
My lord,
What have you done?
my lord, this was supposed to be monitored by the code because this.
So where is are the council representing the that contractor there in the,
I have not seen today also. That's why I pointed out in the last occasion.
yes, who are the council? Who is the council representing?
Mr. Michael.
From
From he
Kohima,
my lord.
lordship, last three occasions,
Delhi, my lord, Delhi.
Delhi.
lordship,
Alright,
last two,
we can require the director or whosoever there is of the contractor to be here in the court.
My lord, let it be on next week. They let them.
We will do that. Okay.
Personal appearance, my lord. Let them.
Who would the man be? Who would the person be?
My lord, it will be MD.
MD of
MD of
which
Ram-
firm? What is the name of the firm?
Ramkey ECI.
Give it in writing.
My lord.
respondent number 8, lordship.
Respondent number 8. All right. Mr. Burgoyne has placed on record copy of the communication dated 25th April 2023 issued by the General Manager NHIDCL indicating that SLP has been preferred by the corporation against the order dated 31st March 2023. And the matter is likely to come up before Honorable Supreme Court on 1st May 2023. This court is further apprised that the respondent number 8 has till date, despite assurances given in the court, not concluded the work on packages number 1 and 2.
My lord, 1 and 2.
Nobody is appearing on behalf of such respondent for the last few dates of hearing. Thus, we hereby direct that the managing director of firm, the respondent number firm so and so shall be intimated by email.
My lord.
The email address is available
My lord. Email
To-
address is available, sir.
to remain personally present in the court on the next date.
Your lordship.
This is the court, your lordship. I am
Can I
bit Mangarura, your honor.
Yes.
come in after some time, please? I want to make one.
Just 1 second, it will take, brother. Okay, all right. You want to address the court first?
Yes, Mr. Burgoyne.
My lord, there is an anxiety on the part of the GM, and I find that he is a bit right in that respect.
Mhm.
Your lordship can kindly come to the order of 31 March 2023.
Yes.
My lord, at page 8, my lord, I after this order came, I heard it, but I did not wanted to file a review on this issue.
Okay, what is it?
That thing what he is highlighting is that there seems to be no possibility of completion of the highway in the near future as per the words of GM Mr. Batra. That,
No, we took his assurance that can you give us a guarantee that it will be completed?
my lord,
So it is in reference to that.
my lord.
You file your review if you want to say, we'll then hold him responsible. He made that statement in the court, Mr. Burgoyne.
My lord.
We are very serious on this. That we put a pertinent query, if you remember.
I remember,
They will be all a part of the recordings.
my lord.
You want
Yes,
us to
yeah,
replay that?
I know that, my lord.
Then don't go on that, don't traverse on that path. It is only after taking all kinds of inputs that we pass this order.
My lord.
Don't question our wisdom on that, please.
That's why I was hesitant to go for review also. my
No.
lord. I know what will be the
File a
consequence.
review. We file a review and then we'll see.
The consequences I am aware, my lord.
Yes. Yes.
May it pleases the court,
Yes,
your
Mr.
lordship.
Arora.
Much obliged, your lordship. Your lordship, I appear for respondent number 12. Your Honor, just indicating to your lordship that on the last occasion, a request was made to your lordship to deem-plead us as respondents. However, when your lordship's order came in, unfortunately, we were not deemed-pleaded in the order, your
We'll do that.
lordship.
We'll do that today. We'll do that.
One
In view
more
of the
request, your
fact
lordship.
that the respondent
There's
number
one more-
12 contract, the contract pertaining to the respondent number 12 stands cancelled. Comma, its name shall be deleted from the array of parties. And
Most
there shall be no requirement to hear such respondent in further proceedings of this PIL.
Most grateful. Your lordship, one more submission I wanted to make, your lordship. Your
Yes.
lordship, by order dated 31/3, your lordship had directed me to file a bank guarantee with NHIDCL. Your lordship, duly by letter dated 19/4, received by them on 24/4, and the mail received by them on 20th/4, 2023.
That you have to do before the arbitrator. That you. have to
They've
do
already, it's
before
already done, your lordship. The only difficulty is they've not released the amount in my favor, as your lordship had directed. Your lordship may kindly direct them to, in a
the-
time-bound
Now,
manner.
why
release
why the
amount
amount
in
is not
my-
released?
We have received their that bank guarantee on 21st of this month,
Yes,
24th
yes,
of this month. So, my lord, as an abundant caution, like a standard operating procedure, we get it verified from the bank.
All
Because
right.
so-
They'll do it, Mr. Arora.
within a week's time, it will be
The
done.
statement of Mr.
No,
Burgoyne.
week's time is fine with me, your lordship. No
All
difficulty.
right.
Just
Okay.
mentioning before the court.
Okay. Re-notify on the so and so shall be required to remain personally present in the court on the next date. Re-notify on 9th May to be taken up at 1:15.
Before my lords conclude, your lordships, if my lords may kindly allow, the authority engineer is an independent authority. On the status of the work, if my lords can.
1 and
let's do
2.
report. The respondent number 10, the authority engineer,
So status of work of package 1 and 2.
all the statuses, lordship. If
Get
some
the status of the
them-
work.
My lord, he is there, authority engineer is here.
He's here
What
in
is,
person,
let us
but-
see, let us ask him right now. Yes.
Please come.
Mm.
Good afternoon, sir.
Yes, correct.
Regarding package 1 and 2, they have requested to provisional completion certificate. As per contract provision, we have issued 28 February 2023. And some balance work, miscellaneous work, I have listed out as a punch list.
Okay, how much of work as per you, what are the bullet points in the punch list?
Only miscellaneous work, some painting, painting or road is totally completed.
Road is functional?
Functional.
Okay.
Only signage, some drainage maintenance. like this.
Try and inform them that they
Yes,
should
already
complete
informed
that.
them, and as per contract provision, 30 days is required. So that
Okay.
30 days also be over. So according to the contract, we penalize this
Okay.
in final bill.
You will penalize them.
Yes.
Tell them, why do you
Yes.
want to face the
Already
penalty?
written 2 times
Written.
regarding slow progress of work.
Okay.
And
very
they are promised to complete by this or maybe 7th May.
All right. So we'll have it on 8th May at 1:15 PM, 9th May.
And
Yes.
also regarding package 3, because we have from November 2016, we have supervised this project. So do big company in a EPC contract has failed.
That proceedings we have seen, that is why this
Yes.
issue has arisen. We'll see after 1st May.
Okay.
Let's see what Mr. Burgoyne gets done.
My lord, when your lordship has fixed the matter on, my lord,
9th May, 1:15.
9th or 8th May, my lord.
9th.
Tuesday, it will be a hearing day, my lord.
How does it matter? We'll take up the matter at 1:15.
My lord.
Yes.
Most grateful, Your Lordship. Most grateful. Most
Yes.
Your Lordship will consider another aspect, that in her writ petition, she has categorically mentioned that father belongs to the general category.
Hmm.
Then again, she has gone to obtain a certificate in father's name as OBC. That Your
Yes.
Lordship first see the environment, page 30.
Yes.
Paragraph 3. ma'am.
Yes.
That it is humbly stated that the petitioner was born on so and so date out of the wedlock of an intercaste marriage between her parents and solemnized her. It is pertinent to state herein that the father of the petitioner, Dr. Santanu Barkati, belongs to general Kalita community, and her mother, Sanso Barkati, belongs to Koch community, which is recognized as an other backward class
Yes.
in the central list of OBC. Now, my lord, having admitted here, and that is the case there, your lordship may kindly come to that certificate. Page 151.
Yes.
This is a caste certificate of the father.
Mm.
All Assam other bachelor's cases association. Caste certificate issued through Santoni Barkati, son of Barkataki. Kiran Barkati.
Issued by whom?
Straight caste, Coach Rajbangshi.
Who has filed this certificate? You have filed it.
No.
Yes.
Yes. That was issued, my lord, on the basis of this next page. In the presence of witness and on the basis of the known facts, it is hereby certified that Santu Barkati late Borwai is currently resides in Jorhat district. His father late
Who has issued it, sir?
Gambura issued this certificate.
Yes, so
And they belong to Koch community, which is a subcaste of people. It is known to us that their family had left so and so Gaon before the year 1953. So, my lord, what was the necessary to get this certificate?
is she bound by the certificate taken by her father?
My lord?
How is the petitioner bound by the certificates which her father may have acquired?
No, she has admitted in her pleadings that father belongs to general.
Sir, why is she bound by the certificate which her father acquires? That is the question. Her father may have acquired whatever certificate he wants.
If that certificate is relevant, then she has.
All right, it is relevant as per you. All right. Argument noted. Very well.
And that was obtained in 2019.
Yes.
After this inquiry was started.
All right.
Now there the case which the learned friend has referred the Ram, where that was a case of single murder. And there it is said to resolve those things that she has to adduce evidence. We do not get a single piece of evidence. Here.
This is the 8th time you are saying so, sir. Now we will not allow repetitions. You can make any number of arguments, but no repetitions, please.
I am not repeating.
You have
that
repeated
only.
this line 8 times. No evidence, no evidence, no evidence. Please conclude your argument in one go. No need to repeat, please. Yes, you may throw files. It doesn't matter at all. Just trying to beat about the bushes, wasting time of the court?
My lord, to put the facts in perspective, my lord.
Yes.
Even going by what my learned friend has argued, if your lordship will kindly come to the impugned judgment, I think one paragraph, my lord, summarizes the whole case.
Page.
If your lordship would kindly come to page 176.
Yes.
Or rather 175, my lord. At this stage, the Mojumdar Learned Additional Advocate General Assam has produced the records before this court,
Oh.
which contains the inquiry report submitted by the Superintendent of Police CID Assam, Guwahati, with regard to OBC certificate of the petitioner. The inquiry report is dated 3/10/2019, made by the Inspector of Police CID Assam.
Yes.
The said inquiry report is also reproduced herein below. In inviting a reference to the subject cited above, I beg to state that I have been directed to conduct inquiry on the contents incorporated in the complaint letter received from the Directorate of Welfare of Plain Tribes and Backward Classes Assam, enclosing 3 different complaints, one of which was submitted by one Sri Biman Hazarika, President of All Assam Koz Rajbangshi Students Union, Jorhat, and 6 others, stating that Monsoon Borkakoti, doctor of so-and-so, other 2 we are not concerned, my lord. So we are concerned with Monsoon Borkakoti. Now I'm reading this subpara. As entrusted, I visited different locations of the alleged person and found the findings which have been presented below. In respect of Srimati Monsoon Borkakoti, I visited her parental address and present address, that is Golaghat at Jorhat. In course of inquiry, it is found that father of the alleged, namely Dr. Santanu Borkakoti, born and brought up at Silpuguri, Guwahati, followed the original rights, that is rights of Kalita community, and got appointment as a medical officer who was posted at Jorhat. The said doctor got married with a lady at Jorhat hailing from OBC community and used to reside at matrimonial house wherein the alleged Miss Monsoon Borkakoti got birth and her mother's house on 12/4/1990. And since then, she started her education at Jorhat and accepted the custom of the Koch community. During 2006, while she was student of class 10, she applied for OBC certificate on the merit of her mother's custom. It is a fact that father of the alleged, though got appointment as MBBS doctor, however, he was not moved for OBC certificate as he was not born to Koch community. It is pertinent to mention here that in respect of issuing OBC certificate, the Honorable Supreme Court of India passed a verdict, that is my Lord Ramesh Bhai's case, on 18th of January, in connection with the appeal. Honorable Supreme Court of India passed the judgment that the child generally belongs to father's caste. However, the child can claim mother's caste also in certain situation, that if the child is born and brought up in the house of her mother, who is hailing from other community, then that of her father. It is a fact that the judgment promulgated not directly related to OBC community. However, the situation incorporated carried the ingredient for which the alleged Monsoon Borkakoti seemed to be entitled for obtaining OBC caste certificate. Moreover, issuing the agency clarified that certificate issued is genuine and issued from their office. The photocopy of the OBC certificate issued by the President, All Assam Other Backward Class Association, Guwahati. Copy of certificate was issued by local Gaonpura, namely Digonto Boro of Sekoni Dhora Gaon, number 3 Town Moja, Jorhat East Revenue Circle. Local Gaonpura certificate issued by Torun Chandra Hazarika, Gaonpura of Betioni, Kakoti Gaon, Moja, Dhekial District, Golaghat, and copy of the judgment passed by the Honorable Supreme Court of India in connection with so and so. As such, it is established that allegation brought against Srimati Monsoon Borkakoti, daughter of Santanu Borkakoti, resident of Club Road, Jorhat, is based on no truth. The complainant perused only the father's caste, but pursued only the father's caste, but did not go through the legal findings of the Honorable Supreme Court of India. My lord, I obtained this certificate in the year 2006 when I was a student of class 10. Had it been my intention to procure a false certificate, my lord, I could have done just on the eve of appearing for the civil service examination. And my lord, that where is the dispute? That my father is a general caste, my mother is a coast. And because I was born and brought up in my mother's custom, therefore, my lord, I have been given this certificate. Now, Lordship knows, Madhuri Patil judgment is a code in itself, as far as my lord determination of caste status.
Right.
If there is any dispute, my lord, it is that committee alone which can look into the matter. Now, in this case, my lord, this honorable learned single judge has said, because of the report of the inquiry officer, the proceedings should not have proceeded any further. Because it is, my lord, the inspector's report which, my lord, propels the inquiry. Because the inquiry report was in my favor, there was no necessity. In fact, the learned additional advocate general who appeared in this case before the learned single judge, he fairly submitted, my lord, that perhaps it's a case which must be given a quietus. Now, my lord, my learned friend is bringing so many issues. How is it relevant? And most importantly, my lord, my learned friend was a respondent in the writ petition. He cannot seek any independent relief in my petition. He can oppose my prayer. How can he, my lord, as an OP, one cannot seek prayer in somebody else's petition. Now he's trying to say, I am NCL, I am this, I am that. Well, look, these are not even the subject matter of issue before the learned single judge. Now, what is wrong in it, my lord? The learned single judge rightly held that since the inquiry report was in favor of the petitioner, therefore there was no occasion for the state level committee to make any adjudication. And that is what learned single judge has held. Now, my lord, if your lordship would kindly have that judgment for a moment, my lord, just one paragraph. Kumari Madhuri Patil, my lord.
Madhuri Patil.
1994 6 SCC 241.
Take note of judgments they have cited, okay? All, there has to be a slip, all judgments cited by the parties. Yes,
My lord will kindly come to page number, my lord, 255, sub-para 5 and 6 and 7
Mm.
of para 13. Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate in the social status claim. The inspector would go to the local place of residence and original place from which the candidate hails and usually reside, or in case of migration to the town or city, the place from which they originally hailed from. The vigilance officer should personally verify and collect all facts of the social status claimed by the candidate or the parent or the guardian as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parent, guardian, or candidates in relation to their caste or such other person who have knowledge of social status of the candidate, and then submit a report to the director together with all particulars as envisaged in the pro forma, in particular of the scheduled tribe relating to their peculiar anthropological and anthological traits, deity, rituals, customs, mode of marriage, date, ceremonies, method of burial, of etc. by the caste or tribe of tribal communities concerned. The director concerned, on receipt of report from the vigilant officer, if he found that the claim of social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue show cause notice, supplying a copy of the report of the vigilance officer to the candidate by registered post with acknowledgement. That means, my lord, once there is a report, then based on the report, a show cause will be issued. Now, please come to sub-para 7, my lord.
yes.
In case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken except where the report or particulars given are procured or found to be false or fraudulently obtained. And in the later event, the same procedure as is envisaged in para 6 to be followed.
Right.
The moment, my lord, vigilance officer gives a favorable report, the exercise is ends. So that is what has been done, my lord. The learned single judge having noticed that the report was in favor of the candidate, there was no further necessity for the issuance of show cause notice and proceeding further. So what is the wrong, my lord? End of the day, my lord, writ of certiorari is not a matter of course. It must cause failure of justice. Therefore, in my humble submission, my lord, in any case, my lord, the earlier day approach.
Can you tell us what was the occasion for you to get a fresh certificate when you were already having a certificate of 2006?
No, I never obtained any fresh. My mother obtained belatedly, my lord. Actually, what happened, my lord?
Why
Both-
this inquiry took place?
Yes, this inquiry took place because this file complaint.
Because of their complaint?
Yes.
All right.
My lord, my mother, when she entered government service, that was as a master worker. It was only in 1993, my lord, that
Yes,
OBC came to be recognized as an OBC. Sorry,
Coke.
host community came to be included in the central list of for the state of Assam.
Okay.
So therefore, when I entered government service as a master roll worker, there was no occasion for me to either identify me as a general or
No,
OBC.
but the muster roll says OBC.
Yes, OBC.
When was,
No, my lord, in 2005, when my lord, the particulars were sent for my lord regularization,
Mhm.
then my lord, normally in office, what happens, they normally ask what you are. Then they said, I belong to Post Rajbangsa, it's not dispute. So
Mhm.
that is why it was given, my lord.
And then,
In 19 years, the mother took the certificate
Where-
in 19,
where is
because
that?
all these things happen.
that inquiry report is on the complaint of the appellant
Yes.
here.
Yes.
Let us see the inquiry report, please. Page.
Yes, yes.
It was not furnished to us, but it's.
My lord, it was not given to us. It is quoted in the writ petition, my lord,
Order, impugn order.
impugn order.
The report was not given to you.
No, my. The records were produced were from my lord, the learned single judges quoted. Page 175 to my lord 179.
This is a case wherein your appointment was cancelled,
Yes, no, I was suspended, my lord.
suspended.
And even now I am under suspension because of pendency of the appeal.
Okay, let's see the report.
Yes, my lord. Page
And where is
175
the impugn order?
of,
Where is the order of suspension?
yes, impugn order of suspension is at page number 77. Lordship may kindly come to third subpara. Whereas the government of Assam Personnel Department wide letter dated 2012-18 requested the Deputy Commissioner Jorhat to cause an inquiry and verify the authenticity, genuineness of the caste of Monsoon Borkakoti. The Deputy Commissioner wide letter dated 8/1/2019 submitted a report of verification done by the Assistant Commissioner, Hartswell Jorhat Revenue Circle with the help of Sarkari Gambura. Whereas Personnel Department wide letter dated 6/8/2019 requested the WPT and BC Department to examine the genuineness of the certificate by the state level committee.
One more question, Mr.
Yes, madam.
As I understand or we understand, there is no reservation as such for OBC unless the category is NCL,
Yes.
right? So how did you get the appointment? Did you get a certificate of OBC NCL?
No.
Then what kind of reservation was provided?
My lord, as an OBC,
OBC doesn't get a reservation
my
separately.
lord, whatever is applicable, that was applied and was given to me. That aspect can be, that is a different, no, I followed what is followed.
That is an important issue,
Yes,
but because only on the strength of OBC, you would not have got a reservation.
unless I belong to
NCL.
non-criminal.
So whether that NCL certificate is there on record anywhere?
No, my lord.
Anyhow, so-
My lord,
Okay.
in the advertisement, perhaps it was not very clearly, anyway, that is a different aspect, my lord. This was never
Naturally.
raised before the single judge.
uh,
Now the issue is, my lord, they doubt.
okay, where is the order whereby your certificate was cancelled? Is that must be on
order,
record?
my lord, yes,
Where is it?
at page 78,
78.
yes.
This order did not take into consideration the interpretation.
My lord, while passing the speaking order, the
Hmm.
inspector's report was not taken note of.
Not even considered.
Yes. Please come to page 82, my lord.
Mm.
First para, in letter dated 5/1/19 addressed to the Assistant Commissioner, Office of the Deputy Commissioner, the Circle Officer, Jorhat Revenue Circle had mentioned that in the context of verifying the authenticity of the caste certificate of Monsoon Borkakoti, he had visited the residence of the incumbent accompanied by Srimati Papori Das, Assistant Commissioner, Office of the Deputy Commissioner, and Gambura. During the process of inquiry, both parents of the incumbent were present, but failed to produce any caste certificate supporting their claim. In the report submitted by the concerned Lat Mandal as well as the government Gambura, so and so, it is very properly reflected that family of the incumbent could not produce any caste certificate supporting their claim. From the records, it is seen that Mother Srimati Monsoon Borkakoti obtained the caste certificate as belonging to Coast community in 2019, which makes it evident that prior to the visit of the inquiry team, Purnima Dr. Borkakoti did not have a OBC class certificate. The visit of the inquiry officer perhaps prompted her to obtain the one.
Mm.
OBC is a collective term adopted by the government to classify caste that are educationally and socially backward. So unlike scheduled caste and scheduled tribe and scheduled caste, where the yardstick for recognizing or identifying a distinct criteria for determining other backward class are social and economic backwardness. In Assam, there is hardly any difference of culture of coast community with that of the culture, custom and tradition of other general communities. Hence, the ground of adoption of custom, religious act and tradition of coast community is not valid criteria for issuance of OBC certificate to non-coast community person. The OBC communities in Assam do not suffer any social disadvantage, rather they're economically backward compared to the general community. But these are all personal views of
This
that.
is the committee formed in accordance with Madhuri Patil.
This is a parallel committee
This is a parallel community, my lord.
by the circle officer.
Just let's see Madhuri Patil. What would be the composition of the committee?
My lord, the portion which I have read, that was by the, that the circle officer who visited, that is there, his view was taken note of. My lord, it will be disastrous to take this view, my lord, that OBC do not suffer from any social and economic. My lord, in fact, the government is representing central government every day to bring them within ST. And my lord, on record, they are writing all this. And kindly see the Madhuri Patil judgment. my lord.
That's what you are.
Yes,
Mm,
para 13.
mm. Para 13.
Subpara 5, which I've read already once, my lord.
Mm.
Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of the police in overall charge and such number of police inspectors to investigate into social status claims.
No, we are talking of scrutiny committee.
Yes,
Which is that committee? Where is it defined? What is the,
yes, yes,
what is the structure of the committee?
yes. Structure of the committee is at my lord, para 4. Para 4, subpara 4.
Subpara 4.
Yes. All state governments shall constitute a committee of 3 officers, namely.
So the speaking order is by that committee?
Yes,
All right, okay. Mm,
as envisaged in subpara 4.
mhm.
No, my lord, as I have already submitted,
Mhm.
this is a code in itself. There's only way to deal with your
So
certificate.
you mean to say that the report of the vigilance officer or the circle officer?
That is the end of the.
That was-
Unless somebody challenges that. Nobody has challenged that, my lord.
And this speaking order doesn't refer to that report?
No. It refers to some in parallel inquiry which was constituted by the office of the deputy commissioner.
Officer.
So my lord, the lordships cannot give judicial imprimatur to an inquiry done by the, conducted by the deputy commissioner, because that's the not the body who is competent to do so. Even my lord, district magistrate is not authorized. It is only the committee. That report of the inquiry officer, that is never disputed by
It
anybody.
is referred to in the order.
Yes, my lord. In
Hmm?
fact, my lord, we are not aware of it. It was only when records were
Okay.
produced before the learned single judge. Then, because my lord, Mr. Majumdar, learned additional advocacy fairly submitted that perhaps there is no further requirement in this case because the report is in favor of the petitioner. That is how, my lord, the learned single judge has passed the order.
And what caused that inquiry? What caused that inquiry to be held by the circle officer? What was the foundation of that inquiry?
Because of the complaint filed by the my lord appellant.
So the state level committee, they did a parallel exercise.
Yes.
And that,
No, my lord, what the state level committee did, they also took note of that report of the parallel inquiry conducted by the office of the deputy.
no, what we are asking is,
My lord.
who
kindly come
authorized
to
the circle officer
Page
to conduct the
70
inquiry?
Page 78, my lord.
Circle officer.
My lord will kindly come to page 78, that gives the actual picture.
Mm,
Whereas a complaint received from Anti-Corruption Liberation Union, that is the appellant,
mm,
alleging that fake and fabricated OBC certificate as host community was
Right.
obtained by Monsoon Borkakoti, whereas she belongs to Kolita.
We are talking of the report which has been relied upon by the learned single bench circle
Yes,
officer.
Yes.
What prompted that report inquiry to be held? What was the basis of that inquiry?
No, eventually, my lord, because of the judgment of the Supreme Court, the matter has to go before the committee. That is how the matter was referred. Because, my lord, to go into the veracity of that certificate, it is only that committee who can go into it, no other authority. That is how the matter was taken to the committee, my lord.
Inspector to the report, down to.
No,
Probably you're not
inspector submitted the report because, my lord, as per para 5, director will depute an officer inspector.
Does the affidavit of the state indicate as to what was the basis of the inquiry conducted by the circle inspector?
Okay. Which is respondent report.
Report submitted by the SP CID Assam.
Yes.
So in what context was that inquiry made? Do we have the original file of the SB? That report must be on the file of the single bench.
My lord, the
In inviting us, I beg to state that I have been directed to conduct the complaint. From director.
My lord, page 175, the report inquiry officer himself says so, my lord. Page 175, last 3 lines. In inviting a reference to the subject cited above, I beg to state that I have been directed to conduct inquiry on the contents incorporated in the
Chaudhary,
complaint
that is-
letter received from
Chaudhary,
directorate.
that is what we are asking.
Yes,
Who directed this inquiry?
director of welfare and plain tribes and backward classes. In terms of para 4 and 5 of the Madhuri Patil mine. Chairman of the committee.
Chairman of the committee.
Yes.
Do you have the records, Mr. Government Counsel? What is referred to in their affidavit?
Yes.
Is there affidavit on record? Let us see. Or this report was just passed across the board?
Across the board. my lord.
Okay.
Across the board.
Okay. And there's no difficulty in taking the report like that. But we just wanted to know the background in
Yes.
which the inquiry was held. Yes. Anything to be said in rejoinder? No? Okay. Arguments heard, order reserved.
Deeply obliged.
Original file. Mahal.
Speaking, this is the speaking order which has been brought because the inquiry by the CID. That has not been referred. That was what the civil bench relied upon. And as per para 5, that is the inquiry. Police report. They have no one to hold a parallel inquiry. They could have passed the order based on that report. Which they don't. That is what they are doing. Because the report is prior in point of time. 90.
Deeply obliged.
Is it available right now?
Right now, not.
You
I can get it.
Pass on the record to the learned court master, please.
Tomorrow I will. put it.
Yes, tomorrow.
Number 25.
Now leave these 2 cases. You can pass them over for the next. Give a date in this.
Yeah,
two.
please, your lordship.
Yes.
Lordship, this matter may be passed over for timing. My senior is lax in
1
point number
week.
6.
1 week, chill. Next.
May I pay for a date which is not
You
in?
can take a date from the court
Lord,
master,
Lord.
whatever date is convenient. 26 is a hearing matter, need not call it now. At 2 we will take that case. Yes. Hearing matters.
Item numbers 29 to 41.
Mr. Mishra, putting the cart before the horse, we want to put a question to Mr. Chaudhary. You have the assistance of your special public prosecutor. In the entire case, as what cursorily we have seen, which is the terrorist act which you are relying upon? Can you tell us, please? That will make the picture clear for us to appreciate the evidence. What precisely is the terrorist act you are relying upon?
Lordship, here is a case where those, of course, DHT has come in later on. Here is a case where the DHT was formed. There were incidents of killing policemen. There were incidents of firing.
We are not hearing arguments on a writ petition. We are hearing the arguments on a criminal appeal.
Lordship.
Whenever you refer to particular incident, there has to be a substantive evidence to support that. In that context, we have put the question to you. Which precisely is the terrorist act which you would be referring to when you oppose the arguments of the defense? Yes, you tell your associate, he can state so.
He was also not there. Well, he was.
Whosoever is briefed with the matter,
Lordship.
anyone, yes.
Yes.
The second question will come later.
Yes,
Yes. Yes.
As I understand, my lord. My lord, these terrorist.
A general story will not serve the purpose you can understand. You are the public prosecutor in the trial court. So we are not weaving stories here. We act on hard evidence. So what precisely is the terrorist act you would be referring to, the prosecution would be referring to when you want the charges to be affirmed?
My lord, they have been continuing the terrorist act all throughout.
Sir, please,
I'm coming to that.
specific act of year 2004, 2005, 2006.
I'm coming to that, my lord.
Yes.
They have been continuing. Now, what has happened? For any organization, you require fund. And that is
Please
why.
forget
one
about
crore-
funds, please.
That is why.
Forget about funds. Right now, you have been asked to answer a simple query.
That is why that one.
Don't go beyond that.
1,4 is the incident, my lord. 1,4.
One,
1,409 is the incident. That is.
recovery of weapon and cash.
My lord, that is.
Does that independently give rise to inference of a terrorist activity
Yeah.
under any statute of this country?
My lord, that is the.
That is an offense under the Arms Act. That may be an offense under the Income Tax Act,
My lord,
or maybe a Hawala transaction.
that is how.
But that is that independently, can that be construed to be a terrorist act? Please give a pointed answer. We'll hear your detailed argument subsequently. Right now, a pointed answer. Which is the terrorist act? Which means we want with reference to date, time, and nature of act.
Carrying of this 1 crore rupees on 1,409.
Read the definition of a terrorist act, please.
That is funding for the purpose of. Funding to consider.
Oh, Rupam, where are the acts? Yesterday, all the acts, photocopies. You may refer to TADA, you may refer to UAPA, whichever act you want to read. What is the terrorist act you are referring to? Section 15. All right. Section 15, read.
15(1).
Yes.
Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security, your lordship may kindly.
Just carry on, sir.
Security, or sovereignty of India, or with intent to strike terror, or with intent to strike terror, or likely to strike terror in the people of, in the people, or any section of people in India or any foreign country.
By. Now there is, this is the general explanation that this should be the objective of the act. Okay. And now what are the acts? They are categorized in A, B, C. Read of from which of these clauses you want to cover these accused.
By using bomb, dynamite, or other explosive substance, or internal substance, or firebomb, or other lethal weapons, or poisonous or noxious gas, or other chemical, or any other substance, wherever allocated so and so, death or injuries to any other person, loss or damage, or to destruction of property, disruption of any supplies or service essential to life of the community of India or any foreign country, damage to the monetary stability of India by way of production or smuggling or circulating of high quality counterfeit Indian paper currency, coin, or any other materials, or damage or destruction of any property in India or in any foreign country used or intended to be used for the defense of India or in connection with any other purpose for the government of India
You are-
or any state. Overall, by means of criminal force or by show of criminal force or attempt to do so or cause of death of any public functionary or attempt to cause death of any public functionary. Your Lordship, kindly mark B.
B, yes, yes.
Detailed kidnap or abduct of any person and threatens to kill or injure such persons or does any other act in order to compel or the government of India, any state government or foreign country, so and so organization to obtain. Now,
Yes,
Your Lordship, overall.
a public functionary by use of force. This is the only act you will be referring to, right?
Yeah.
You're meaning thereby PW 29, whom they forced to resign from the post of the Hill Council chairperson. That is the terrorist act, none other.
That is a terrorist act and but connected together, you also will find that the fund has been transferred, collected and. These
Sir,
are all
transfer of funds is a different charge. It's a different charge. It may be money laundering, whatever you want to say. But terrorist act, you have got qualifications in A, B, and C, right? So from amongst A, B, and C, for defining the terrorist act, you will be referring to clause B. Okay? In this, there is nothing of the sort that economic transactions, underhand economic transactions are also construed to be terrorist acts. You refer to economic activity right now. That is not there in the unamended definition. You are having act of which year? We'll be referring to the UAPA 1967, Mr. Mishra.
My lord, 2013 edition.
2013
I
edition.
My lord, print out to your lordship, 13 edition.
The Corona Act, Corona Act, no?
2000, because this relates to.
This one, this is it, yes. So you are referring to which definition, sir? In which year?
I think it's to be of 2013. That is, wait a minute, 2013, no.
No, which edition?
It should be.
It will be on the top of the book. Just turn over, front page.
2008 and 9. Madam.
You can pass on the,
2008 and 9, madam.
Mr. Saab, you can pass on the 2013 edition to him.
Yes, Lord, I'll.
8 and 9.
Yes, read the definition of 15 from here.
13, 213, okay. Okay, more corona than I know.
That is 20. The incident has happened in 2009.
More fun, I hear it, madam. Yeah. Yes, the B, mother, yeah. Overall by means of criminal force, also criminal force.
So in this provision, there is no such word like economic activity. Economic activity is referred to transfer of funds in section 11, which is unlawful association.
B is there, madam, overall by means of criminal.
Yes, so that's what we are saying, that this is the only alleged terrorist act you will be referring to.
I'll be referring to. Yes, madam.
Making the elected representative to resign under gunpoint, as per you. So, okay, so now we'll proceed accordingly.
My lord,
Lordship had asked regarding my appointment.
Yes, yes, let's see. Because, Mr. Chaudhary, when we mark in your attendance, it will have to be as a special public prosecutor. Yes, as deemed public prosecutor. That's what we wanted clarity. So now in order sheet also, you would refer as public prosecutor NIA. Public prosecutor NIA.
Well, your lordship asked us to prepare a chart. I don't know whether it is
Please.
what your lordship wanted. But, why have we given? I'll not give you, I'll give him.
Deputy SGI and public prosecutor, come public prosecutor.
My lord, the first one is chart showing date of
Paragraphs
arrest.
of the judgment discussion.
Yes.
This will,
And then, my lord,
this will make life easier for us.
Yeah, that, and I'm happy, my lord. We have made it.
This is released on bail status. During trial, they were released on bail.
Yes.
Hojendra and Babu.
Yes. Yes.
Okay. Mohit Ojai continues to be in jail.
Yes, my lord.
And Joel Garlosa
And Niranjan Hojai.
and Niranjan Hojai.
3 persons are still in jail. They were given life.
Okay.
Others were all granted bail.
Okay. All right.
My lord, on the question that has come from your lordship, because yesterday I was harping on it, that there is no terrorist act. It's a generalized submission.
Story kind of thing, yes.
Yes. Now, on that, my lord, your lordship can have the statement of the chief investigating
Yes,
officer.
that we feel that two things are very important
Yes.
in this case. One
Volume
is the
4.
charge sheet and the statement of the
Yes.
IU.
Volume 4.
Page,
Volume 4.
volume 4.
Yes. Page.
But there is one paper book of relevant evidences. Can we find it in that?
That we don't have.
PW
PW 150.
115.
150.
150. Probably it will be there in this. Any request? Mukesh Singh.
My lord, if you.
Mukesh Singh.
Yes, my lord.
Yes.
Your lordship may come.
There's a compilation.
Yes.
We don't know who has given it, but there's a compilation. You can have a look at it. That's only relevant.
My lord, that may be given, my lord, junior says we have given at the time of bail,
Maybe, yes.
bail hearing. Is the same thing?
All right, we'll refer it.
This we have.
We'll refer it.
My lord, your lordship may kindly come to 785. Page 785 of Mukesh Singh. It starts, my lord, at 757.
Yes, 785.
757 and relevant is 785. Mukesh Singh.
Yes.
Your lordship will come to 785, the last but one para. I do not have any, my lord got it. I do not have any personal knowledge that prosecution has filed any petition regarding threat to any witness. In this case, no arms were recovered from accused Joel Garlosa or A. Warisa. In this connection, no expert evidence concerning fingerprints of Joel Garlosa and A. Warisa was received. Now, your lordship, this is important. It is a fact that I have not investigated any violent incident committed by DHDJ in connection of this case. There is a clear. And it is incorrect to state that there is no ingredient that is different. He
That
has
is an
not-
opinion. You are taking opinion of the witness. It was not.
He has not investigated.
That's true.
The other, of course.
There is only a single investigating officer. Only one.
The other one I'm referring to.
Okay.
There is another one who.
PW 149.
149 at page
719.
719. my lord.
Paper book.
Paper book 3. I'm sorry.
Paper book 3. Seven 119.
The relevant is at page 750. 750. my lord.
Yes.
the last 5 lines
Mhm.
in NIA case number 1 of 2009, that's the present case your lordship is having.
Mhm.
Fourth
Yes.
line, my lord, from the bottom. And 2109, there was no act of killing or other terrorist activity under the meaning of section 15 of the UAP Act.
Mhm.
And then others of course. So admittedly, the only act which my learned friend has somehow referred is overrowing.
Overrowing.
But if your lordship will see the opening lines of section 15, that is missing. Because it is not for money. It has to be for something else.
Right.
And that is, of course, my learned friend will show. And I will also, my lord, specifically, I will also refer to the judgment on terrorist act, but I will do it that at last.
Yes.
Uh,
No, you do it at your own convenience.
Now, just terrorist act, if your lordship will see, section 15 at page 10 of the my lord, printout that I have given. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India and in foreign country, then those acts will come. Now here I'll take your lordship to the evidence to show there is absolutely nothing on record in the evidence which could show that there was any intention of that. Rather, the investigation says as if I am part of DHDJ and together we have misappropriated all the money, allegedly for procuring arm and supplying.
And amongst all the witnesses, who has given an idea about the activities, idea which is acceptable in evidence about the activities of DHDJ?
My lord, no one. There are 2 witnesses.
Approver.
Approver says my lord, your lordship will be surprised. His confessional statement is exculpatory. His statement as approver in the court is exculpatory.
Okay.
Your lordship knows approver is partner in crime.
Partner in crime.
He's a
Unless
guilt
he confesses
associate.
to the crime,
Unless he confesses,
his evidence would not be accepted.
would not be accepted. Plus, there is no corroboration. Now, though section 133 of the Evidence Act says that his evidence will be admissible.
But corroboration is generally sought for.
My lord, section 14 of the Evidence Act, E, which says, my lord, that he is an unreliable witness unless there is corroboration. And there are so many Supreme Court decisions on the point. I have brought 1 or 2 which I'll be referring. Now, my lord, one more thing on this point only when I'm there. If your lordship will have exhibit paper book 5. I was referring to it in my argument yesterday. Exhibit 271 and 272.
Yes.
Exhibit. Lord, page 1212. Your lordship will find exhibit 272.
Yes.
This is a letter which is addressed to Inspector General of Police CID, Assam. With reference to subject cited above, I have the honor to submit the required information along with certified copies of the FIR of the cases registered in NC Hills district in connection with the weapon of security forces being snatched after being attacked. A copy of the list of weapons deposited by surrendered DHD cadres are also enclosed. Now, your lordship will see these are the incidents, some of which have been referred by them. And these are, the first one is, my lord, 11/6/2004. This is Umrangso PS case number so and so.
Yes.
The second one, extremists enter so and so and killed 2 number of guards. This is also Umrangso PS case number so and so. So all are different. I was saying, my lord, yesterday I submitted that all are different. Investigation was done, and I don't know what the stage of trial and who have been cited. My lord,
Well, it's not their case that any of the accused arraigned here are also facing trial in those
my lord,
cases.
accused 1 and 3 am appearing. No.
The other accused, any
Other
statement?
accused,
One case, I appeared on behalf of Jwel Ganusa.
Hmm.
He's been discharged in one of the cases.
Anyhow, the prosecution would have to say that any of these accused who are here in appeal, they were also arraigned in any of these incidents.
that they should.
That is on the,
Yes, and of course,
okay, very well. 17, you are referring to two documents.
two documents. One is the letter, because they have got it from the district, my lord, that what are the cases which are pending?
Antecedent
Arrest
report
act.
kind of thing, yes.
And then they are now referring that these are the things which we have committed.
Hmm.
And your lordship, one more thing, if your lordship will see, nowhere it is mentioned that which extremist group.
Yes.
It only says extremist group.
Hmm, hmm.
And somewhere it says unidentified.
Unknown
Yes.
extremist,
Unless-
ambush,
Yes.
extremist group. Okay.
Because, my lord, admittedly, I will show from the evidence when I go specifically to this.
Mhm.
The evidence which shows that there are 5 or 6 insurgent groups
Which were
active in
functionally
the
active
area.
in that area.
Yes,
Okay. Hmm. Okay, please carry on.
now, my lord, with your lordship's permission, I will just recap what I argued with
Mhm.
very shortly. My lord, I submitted before your lordship that the
Rajiv,
appellant number
Take note of
one,
the arguments. Yes.
appellant number 1 is a first-class contractor of the NC Hills
Mhm.
Autonomous Council. Accused number 3 is a politician. He was elected as member of the NC Hills Autonomous Council in the year 1996. Then again, he was elected in 2007. He is a politician. He has nothing to do with the extremist element or any connection with the extremist.
All right.
Now, on 1st of April 2009, accused number 1 and accused number 2, it is alleged that they were proceeding towards Shillong. They were intercepted on a specific intelligence input, and their vehicles were searched, and 1 crore rupees was found, and 2 pistols were found. Their mobile, everything was seized on the spot.
Mhm.
That PW10, who is the informant,
Caesar officer.
says that. Now, charges were framed on 4th of August 2012
Hmm.
against all the accused persons, and all the accused persons, it is alleged that they are member of DHBJ
Yes.
without there being any iota of evidence.
Okay.
Now, my lord, paragraph 12 of the judgment, yesterday I could not refer,
Mhm.
where I have been submitting before your lordship that the purpose of the conspiracy was to wage war against the state.
Uh-huh.
That portion only, if your lordship permit me, I will show from paragraph 12 of the judgment, which my lord will find one minute. I'll just.
Yes, please.
My lord, internal page 24. My lord, in your lordship's appeal memo itself,
We are
the judgment
having
is
the
on the
judgment.
top.
We are having the judgment, yes.
Yes.
Page 12.
Page
Para 12.
24.
Yes.
Para 12. Here in this case, it is submitted by the learned public prosecutor NIA that conspiracy was hatched for waging war against the state.
Mhm.
And in furtherance of the said conspiracy, so and so was done.
Hmm.
So this was waging war, and yesterday I have submitted before your lordship that they were acquitted under section 121 and
121.
121A. And that I refer to page 281 of the judgment,
Right.
paragraph 451
Okay.
of the judgment.
Mhm.
Now, I also submitted before your lordship that once the accused, the appellant was acquitted of the charge that he conspired to wage
War against the country.
he has again been brought in under section 120B to say that you have conspired to wage war against the country.
Mm, mm, mm.
So in the first
So the
place,
substantive evidence, he has been acquitted, substantive offense, he has been acquitted, but then by ambit of conspiracy, by,
yes, that's
Yes,
a
ma'am.
general law, your lordship, when there is a special law, a general law will not prevail. That's a settled position.
because 121 and 121A,
Yes.
even they take care of the act and the conspiracy both.
Absolutely. Even attempt, my lord.
Attempt.
Yes.
Yes.
Even attempt, it takes care. And my lord, learned trial court has compared 120B with section 18 of the UAP Act. And he said both are similar. That I will come to that.
Yes.
Because in Nalini's versus State, 1999, Tada case, and my lord, some of the sections, as your lordship said yesterday, it was brought in from Tada. So section 3.3 is now section 20 of the UAP Act.
UAP Act.
And while dealing with 3.3, the Honorable Supreme Court held that unless there is a terrorist act, she may be, what crime she has committed may constitute offense under some other act.
Penal code.
As your lordship said in the beginning, but not under UAP Act.
No, that is just a general kind of observation.
No,
You
but
don't hold us to
that's
that.
what Supreme Court said in 1993, my lord.
Don't hold us to that observation. It's subject to correction.
No.
Still, we have not heard the
My
other
lord,
side.
it has, when we read something, and from nowhere, your lordship says the same thing.
It's
The
just
feeling is human being.
Just a perception, sir, just a perception.
Yes, but then the feeling comes that yes, whatever we have read is also
Right.
read by this. Now, my lord, then I referred to, my lord, each of the charges which is preceded by a sentence, you after forming
DSDJ.
And I referred 3 witnesses on it. PW 46,
PW 46,
PW 120, PW 150. My lord, after I finish my argument, I'll give a chart like this and I will say whatever I had said in one line.
Yes.
And
None of these witnesses substantiate this allegation
no,
that the accused was a part of DHJ.
no. No, that would don't say, because my lord, 46 was a DHD members who joined in 1995.
95.
Then similarly, 129 also, same thing, 1995 DHDJ. And 150 is Mukesh Singh, the chief investigating officer. He has narrated who formed DHDJ, where none of the accused, except few ones, have been mentioned. I have read it out here. Now, my lord, even the charge sheet, this I could not place yesterday. Even the charge sheet do not stipulate that I was accused number 1 or 3 from the DHDJ. Even the charge sheet. If my lord will take volume 9 of the paper book, not exhibit, paper book,
Volume 9.
as page 2217.
Here, luckily, there is a set of arguments advanced by Senior Advocate Sri D.K. Mishra on 18-221, 2-3-21, 4-3-21 and 10.
I was asked to give date wise, so I had given, but then after that, I had a consolidated one also.
Okay.
That I could not give.
Yes, all right. Charge sheet.
Now,
Page.
charge sheet, my lord will kindly come to 2217, paragraph 17.1.
Yes.
Dima Halim Dauga is a splinter group of the former armed insurgent group of Assam called Dimasa National Security Force, which had surrendered en masse in 1995. Except for its self-styled commander-in-chief, so-and-so, subsequently said so-and-so launched DHD, it declared objective to create a separate state of Dimaraj for Dimasa tribe, comprising Dimasa dominated area of North Kachar Hills and Karbi Anglong district of Assam and part of Dimapur district, Nagaland. Pradab Nunisa, who rose to become commander-in-chief of DHD and the head of the outfit armed wing, Dimasa National Army, took over the command of DHDJ by ousting the president, accused so-and-so in charge, on charge of anti-DHD activity. DHD headed by Nunisa forced a ceasefire with the government in year 2003 and surrendered. Sri so-and-so, however, had gone ahead and formed a separate outfit on March 31st, 2003, which according to him was official DHTJ, militant belonging to Hamar People Convention. Democrats abducted 23 Dimasa tribal men from the two villages within Sonai police station limit in Kachhar district after torching about 450 dwelling houses should have been on 31st March 2003 and later killed all of them. All those killed, 17 men had families, and these 17 widows themselves called themselves Black Widows and vouched to take revenge on Hamar. DHD so-and-so faction also adopted the name Black Widow and stepped up their act of violence and terror, mainly in Kachhar, NC Hill, and Nagaon district of Assam. It is also a strong presence in so-and-so. Not a single word about accused number
1 and 3.
and 3 or any other accused person.
Other than Joel Carlosa.
Yes.
Yes.
Now, my lord, thereafter I placed, my lord, the allegation that pursuant to this conspiracy, what act was done.
Para 17 of the charge sheet. Yes. Yes, please. Carry on.
Now, my lord, the allegation is after conspiring, the following acts were done by the accused. The first one was overhaul the elected CEM that I have placed before your lordship. I also submitted that 9 witnesses were examined by the prosecution, out of which 8 were declared hostile.
One was not declared hostile.
He also did not support.
Did not support.
He corroborated the other hostile witnesses. And then what was done was 161 statement was put to the IU. It was brought on record, recorded, and it was proved. It to be proved. In these connections, there are 7-8 paragraphs, which I will of course write. I can say on this paragraph is 156
of the judgment.
Of the judgment. 156 is. I have already placed it before your lordship.
You already
I'll just give the number. If he's writing, he can write 156, 282, 282-1, 284, 285, 287, 288, 289, 290, 291, 442, 443, and 446. Same 161 statement was placed. 444 and 446, not 443. I'm sorry if I said that. Now, the trial court discussed these hostile witnesses and referred to 3 judgments which your lordship summed up. That Hardhan Das, V.K. Mishra, and Tahsildar Singh, it is quoted there. So that those paragraphs are 292. Discussion by the trial court was paragraph 292.
Evidence of hostile witnesses.
Yes.
Yes.
292 to 292 Roman 2. And then 3 decisions were discussed. Now coming to today, I'll begin with the second act.
Right.
Now, second one was that we have siphoned off the council fund, and I have submitted that this is subject matter of PBI investigation. I have shown from the chart sheet at page 2232, the last paragraph. Then today I will go to the third allegation that accused number 3, Mohit Hojai, who was the chief executive member of NC Hills Autonomous Council, sent money to Kolkata, large sum of money to Calcutta, with the help of PW 35, PW 106, and PW 21. This is stated in paragraph 17.29 and 17.3. I have already placed before.
Of the chart sheet.
Yes, of the chart sheet. I have already placed. Now I'll place the evidence.
Sure.
The substantive evidence. Obviously has to be recorded in the court. And my lord, your lordship will take up evidence volume 2, paper book, not exhibit.
Would it be a part of this paper book of relevant evidence.
My lord, what I can, I.
Maybe the, if the index is given, we can find it out.
Yeah.
You are
What
referring to
I will do-
PW?
What I'll do, my lord, this was given by us, if your lordship gives us, we will now what do? We will make another one relevant.
No,
so
no.
that Your lordship will
Probably
not have to,
there are 3 sets or 2 sets only.
no, but then it was.
You
only-
will not have the corresponding document
No,
with you.
no, not, I'm not saying that. I'm saying it, this was meant only for bail. Now we'll make another one. after
No, no,
saying
but
this.
Mr. Mishra, the thing is that we don't have to take out volume 1, part 2,
That
volume
is
1.
why I'm saying.
So if this paper book is with you, you can refer to the statement, name of the witness,
Yes.
PW.
Yes.
We'll find it out from the index.
Definitely it will be there, my lord.
PW.
I think we will have, my lord. Your lordship will have Imdad Ali at page 669.
69, yes.
Imdad Ali.
So that makes life a lot more easier rather than
Yes,
fishing through so many files.
yes, my lord.
Page 69.
I think
It's in a print.
we must have, I think, when,
Only index.
you give me the index, so we'll refer from here.
Imdad Ali.
Yes. Now, my lord, what I propose to do, subject to what your lordship says. I propose
What
to-
you do is, listen, you pass that paper book back to us. You read from your own paper books. We'll read from this. Statements are one and the same. We'll find out. You just refer to PW so and so. Okay.
But
You can give the relevant statements to us. Yes.
that's what that's what I'm saying.
You
that,
carry on right now.
Whatever
please.
I'm arguing, whatever evidence PW's and I'll make a separate paper.
Already there, you need not repeat. You can have a copy of this one.
We may,
You can just get an index, copy of the index.
we
and then-
may have this, my lord, there in the chamber, we may have
Right.
this.
Okay, okay.
Because,
Yeah, so read, all right.
my lord, your lordship will, but
69 from this. Yes. Imdad Ali.
yeah,
Numbered in print. Yes.
well, what I propose to do, I propose to take your lordship through the relevant portion of this, and thereafter I will place the whole.
Sure,
evidence.
sure, please.
Now, my lord will come to internal page 2, 3, 2. Internal page 3, my lord.
Of this witness. Yes.
My lord, fourth paragraph, if your lordship will see.
My brother Ibrahim in the year 2008.
Yes.
Yes.
In the year 2008, my father had cancer. In the year 2009, I underwent a treatment at Tejpur Mental Hospital. Tejpur Mental Hospital for about 2 to 3 months.
Yes.
I was under medication from the said hospital. I will be able to inform the court as to what medication I was in after I took my prescription, which is at my home. I had clandestinely taken the medicine due to embarrassment. I also underwent treatment for depression in Guwahati at Panjabari Mental Hospital during the same period as in the year 2009 to 2010. I underwent treatment at Panjabari Mental Hospital and continue to have medication. I still have medication for depression till date. I underwent depression because of the NIA inquiry in the present case and various other personal reasons. It is correct that when I was taken to magistrate to record my statement under 164 CRPC, I was taken by one Mr. Thakur. He is an investigating officer, my lord. Mr. Thakur of NIA was present during the period of my giving a statement, volunteered to say that he was outside. It is correct that I was asked to give this type of a statement by Mr. Thakur of NIA. It is correct that I was threatened to be handcuffed by NIA if I did not give such a statement. Now, two things comes out from here. One is this person is a mentally sick person. He was in the hospital twice. One was Tejpur, other was Panjabari. He was under depression And he was put into more depression and threatened to make the statement.
Mm.
And accordingly, he made a statement under 164(5).
Mm.
A witness's statement. Now, my lord will the allegation is, now I come, my lord, to page 1.
Of
Page 1 of the same witness.
witness, yes.
In NC Hills, from year 1994 to 1999.
I was in NCLs.
I was in NC Hills from 94 to 99. I was a contractor in PWD and I had worked for construction of road, bridges, building, etc. From 1996 to 2000, Prasanto Varisha was CEM of NC North Kachar Hill Autonomous Council. Thereafter, Punandu Langthasa became CEM from 2001 to 2006. From 2007 to 2008, Deepolal Hojai was CEM. For my construction work, I have received payment, but small amount remained with the council, which I could not recover. When I was in NC Hills, I came to know Jayanto Kumar Ghosh. He is accused number 12, who is known as Dhruvo Ghosh. He has a hotel at Lower Haflong railway station, and he had business of railway catering business. Since then, I came to know J.K. Ghosh. I became friendly with him. In 2008, I carried a sum of rupees 15 lakh from Guwahati to Calcutta to be given to Jayanto Ghosh. And accordingly, I gave this amount to J.K. Ghosh. The amount of money was carried by J.K. Ghosh and he has given it to somebody, I do not know. And I was along with him, but I was in the car. Then I returned to Guwahati. In 2009, Deepolal Hojai resigned as CEM. And Mohit Hojai became CEM. This is important, because he alleged that I rang him up and said, do you know somebody who can send the money to Calcutta? In 2009, Deepolal Hojai resigned as CEM and Mohit Hojai became CEM. Mohit Hojai rang me up and told me he wants to send some heavy amount of money to Jayanto Ghosh at Calcutta, whether I could help him in sending the money. He also told me that the money was sent through Marwari. And whether I know the procedure. As I was in my village at Hojai, I told him that I do not know any such person who could help him in sending money from Guwahati to Calcutta. After about some days, I happened to meet one Didar Ahmed Chaudhary, who is known to me, and he told me that Mohit Hojai has taken his help in sending 80 lakhs. Now, Didar Ahmed Chaudhary was not examined. So this is hearsay. In later part of 2009, Mohit Hojai again telephoned me and told me that he was to send some money to Calcutta. I told him I'm in Delhi in hospital. As such, I'll not be in a position to help him in sending money. I have given my statement before police, NIA, regarding above incident. I also given my statement before SDJM Kamrup Guwahati, and the same was recorded by the magistrate. Today, I have seen my statement made before the magistrate. Exhibit 97 is the said 164 KRPC statement. So-and-so are my signature in the 164 statement. Exhibit 98 is the check amounting to 20 lakhs, which I had given to J.K. Ghosh, and so signature was also given to, Exhibit 90 rupees so-and-so was given to J.K. Ghosh, etc. Both these amounts were withdrawn by J.K. Ghosh, and demand draft was made by depositing at Indian Railway Catering and Tourism Corporation. I do not know whole amount was used for making demand. Exhibit 100 is the statement of SBI, Commercial Branch Ganesh Gudi, where different transactions are respected. Now, these transactions are not certified copy, and these are at page 2.
Basically, what you would argue is that the witness, so far as Mohit Hojai is concerned, he only says that Mohit Hojai made about attempts to send the money. That's all.
That's all. And my lord, one more thing which I would
to propositions rather.
My lord.
Not even attempts, propositions.
My lord.
All right.
And another thing I would, my lord, CEM is head of that autonomous council. Under, if your lordship will see, under section, under paragraph 3 of the 6th schedule, the council has legislative power. My lord, have constitution for a minute.
Yeah, Constitution of India.
He is, my lord, not a very big man, but yes, for the area, he is the head.
He is the head, right?
He's, people say he's like chief minister, but yes,
In
he's head,
Schedule
he has all the
6.
powers.
Schedule 6.
Now, schedule 6, if my lord will come to. Schedule 6. Schedule 6, your lordship will see. Power of the district council and regional councils to make law. 3.
3, yes.
The regional council for an autonomous region in respect of all areas within such region and district council for autonomous district in respect of all these areas with district except those which are under the authority of regional council, if any, with.
As good as a legislative assembly.
Yes.
For that
My lord,
district.
Yes, my lord, it's a small area. He may know everyone, but it's not that the CM will ring up an unknown person. There is not a whisper that he was a friend of him.
There was acquaintance from before, there is nothing. And furthermore, of course, that is subject to your cross-examination. How Mohit Ojai would know that this Imdad Ali is friendly to Jayant Kumar Ghosh? That would be probably your argument. That he would approach Imdad Ali to get the money transfer to Jayant Kumar Ghosh.
Well, he says, I know him, and they both were contractor, he says. And the money that he has given is gone for an Indian catering.
IRCTC.
Yeah. So therefore, my lord, there is nothing in the statement of exhibit of PW.
What is your cross-examination on this aspect? Or you didn't bother to do that?
Cross-examination, this part is very, very bad. But some of course, something has definitely come up. A few I will refer also. 2 I have already referred, my lord, at internal page 3. Internal page 3, 2 I referred in the beginning.
He was ill and medication. Not that. Regarding his statement,
then
how do you question that statement that Mohit Ojai approached him to transfer money? Because maybe the prosecution would rely upon that. What is the cross-examination on that?
Now, about the money which bank transaction, he says, my lord, that will, I admit, my lord, I have not found anything. There is a suggestions only, and that suggestion is at page 4.
Just a confrontation that what you said in chief is a false statement. That's all.
Yes. That's the
as perfunctory as the cross could be.
Yes. But my lord, what I'm
the witness could have been strung to the line.
My lord, I can, my lord, tell, thanks to Mr. Bhora Gohai, those things which I have shown has come up in cross-examination. That there were no terrorist act. It is he who brought it when he appeared before the trial court. Otherwise, this witness could have been, my lord, shredded and
Yes, he could have just torn apart.
All said and done, my lord.
Very
The
well.
onus
Anyhow.
remains. And he doesn't say that Mohit Ojai has given him money.
Has given him money. It's only even if you consider the statement to be truthful on the face of the record,
Yes.
it is nothing beyond an attempt to transfer money.
Yes.
Not even an attempt, a preparation.
Yes.
Yes.
So he said, and another thing, my lord, the NIA has collected all data record of all the persons. But he has not, he says he was in touch with Mohit Ojai. You have Mohit Ojai phone number.
CDRs at that point of time, they did not have 65B. Trial court has not relied upon those.
My lord, they have, 65B had come. Had come in.
We were reading through the
But
judgment.
there were no certificate.
That's what we are saying. The trial court has discarded.
Yes.
Trial court has discarded.
Has discarded. My lord, trial court has discarded. And I was telling yesterday, my lord, that here it is discarded. And in the circumstances which has been called out by the learned trial court, it is mentioned. I'll show you.
We'll see. So, all right. Okay.
In the final.
So this is the witness.
This is the
Imdad
star
Ali.
witness.
Imdad Ali.
Yes.
Regarding
Now-
transfer of funds,
Yes.
he is the only witness.
No, there are 2 more,
All right,
which has
please
been relied.
refer to them.
My lord, may I, my lord, refer to paragraph which have been
Of the judgment.
of the judgment about PW 35.
Okay, very well.
PW
Yes.
35. My lord may have at page 55 of your lordship. Paragraph 106.
106. Para 106. Evidence of Imdad Ali dealt by trial court. 106.
The internal is 55, my lord.
We have it.
106 I'm placing. The evidence of PW3 in Dadali reveals that he was working as contractor in NC Hills. From 2007 to 2008, Deepolal was CEM, who resigned in 2009, and Mohit Hojai became CEM. From 2007 to 2008, Deepolal Hojai was CEM. For his construction work, he received payments, but a small amount remained with the council.
That is just a reproduction of the
Yes,
statement.
what he has said.
Where is the conclusion? 1063.
My lord, 1062, your lordship come first.
Yes.
My lord, it will be necessary to read.
Where the trial court
because
refers to
what-
the 164 statement
That has been.
as a substantive evidence.
Absolutely, this is what I wanted to say. Now, my lord, will see section, paragraph 1061. His evidence also revealed that he has given a statement before the magistrate, exhibit 97, is the said one, on 164 statement, so and so, so and so. Now, then my lord will come to 1062.
Yes.
1062. Where it appears from his statement, exhibit 97, that when and then whatever is there in exhibit 9 is roughly mentioned here, my lord. And then 1063 is the finding, my lord.
Right.
It is true that the statement under 164 cannot be read as evidence. It can only be used for the purpose of corroboration or contradictions. Here in this case, exhibit 97 has not lent corroboration to PW 35. But except, however, carrying 15 lakhs to Kolkata, this was in 2008, he says.
So this is the only part of Imdad Ali which has been relied upon by the trial court.
Yes.
To draw a conclusion that he carried rupees 15 lakhs to
Yes.
Kolkata and gave it to Joyant Kumar
January
Ghosh.
2008, we are not concerned.
Got
The
it.
next line is very important.
Hmm.
It lends corroboration to the evidence of PW6, Ravi Agarwal. and
106 and PW 21.
My lord, your lordship, may I kindly have 156(7) of the Evidence Act? 157 of the Evidence Act.
Statement of one unreliable witness.
No, not that. 164 statement will be only used.
Corroborate the maker, only the maker.
Absolutely.
Yeah, that's right. That's right.
157.
Yeah, yes. No, you need not cite this provision.
Now, my lord, there are some, what I supposed to do, my lord, is I'm dealing with this, though therefore the relevant decisions, if I can put at this stage, then I don't have to.
Very
go
well.
to the last.
You argue as per your convenience.
Now,
Yes.
my lord will kindly, first, 2013.
Section 157 of the Evidence Act. Para 1063 of the judgment, impute judgment, section 157.
29. Compilation there. The compilation of judgments are there. Page 29, if my lord will kindly come to.
It's good of you to enrich our knowledge, but if you ever take the trouble of reading my judgments from Rajasthan High Court, I hardly ever refer to any judgments while deciding the appeals.
My lord,
I am of the firm opinion that no two criminal cases are similar on facts. And so far as propositions of law are concerned, these codes are the Bibles, Gita and Quran. They are sufficient to decide everything. Very well.
my lord, page 29. Page 29 is R. Shaji case. Page 30. my lord,
Yes.
citation ko diya na.
2013.
2013-14 SCC, page 266. Paragraph 26, my lord.
Yes.
Just few lines. Evidence given in a court under oath has great sanctity which is why the same is called substantive evidence. Statement under 161 CRPC can be used only for the purpose of contradictions. Section 161 can only be used for contradictions, and a statement under 164 can be used
Both for corroboration and contradiction.
and contradictions. Then I'll come to 28, my lord. Section 157 of the Evidence Act makes it clear that a statement recorded under 164 CRPC can be relied upon for the purpose of corroborating a statement
Of
by
the
witnesses
witness
in the
himself, yes.
Yes. Relied upon for the purpose of corroborating the statement made by witnesses in the committal court or even contradict the same. As defense has no opportunity to cross-examination, of course, facts were different, as you lordship said, there the person was not. But on
The argument is that 164 statement of Imdad Ali cannot be used to corroborate the evidence of other
other
witnesses.
evidence. And there are 2, 3, I need not take your lordships to the others.
No, if you want to enrich our knowledge, you're most welcome.
My lord, your lordship may come to page, what does it say? 143, just a minute, my lord. Procedure 11. This is the last, this will do. Paragraph 11 at page 148, my lord.
148.
148. This is 2004 4 SCC, page 236.
Yes.
Next question that arises in the case on hand is as to whether this statement of PW1 recorded during the course of inquiry under section 202 of the code can be proved under section 157 of the case to corroborate the
Only
absence
his
of
own
other
evidence.
witnesses.
Only the evidence of the
my
witness
lord.
himself can be corroborated by the previous statement. Right.
So therefore, Ravi Agrawal 1606 could not have been. And my lord, even there is nothing in Ravi Agrawal's case.
That
I will
will see.
place.
That will see.
My lord, kindly have volume 8. Oh, sorry.
Referring to Ravi Agarwal,
Ravi Agrawal.
PW
106. PW 106.
106. 205, page 205. That book. Yes.
A very short 1.5 page statement. I have been in cement business. My lord, got it? I have been in cement business since last 12 to 13 years. In 2009, also I was in cement business. The name of my firm that deals with the cement business is Ravi Agrawal and Assam Cement. Assam Cement was situated at Teejpur and other one in Guwahati. However, as the owner of both the firms, I usually used to conduct the business from Guwahati itself by managers and staff. One Imdad Ali was my customer. He used to purchase cement in large quantity. He used to buy cements from us sometime in large quantity. In and around first part of 2009, Imdad Ali came to my house with a bag containing large sum of money. And he told me that he was to hand over this money to a person who doesn't have an office in Guwahati. And that is why he had already requested that person to come to my shop and receive money from him. After about half an hour, one Shyamji came. But he is also a mysterious person like Tapan who converted money. This fellow was never, although this witness says, I know him. No effort was made to press him out. After half an hour, one Shyamji came, whom I know from earlier, and Imdad Ali took the bag from
Imdad Ali came and he gave money to Shamji and then both left the office.
both left the office.
Even in this statement, there is no reference to Jayant Kumar also.
No. And this evidence has been discussed in 107 of the judgment. 1931, page 56. Page 56. Okay, there is, my lord, I'm sorry if there is cross-examination of this witness that I should place. 106, what was it, page?
There is no cross-examination from him.
No, he.
2 lines, we suppose.
Cross by prosecution, he was declared. hostile.
Prosecution.
Yes. hostile.
All he says is in my statement to the NIA, I said that Shamji was a hundi operator.
Yeah.
But who is Shamji?
That's right. That's right. So this is,
That's what
10
when you are referring to cross-examination, it's not by the defense.
no, not very.
Defense gave up
By
the,
prosecution, because otherwise, my lord, I'll be accused that I have not placed your lordship. So I placed. Now, 107 of the judgment at page 56. 56.
what was the purpose of examining this witness?
My lord, the purpose was that I took help. Accused number 3 took help. With his help, which I sent lots
The
of money.
witness doesn't say anything about Mohit Ojha.
Everything, neither PW 35 nor 10. And 107, your lordship. will
I know,
find.
but what finding you are pointing out regarding this witness?
My lord, I just.
The trial court also doesn't say anything about, no
Absolutely,
conclusion about Mohit Ojha.
But my lord, the conclusion is that, yes, they have said, they have proved.
No. Read 107.
My lord, that conclusion is at 127, but these are the discussion.
127.
127.
Okay.
127 is at page 68, my lord.
No, before that you can read 109.
109, I'll come after placing 21.
Okay,
Because
very well.
it refers to 21 also.
Page 127 you want to read? refer.
Paragraph, my lord, paragraph 127. This is
Yes.
finding regarding accused number 3. The relevant your lordship will find at page 68.
Yes.
My lord, 8, Roman 8 at page 14, at page 68. He sent money to Calcutta meant for Jayanto Ghosh through witness in Dadali. He said nothing. Well, my lord, perverse finding.
Even going further, this is a finding qua which accused? Is there any
Accused number
heading?
3, accused number 3 at
Any heading?
yes,
for
page-
these findings?
Will kindly come to paragraph 63. I have given a chart also.
All right, if the findings qua accused number 3 start from para 63.
Para 63, page 44.
All right, okay.
44 of your lordship's judgment.
Yes.
63, and it ends, my lord, culminate into paragraph 127,
Hmm.
where, my lord, at page 67, the beginning of 127 paragraph is, they accuse has cross-examined the witnesses mentioned here and above, but nothing tangible could be elicited to discredit them. On dispassionate analysis of the above evidence, the facts and circumstances appearing against the accused can be recapitulated as under
Okay.
Mohit Ojha's in the other recent one. Now, my lord,
Keep taking note of the arguments from where Rajiv is discontinued. Yes, please.
now the
carry.
last witness on the point is
121.
no, only 21.
21.
At PW 21 at page 72, volume 1. Oh, sorry.
No, it's okay. Chandra
I'll
Sharma.
get it, my lord.
Chandra Sharma.
Yes, Chandra Sharma.
What is
My lord, I confess, my lord, I have not understood what he said, but I'll place it before you.
You can give him the benefit of doubt.
I am doing supply business, my lord, got it?
Yes.
I am doing supply business at Haflong, and I have a hardware shop at Tilpukri.
Please.
My father was working in handloom and textile at Haflong, and he had retired from service. We had been residing at Haflong for 10 to 12 years. I know Mohit Ojha, he is in politics. We have a family touch with him, with his family. He has got a daughter studying at Guwahati, and I'm close to him. I have been looking after his daughter as a local guardian. On 1/4/2009, when Sonam Lama telephoned me regarding taking my vehicle on hire, he informed me that the vehicles would be used locally and may have to go outside the city. Accordingly, I gave my phone number to Mr. Lama to my driver, Dipankar Deka. He took Tata Sumo out for hire at around 1 or 2 p.m. My driver telephoned me and told me that he is taking the vehicle towards Shillong. I instructed him to come back soon. In the next morning, my driver's wife came to me and told me the vehicle was seized and I was lying at Basista police station. Thereafter, I went after doing formalities and took the vehicle on remand. This is the vehicle from where there it was intercepted and accused number 2 was occupying this vehicle. Now, my lord, the main part is last paragraph of this page. In 2009, Mohit Hojai telephoned me and told me to go to 80 Road. Accordingly, I went to 80 Road. Exact location I have forgotten. I met in Dadali. At that time, a person came, he met in Dadali and talked to him. And thereafter, we both left. Again in the year, and same year in 2009, Mohit Hojai telephoned me and told me to meet Jayanto Ghosh. Jayanto Ghosh sent a man with a packet to me, and then I took the packet and gave it to Jayanto Ghosh. So Jayanto Ghosh sent the man with a packet. That man delivered it to this witness and he gave it back to
It may be a little hyper technical, but the prosecution will have to answer who Jayanto Ghosh. Jayanto Ghosh was facing trial.
Yes.
If at all you want to pinpoint that it is the same Jayanto Ghosh, there is a procedure called identification in the court. Which Jayanto Ghosh? There may be n number of Jayanto Ghosh, and they are bound to be in this state. Yes.
Then, my lord, at least this witness says that I'm in politics. Now, so these are the 3 witnesses on the basis of which
Para
paragraph
127 findings have been given.
109, there is finding.
127.
109, my lord,
Para.
of the judgment, page 57. Page 57.
109. Let's see 109. No, the conclusions are at.
Page
Okay.
50
Yes.
57, 109.
Yes.
A co-joint reading of the evidence of PW 35, 21 and 106 and exhibit 97 is being read as substantive evidence. My lord. This is the confessional statement. Would show that the accused Mohit Hojai has link and transaction money with the accused Jayanto Ghosh. Mohit Hojai used to send money meant for Jayanto Ghosh at Calcutta, sometimes through PW 21, sometimes through Hundi operator. This is what, my lord, I have not been able to reconcile from where this has come. PW 21 doesn't say anything. He says Jayanto Ghosh sends a
Just for a moment.
my lord.
Assuming that these are the conclusions.
Yes.
What offense would they lead to?
No offense. They are trying to create a situation that somehow I have sent money to Calcutta.
Calcutta. So
And then rest is assumed.
So supposing it was a transaction, the Benami transaction, a Hundi transaction
Yes.
of money to Calcutta,
Yes.
where does that lead to?
Now, further, they have alleged that this money, which accused number 3 allegedly sent to Calcutta,
Was
was received by Jayanto Ghosh, accused number 12,
12. Yes.
13 and 14. 3, they are Jayanto Ghosh associates, these 2, 13 and 14. They received the money in Calcutta and they handed over to accused number 1. Accused number 1 was staying in hotels, Shalimar and Madhumilan guest house, from where accused number 9 collected this money and gave it to accused number 10 to get it converted into US dollars.
US dollars.
And then he gave it back to accused number 9. Accused number 9 then gave it to accused number 8. He procured the arm and supplied.
All right. Okay.
So it's a my lord.
So far as accused number 3 is concerned, your argument, which you have so far formulated, is that these 3 witnesses, the statements, even if considered as such, on the face of the record, do not establish that any kind of monetary transactions were done on behalf of Mohit Hojai. That's all right. Okay.
Now the fourth part of the fourth act, which allegedly done by these accused, is that money sent to Calcutta was handed over to accused number 12, 13 and 14. There is not even an iota of evidence.
Jayanto Ghosh.
Jayanto Ghosh, Bhattacharjee, Devashish Bhattacharjee and Sandeep Ghosh.
Right.
A14 is Sandeep Ghosh. 12, 13 and 14. There is not even slight evidence to show, because when the money has not gone to Calcutta according to their own witnesses, where is the question of handing over money, receiving money by accused number 12, 13 and 14? There is
Sir,
absolute.
if at all money went as per Imdad Ali, it was his own independent transaction with Jayant Ghosh. That was in 2008.
That was in 15 like 2008. When, my lord, in January 2008, he says, January 2000, Mohit, Deepalal Hojai was the CM. He has taken over.
Anyhow, what is the finding regarding Jayant Ghosh, Debashish and
Yes.
Sandeep Ghosh?
Your lordship
Can
may
you read
kindly,
that?
may kindly come to internal page 236.
Six. Yes, please.
Two triple one.
Mm.
279 starts at page 236, my lord.
379.
379. From evidence discussed above, roles so played by three accused persons are recapitulated. Now, my lord will see the 5.
Para 3. Subpara 3.
Para 3, I can read.
Checks in favor of the firm.
Well, this is this is defalcation. The allegation is that these contractors, 12, 13,
The
and
funds were
14,
siphoned off in this manner.
they met in Pragati Manor Hotel. They were there and they called the engineer and threatened
So
them.
there
to
was,
pay
there
that
is
one.
no pertinent charge related to this transaction.
That not in this case.
Not in this case.
Defalcation has gone to the different CBI.
What is the fate of that trial? Just for our curiosity.
My lord, that there, I'm told there is conviction, about 2 years, 3 years. And it is pending, appeal is pending.
Appeal is pending. In which one? Okay, okay, very well. All right, yes, please. Carry
So
on.
the relevant my lord, sub-paragraph will be 6.
6, yes.
He had nexus with Imdad Ali, who carried money of accused Mohit Hojai on several occasions to Calcutta. And this is perverse, my lord, with respect. This is perverse. And then the 7th talks about check, some check he carried, that is not relevant at all. So,
okay.
and then of course, my lord, all others are relating to defalcation. Defalcation. Now, my lord, so I was saying, my lord, there is no evidence. Number
Regarding Mohit Hojai having ever transferred money to
Calcutta.
Jayant Ghosh.
Therefore, question of Jayant Ghosh receiving the stage money doesn't arise.
Okay.
And then thereafter, the next 5th act which is attributed is that A12, A13 and N14, having received the amount, given it to A1. Now, when the money has not gone from Guwahati, you not proved. Where is the question of, and not received by Jayant Ghosh and his associates, where is the question of their handing over money to accused number 1?
All right. Yes.
And my lord, as I said, there is a concluding finding which has been written in the judgment. Fajinder Hojai's concluding finding is at paragraph 61, page 42 of your lordship's judgment. 61. Page 1917.
Page 42.
Page 42.
Right.
61.
Page 61.
Paragraph, page 42, paragraph 61, my lord. Thus, the role played by accused Fajinder Hojai become apparent from the evidence of the aforementioned witnesses discussed here in above. We find no ground to disbelieve
So
their
the
version.
carrying of cash, of course, that is not disputed. That is a seizure which was made.
No, that is Guwahati. That is from, that was seized in Guwahati.
Shillong.
Shillong.
Right.
And there also, my lord, when I placed my lord case of accused number 1,
No, you are referring to that only now.
I'm referring for the purpose that if,
In relation to this trail of money,
yes,
right?
because if the money has been handed over by
Mhm.
accused number 12, 13, and 14 to accused number 1,
Hmm.
it must find place here,
Yeah, okay, yes.
only for that. Now, your lordship will see there are 5 findings,
Hmm.
not a single one says, my lord, that he has received money from 12, 13, and 14, although 3 says, your lordship will see 3. He has given money on 3.
Two, will you read please two? One letter of Mohit Ojai written to
Yes.
SCPWD so and so
Yes.
to award contract of rupees 88.
Yes, my lord, in this connection, I have seen this was put to Mohit Ojai. Mohit Ojai said, I am a politician. Whoever comes, I write. It is for the
Recommendation.
officer to go through the caudal formalities. Can he award contract on my letter? But I am a politician.
Mhm.
And my lord, this is true. I have seen in Nagaland, Chief Minister's letter was once found by CBI, my lord.
In transfers, there are recommendations by politicians.
Yes.
That's true.
So that is the answer he has given. That look, I don't know what was recovered, but if anybody comes to me, I know I recommend. But I don't say that you don't follow caudal formality.
Mhm.
That has to be followed. So this takes nowhere.
Mhm.
Therefore, my lord, I was referring to 3.
3.
He has given money on 3 occasions to Malsa Kimi account amounting to 4 crores. On 1 crore, 1 crore, and another 2 crores, and then another occasion, 1 crore. And this also I will show that there is no evidence at all, because he did never received any money.
Yes.
So even this, my lord.
Number 5. He received phone call from accused Mohit Ojai Niranjan
That-
while he was in custody.
That's very interesting part. It is alleged that after arrest,
After he had been arrested in connection with the seizure.
yes, he was being brought to Basista police station. On way he received. Now PW10 says, who is the police officer who seized, that I seized his mobile on the spot.
On the spot.
Seized already, money already seized, pistol already seized, whatever was recovered. But they say that he recovered. Now,
He
the
got a call.
CDR has not been admitted.
Not been proved. Rather.
Not been admitted because
The trial court did not
65
find it
certificate was not there.
Yes.
So it was not admitted.
Right.
And then, my lord, though CDR was not admitted, they had another way of proving it. What they did, they say that the call that accused number 1 received from Mohit Ojai and Niranjan Ojai
were overheard.
No.
Then
got recorded, automatically recorded in Sony Ericsson, his telephone.
in his instrument.
In his instrument, automatically recorded.
Mhm.
And the record was transferred to CD.
No.
And it was played in the court.
But whether the
So-
transfer procedure was proved anywhere?
No, 65B was not there.
Okay.
And what surprises me is the learned trial judge says that 65B's certification is not necessary because primary evidence was there.
CD.
No,
Or the mobile instrument.
But the question is whether it was played through mobile.
Mobile, if mobile was
Played, then 65B
then
would not have
65B would not have been necessary. But it is once it is a reproduction,
Yes.
65B is necessary.
Yes.
Yes. Okay.
That I'll be referring to a direct decision of the Supreme Court at the point.
There's primary evidence and secondary evidence.
Yes.
Yes.
There also, my lord, the fact was that there was a political gathering. Some statements were made and from the CD was played, but that CD was not seized. Or they seized the CD, but recording was through another instrument. And they had not produced 65.
That instrument was not produced.
Yes. So no.
Okay.
That is the decision. So, my lord, your lordship will see there is no conclusion, either in the evidence of A1 or in the evidence of in the conclusion of A12, 13, and 14, that A1 has received money from 12, 13, and 14. It cannot be because the money has not moved from Guwahati. There is no proof. Now, the sixth act attributed is that accused number 9, Malsa Kimi, collected the money from accused number 1. Now, I'll place it like this. The money was not sent from Guwahati. No question of receiving it by accused number 12 and his associates. No question of giving the money to Mr. A1. And therefore, there would be no question that Malsa Khimri could collect. And that to 4 crores on different occasions.
4 crores, 1 crore, 2
Yes,
crore.
2 crores, yes. Now, in order to create evidence, PW accused number 10 was won over.
Was made a approver, right?
Now, my lord will kindly see the judgment. Just a minute. The initial. My lord, the judgment at page 5, if my lord will kindly see, just to show that charges were framed against this person.
Page number 5.
5.
Yes.
Accused number 10, George Lamthang. My lord got it. So the charges were framed under 120B, 121, 121A, 16, 17, 18, and 20. So he was facing charges. And the charge was framed, my lord, on 4/8/2012. And he pleaded not guilty. Then on 6/11/2013, he was granted pardon. And he became an approver. That lower court record is not there. We tried to find out how the pardon was granted.
You don't have those proceedings with you?
No, that is not there. That lower court record is also not set.
LCR is not here? Section, it is there in the section. You can ask your associate. But you could have procured certified copies, sir.
My lord, I said, but then 6 trunk and then there were so many, I don't know. I had said-
Because this matter you have been arguing over a period of 2 years, we can see, 2-3 years.
Yes, yes,
So this is a very important
Yes,
link
that's
in the
right.
case.
That's right, my lord. And I was trying to get it. Now, only thing, my lord, I can get it, the fact from where it is mentioned that he was.
There must be in a judgment.
Pardon,
must-
yes, my lord. At page 151. But this, of course, if the relevant file
The
is.
record, you can send any of your associate to us, inspect the record,
My lord,
get a copy
my lord,
immediately,
my lord.
instruct them. Anyone goes and flags the documents, makes an application for certified copy, immediately get them. We'll need it for adjudication. Yes.
Page
Sir.
151 of the judgment, my lord. Paragraph 227. The evidence PW 29, George Lamthang. You know, to me, right, he was accused number 10.
So he had given a confessional statement
Yes,
even during investigation.
during investigation.
But then he was, at that time, he was not granted pardon.
No, because it's exculpatory, my lord. I will take the
Okay.
relevant portion. It is to be mentioned here that this witness was an accused here in this case. During investigation, he made confessional statement before the judicial magistrate under section 164. During the trial, he turned approver and the court granted him pardon on 6/11/2013.
Examined as a witness,
Yes.
thereafter enlarged him on bail,
Yes.
right?
PW 29, he was examined as PW 29. Now,
So,
I'll start with Pelot, his confessional statement. Because I'll have to see the record, whether he could have at all been
Granted
given
pardon.
Gotten, Millard,
but that
pardon.
part is not under challenge. The grant of pardon,
No, that of course is not under challenge. Your lordship has seen how the case has been conducted, see the cross-examination and other part.
Okay.
My lord will kindly have exhibit paper book 2,
exhibit paperwork part,
part 2,
yes.
page 502.
902.
502. My lord, exhibit, that is
We are having exhibits, part 2, volume 5, volume 2,
volume 2, my lord.
volume 2,
Volume-
sure.
Yes, my lord. Volume 2, 502. The relevant is at 510.
Yes.
My lord, the confessional statement starts at 502. Your lordship will come to relevant portion at 510, the last page. And the last paragraph.
Roman Barua.
After arrest,
Yes.
after arrest, police in interrogating me regarding arms transactions, but I have no relation with arms transactions with anybody. I admit that I converted the money to US dollar. I have seen Vantia in police custody at Guwahati. I do not know where the money comes from and where it goes. I only do the
Business for commission.
business for commission.
Okay, okay.
He has not admitted anything. And similar statement, rather he has gone one step further in as PW 29. He says, I'm not a colleague of the accused, other accused. Then your lordship will kindly take his statement now, which was 29. Which was, your lordship will find at volume 1.
Yes.
Oh, sorry.
The events which preceded the recording of this statement, they would be very relevant.
My lord.
The order sheet and all. This is after framing of charge.
After framing of charge. That's why I think we should took your lordship through the
The
judgment.
proceedings would be very relevant.
Madam.
Yes.
PW 29. The condition of
The
306 is
issue
not fulfilled.
which crops up is the case was under trial of a special judge.
My lord.
Then who was competent to grant pardon? Who has granted pardon? That there is nothing on the record.
Nothing on record, my lord. That is why I have been telling, I also told my lord in my initial argument when I made that I'm not getting that
It's very
record.
relevant, very relevant.
Relevant.
The record must be very bulky. You send some of your
I'll send
associates.
my lord tomorrow.
Today only you go to the record section.
Yeah, he'll go today itself.
There must be a formal application kind of thing permitted in the rules for inspection. Go with a pencil
We'll do it
and paper.
and we'll give that application to court master. He will.
Go give it to the registrar judicial. We'll ensure that
My lord.
he gets to see the record. First they'll have to inspect which document they want. They don't know. It'll take some time. Let him do it today. Yes, because even for us to search that record, it will be a very tedious process. Okay, yes, please.
My lord, your lordship will go to internal page 3. Internal page 3
Of
PW 29.
PW 29.
George Lamthang, the approval. My lord, 4th paragraph from the top at page 150. Sorry, 3, my lord. My lord, got it.
Yes.
I admit that I converted rupees to dollar, but I am not a colleague of any of the co-accused. I was only a commission agent working only to get a little commission to be able to maintain my family. This, he could not have been an accomplice. Now my lord, the leading cases till date is, my lord, Pakla Narayan.
Pakla Narayan.
Pakla Narayan. And then, my lord, there is a case of Ravinder Singh versus State of Haryana. That is 1975, 3 SCC, page 742. 742. That the first requirement is that an accomplice being a guilty associate or partner in crime must implicate himself.
Implicate himself.
Must implicate.
Exculpatory statement is not acceptable
My lord,
coming from the mouth of a accomplice.
accomplice, my lord.
Yes.
Now, if your lordship will see the judgment compilation at page 113, just one paragraph, I'll refer. My lord got it at page 118, relevant, paragraph 12. An approver is most unworthy friend. If at all, and he, having bargained for his immunity, must prove his worthiness for credibility in the court. This test is fulfilled, firstly, if the story relates involves him.
That's
the
a
crime.
fundamental reason,
My lord,
fundamental
fundamental
requirement.
principle, my lord, and appears intrinsically to be a natural and probable catalogue of events that had taken place. The story, if given of minute details according with the reality, is likely to save it from being rejected. Brevi manu. Secondly, once the hurdle is crossed, the story given by an approver, so far as the accused is on trial concerned, must
Implicate him in
must
such a manner so as to give
My lord.
rise to a conclusion of guilt beyond reasonable doubt.
So that is not there. Once he says, I'm not a colleague.
Maybe if you expand the argument, the admission should have been to the extent that he knew that this was money intended to be used for waging war against the
That also
country.
He doesn't know. He says, I don't know.
I don't know.
If the money comes from where it goes, I don't
He
know.
is only friend of Gandhiji. That's all. Commission. Yes.
Now, he is the person, my lord, who has said that the money was collected from A1 by accused number 9 in my company. So he accompanied her. That relevant portion I'll place you for.
Yes.
29.
This cross-examination. I do not know for what purpose the aforesaid US dollar will be used, by whom and for what purpose.
Yes, Lord. Now, my lord, first and foremost, I would like to, my lord, please, at page 15, internal page, my lord, 3.
Of this witness.
Yes.
Read, please.
The top 5 lines. Although I was accompanying Malsa Kimi to the said 2 hotels, I did not have any knowledge about Khojinder Hojai, from whom Malsa Kimi collected money on 3 occasions. Even Malsa Kimi did not have any knowledge about Khojinder Hojai. I learned from Malsa Kimi that she was collecting money on behalf of Banlal. I was simply accompanying Malsa Kimi when she said and that she had money to be converted and she had to collect the money from a person in a hotel. My lord, I pause for a second and submit. Both were collecting money, such large sum, to the extent of 4 crores from an unknown person. And in order to overcome that, what the prosecution did, when all were sitting in the police station together, they made one identify each other.
Okay. Where is that proceeding?
My lord, your lordship will kindly have exhibit 77 at exhibit paper book 3, page 512.
Identification.
Yes.
So this is basically identification of the hotels
Hotel is different.
and the person.
Person. 2 different exhibits are there. Identification of the hotel, my lord, will not be something, I don't know. These days they do.
It's pointing out of the place of occurrence, maybe kind of thing. They get it done in 27 of often.
Well, 27 is a
Verification.
common knowledge. That is not, there is a hotel called Salimar, will not be an exclusive knowledge of the maker of the statement.
Fact
Relevant
not known, fact already not known to
Yes,
the
yes.
investigating officer.
Has to be
Yes.
exclusive.
Page 77, pages
512, my lord.
512.
Exhibit 77. Now, here, my
Disclosure
lord,
statement.
accused number 1 was identified by George Lantham.
Just a minute. Identification memo, 18/8/2009.
18/8/2009. Yeah.
This identification is on
18, my lord.
18/8/2009.
2009.
So where did Fozendra Ozai, how did Fozendra Ozai land up in jail, in police station?
My lord, he must have been, he was called, I'm told. I asked him. He was called. Hmm?
He was called means what?
The police summoned him.
Where is that document? Where is that material?
That I'll have to check up, but I.
There has to
definitely
be
asked
because
he was on bail.
that is why this chart becomes
Yes.
relevant.
Because he
Immediately
was-
looked up.
I asked this question that
If
you were.
if at all there was any identification of Fozendra Ozai in the police station, then Fozendra Ozai was supposed to be there physically.
Yes.
And unless Fozendra Ozai was summoned
Yes.
by issuing a proper requisition,
Yes,
there was no question of
him being there.
him being there.
Yes.
Well,
That is-
we'll
that-
see.
On this, my lord, I-
Which is the police officer who proves this document?
my lord, there is one executive magistrate. He has been examined. And
This identification is by an
PW40.
executive magistrate
Yes, my lord.
in the police station.
Yes. Hit by 26, my lord.
Uh,
It will be hit by section 26 of the Evidence Act.
Fozendra Ozai is a signatory to this
Fojinder-
document.
Fojinder Hojai, my lord, is not. Fojinder Hojai is not. Huh? No, George Lanthang is there, then signature of. P.
Just let us see, read this document, please. Identification memo.
In the above mentioned case, accused George Lanthang,
Hmm.
so and so, was shown a person unknown. Fojinder Hojai, I don't know what, unknown of or something, Fojinder Hojai. The same person from whom he along with Malsa Kimi had collected money from Madhu
This
Milan Hotel.
executive magistrate was examined.
Yes. He was examined.
Is that statement available?
Yes, yes.
Let's see. So that's what we want to know.
Yes.
How did Fozendra Ozai
Yes.
come to the
Was-
prison? And if this is an identification memo, it's not a confession, then why signature of Fozendra Ozai is not there on this document?
No, no.
Let's see the statement of the magistrate, please. PW,
I'll just give a look. In fact, this part I. because
can do it tomorrow?
Yes, yeah, we can do it tomorrow. Huh?
Yes.
Time also.
In the meantime, that major
Yes,
thing you have to deal with is regarding the approver.
Yes, I will send my learned son.
And also you can focus on this identification part.
Yes,
Whether there is anything in the evidence of the IO that he summoned Fozendra Ozai for the purpose of identification.
Yes.
That has to be done. We can have it day after tomorrow because tomorrow we have a different bench of environment at 2. List hearing continues. List on 28th April for further hearing. Need not mention the time. We'll, as soon as the remaining part is concluded, we'll commence hearing on this. Yes. Why are you looking so troubled? No.
Lordship, if it can be in the second half, if I got something fixed in the.
He'll be arguing. You ask your colleagues to
Yes,
take note of the arguments.
They will be.
They'll be there, don't worry. We'll not put any difficult query in the meantime.